for postings.
There is a list.
Seeking for
Yes.
seeking for extension of interim order.
My lords, may I make a submission, my
short.
lords?
1 minute. Yes.
Seeking for extension of interim order.
When the interim orders expire?
Not
When the interim orders expire?
4/7.
4th?
4/7.
4/7.
4/7.
Oh, take it. Yes.
On matter for final hearing, RPFC matter, my lord. 2022.
Why there are other matters pending? Why your matter should be in priority? We'll see. Yes.
National Highway Authority of India have filed petitions, my lords, it has not been listed.
Seeking? Fresh matter?
Please.
Have you complied with the office objections? If the office objections were complied, if it, then post this matter tomorrow.
Lordship's kindly
Yes.
extension of the interim order on 25th of July. It expired by oversight. There was a hearing. I have seek for extension of the order. There's an inquiry going on as regarding disobedience of the order of temporary injunction in the matter.
So this respondent is served.
I have served them through email and I'm also filing an application. This is the memo for posting.
No, what is, from 25th July, there is no interim order.
Yes, by oversight. It was heard on 25th July comprehensively and a detailed order was passed. In the meanwhile, the evidence is being recorded before the registrar.
We'll see,
judicial.
post this matter day after tomorrow. Yes.
Obliged.
Yes, Ms. Senior Counsel.
Yes, my lords. My lords, I wanted to mention one matter which is at serial number 14. My lords, this is an appeal MFA filed by me. In fact, on the last date, on 30th, my lords had adjourned it to 12th. And in fact, the date was given as 12th. Now, my lords, respondent, in fact, I believe without informing us, have moved it. I have an arbitration today.
Maybe it is something like this. Without informing him, there were many.
No, my lords, we had in fact, my
Lord,
lords are very,
the respondent in this case, we were not informed on that.
No,
That's
my
what
lords.
it is.
So that's why we moved
We'll
matter.
See, if they have urgency, we'll see.
There is a.
Can it be
essence, my lord.
kept, my lords, today I have an arbitration. Can it be kept on 8th or 9th? This week we'll fix it. I mean, there is no difficulty for me to argue the matter, but let it be on a date that both of us are
7th.
7th, my lords. Very well.
Great.
7th will take up.
Grateful. Interim order to be extended. my lord.
At the request of learned counsel for the appellant, post this matter on 7th, interim order earlier granted is extended till then.
Grateful, my lords.
On
Grateful.
MFA matter, my lord, notice is already ordered. Now the respondent is prosecuting the matter before the execution court by making a sale certificate. Request for any date.
Which year is that?
24, my lord. Notice is already ordered, my lord.
Wednesday? Yes. Page wise mention.
Petitioner, my lord, first to time on me. Senior application,
Which case?
first one, admission.
You can ask the first matter, why in a mention? It is coming up for non-compliance of office objections, 2014 matter. We'll see what it is. Yes, next. Don't make a mention in the sold matters.
Your Honor, serial number 33. We are
And
for
for
the
the
respondents.
petitioners.
13.
Seeking an adjournment,
33.
Your Honor.
Hmm.
Your Honor, this council is busy with occupied with the rituals for the bereavement in the family. So we are requesting you to post it on day after tomorrow,
Maybe
Wednesday.
post it on Monday. We have so many matter posted on Wednesday, next Monday.
Post this matter on Monday at the request of learned counsel for the respondent.
Your Honor,
Yes.
the matter may be posted on Wednesday, Your Honor. Wednesday, day after tomorrow.
No, it's not always both your convenience. Court convenience also has to be considered. In the earlier matters, wherever these adjournments are done, if there is an interim order, whether they ask or not extended. Yes,
Serial number
Much over.
34, Lordship. Serial number 34, Lordship.
Hmm.
For the
For
petitioner,
respondent.
Lordship, we have informed others.
Last occasion also they took time. Kindly have this matter Thursday. Thursday.
Thursday. At the
Much
request of
obliged.
council
Interim order
respondent
to
or
extend.
petitioner, post this matter on Thursday.
Interim order.
My lordship, respondent, serial number 39, my lord.
Hmm.
Respondent, seek time for senior counsel engagement.
Have you informed the other side?
It's not coming.
He'll not come, his matter is 39, you have to ask him. Please, we will call, please make a mention when it comes, when it reaches. Yes. What happened to this? Have they informed? Hmm. Hmm. What did they say, registry?
It is that the pending people have instructed that.
Hmm.
That your matter is restricted.
They've done, where is the office not? Why they are not with the office now? No, if they have done, no, there should be an office note here that as per the order of the court they have done. Otherwise, why would we know? No, it is not about tomorrow. Why are they not doing it every time? Call the concern. It can't go on like this forever. Yes, next part.
I appear for the appellant in this case. I have completed the office objection as per the order of the Honorable Court on 1970. I have complied. And 3 more applications I have failed to bring the LRs of the deceased appellant. Pending.
Non-compliance of office objections raised on IA 1, 2, and 3.
I will verify well. Here, what are the objections I will verify. In the
Hmm.
remaining objections I have filed. I have complied all the objections. I have paid the court fee and also have
No,
taken.
no, there are two. One is about the court fee and other things.
I have complied.
Then what about the other one, non-compliance of office objections on IA 1, 2, and
1, 2,
3?
3, I have filed recently, last week. I
Hmm.
will verify.
For complying with the office objections, finally a week's time is granted. If the objections are not compliant, the appeal shall stand dismissed without reference to the court, further reference to the court. Yes,
Petitioner, applying for respondent in case, my lord. Yes, I do not have the papers, my lord. Copies have to be served on me, the petitioner. My lord, the matter is pertains to video conferencing application which was rejected by the family court. My lords, remembers the other day we applied for petitioners, my lords. The matter is listed tomorrow. If this matter can be taken up tomorrow, so that both matters can be disposed of. Though it is not connected, but
Similar
it
subsection.
is a similar. The case is similar.
post along with, what's the number?
I will give it, my lords.
Give it to the court
Yes.
officer along with so and so tomorrow.
I appear for the petitioner, my lord. I filed this petition for
See the mics are on.
directing
There.
the lower court to dispose of in 1 month. The petition below is the diverse petition filed by the petitioner, and it is 2019 matter and is
2019.
yes, your
Hmm.
my lord, and he has got anxiety attack and he was admitted in ICU also. So Annexure D shows the discharge summary wherein it shows that he is suffering from and he has nobody to help him, my lord. So
What is the MC filed by him?
for divorce, your honor, 31A and the also adultery. Now the matter is for like I have filed amendment application and that is for orders, my lord, down in the lower court. So I request for the speedy disposal, my lord.
No, you file amendment petition, no, and you want a speedy disposal of both of
It's
the.
all, it's for orders, my lord.
Huh?
It's for, already for
What-
orders.
What has to be done? After that, after the amendment is ordered.
Then additional objection and my evidence will be posted.
So with all this, how do you expect the court to dispose of the matter in 6 months? Sir?
At least time bound my billing, fixed my.
And don't file all those applications now, from now on.
That's all, my lord. I have cured all the defects,
The
whatever
present
was.
petition is filed, taking mandamus to the family court to dispose of the matter within 1 month. Within 1 month. It is submitted that the petitioner is not keeping well. And considering his health reasons, and also that the MCs of the year 2019, there may be a direction to the trial court, to the family court. This court, having heard the learned counsel of the petitioner, had perused the material on record, considering the fact that this is a MC of 2019, where this court is directing the trial courts to complete the 2019 matters by this year, at the end of this year. This court deems it appropriate to direct the trial court to dispose of this MC as expeditiously as possible, but later than December 2024. The next part, this court is not proposing to issue notice to the respondent as disposal of the case is in the interest of both the parties and no adverse orders are passed against her. Yes,
Much obliged.
yes.
The petitioner is a vice petition for enhancement of maintenance.
Notice, petition is permitted to take out notice on the council appearing for the trial court and shall file a memo to that effect by 14th of August. Post this matter on 28th of August. Yes,
Madam, your petitioner. Madam,
Yes.
this matter is with regard to that 2 hours visitation, madam.
huh. Who is who was
I have to
appearing?
serve a copy, madam, the first time it's coming up.
You served a copy.
No, I'll serve a copy, madam, because they are not filed away.
So in the connected matters, he is appearing, shall we?
I'll serve on him, madam.
It is submitted that in the other connected matters, who was the advocate?
Arun Govindraj.
In the connected matters, Mr. Arun Govindras is appearing for the respondent. Petition is permitted to serve a copy on the council. Print the name of Mr. Arun Govindraj. When do you want?
Madam, early, at the earliest, madam, whenever.
Thursday? Yes.
Respondent number 1, my lord. I was directed to
Only to on that aspect.
aspect, my lord, but I need time, my lord. The officials, I spoke to them, they said they have to visit this place along with this sketch and this one.
Where is that place? Is it somewhere outside Bangalore?
My lord, I couldn't get the order so that they can prepare a office note and everything, my lord.
Order is not uploaded till now?
It was uploaded on Saturday morning, my lord.
That, my lord, in support of that, mother, that photographs I want produced, mother.
No, even,
Please.
no, one thing, only why I want that clarification is, if at all within that, if your building is there, if you're residing, the court will pass an order as far as this is concerned.
And
Not for
that
the
is
entire
concerned,
thing.
mother, our side,
That's why let us.
they
Then
are,
also give them the photographs.
and
Get
moreover,
the-
mother, in the return statement filed by the BDA, they have admitted regarding my position of that 1 acre 15.5 guntas, mother.
It is not the possession.
That
It
your
is
lordship
this
can
house
see
only.
para
The
50.
case of the,
It is what? It is?
he is saying that we have admitted his possession
Hmm,
as regards to that sketch that has been prepared.
hmm.
It is not as regard, he claimed that yarnu bidale avaru without leaving anybody. He is just want to have that proportion and that though it is included in the acquisition, he says that it is in his possession. So when the officials visited, he said they have indicated that portion as it is in his custody. Now here the question is only where if his house is constructed within the acquired portion or not. That is the only
That,
question, my
When
lord.
can you get instructions?
2 weeks, my lord.
My instruction is.
Oh, it is a long time for getting
Right.
instructions.
The thing is,
Then what has to follow is will grant injunction for them.
The only thing is-
That my sum and substance of my submission is.
Please understand, I heard you at length
Please,
the other
please,
day.
please, ma'am,
Yes.
please, ma'am.
and
This
my
is
lord, one
posted only
submission,
for that purpose, no more arguments on that, yes.
only one submission is nowhere in the petition, as he stated that his house is within the acquired portion and that he has been living there, my lord. That is the only difficulty. Now here, my lord, The land acquisition section and the engineering section, they are two apart, distinct branch, my lord.
When there is an urgency, I
Well-
don't think it will take, it has to take 2
That's why,
weeks
my
or
lord,
3 weeks, like how the government functions.
My lord, there is a difficulty.
May I
2
make,
weeks, my lord.
may I make one submission, mother?
Yes.
My lord,
Some
the
and
thing-
substance of my submission that, that already suit is
Understood
pending.
that you are in suitable property, let us find from them. Yes, we'll have it on
May I make a submission?
19th, my lord.
13th of August.
My lord, 19th, my
It's
lord.
hardly about 12 kilometers, 13 kilometers, number one. Number two is, now my client.
No, anyway, they are not concerned,
Oh.
their duty is over, now you have taken it, so
My-
they
my-
require 2 weeks, 4 weeks, doesn't matter.
No, let it not, because there are,
But it will not be put
No.
on my, on my
there-
part.
And it was, if you are not if you are not purchased it, they would have got the instructions by today itself.
by.
That is
my-
not so.
My instruction
It
is,
is
my
only-
client's satellite picture is a vacant land, number one. Number two is, so far as this person is concerned, there are local rates. And now if my lad allows them leniently for 1 or 2 weeks, what will happen is, in a overnight, they take law into their hands and either sheds or some temporary sheds they'll put up.
Let's see the photographs.
that's
what is
my
showing.
approach.
That your lordship,
Please pass
That's
on
my,
the photograph.
that's all together.
photographs your lordship may kindly.
Now,
That first photographs is mal that. That shed is there mal that. It is in the remaining portion of the land of the appellant mal that. And all the family members mal that they have in the shed mal that, they are working in that garden, that agriculture land mal that.
When land acquisition proceedings, you have to take physical possession of the property.
my lord, physical
It is
position is also taken.
Taken, man.
And your
They-
lordship may kindly.
For his
No,
past,
you-
Just minute.
No, we have seen, already we have seen the photographs. No question of he creating
Creating.
something now or laying something won't arise.
Correct.
Have it next week, not 2 weeks.
Because,
my lord, 19th, may I tell you, there is
Huh?
19th. 19th month.
19th again, 2 weeks, what my learned friend is
That's
asking
what
again.
you are asking, you are getting it.
But there are
19th
four-
is a holiday, I think. 19th
This
is a holiday.
Varamahalakshmi
that.
Puja and other thing is 15, 16, 17, the holiday.
21st.
Then the,
I think it's
19th is
holiday.
holiday.
the
Let's not have, let's
authorities will come and
be like
say,
that.
they have the
Post this matter on August 14th. This court on the last occasion has directed the council appearing for the BBMP,
No,
BDA, BDA.
PDA mal.
a council appearing for the BDA to get instructions. The land council's instruction with regard to whether the house of the petitioner is situated within the
Acquired portion.
Acquired,
acquired area. He required some more time. Finally, post this matter on 14th of August. By that time, if the instructions are not placed on record, the court court will pass appropriate orders. Yes,
Me, I'm not 19th, may cannot, it is very difficult to.
your officers have to get when there is a court order.
Right.
Yes, next.
That till then mal that interim order may kindly go. Till then mal that interim order.
That granted,
Please mal.
yes.
Those properties are nothing to do with,
Huh?
those properties are nothing to do with the present
That's why. that's
issue.
why.
Even otherwise, on the other day, this court can appoint any respectable member, they can visit and they can also
Yeah,
place
the end-
information.
In the ends of interest mal that may I make one submission mal that. Already suit is pending mal that. All the parties in the suit mal that. The question is that mal that whether the BDA acquired 5 acre 27 guntas or the appellant has entitled 1 acre 15.5 gunta. It is to be decided on merits mal that before the trial mal that. Admittedly, prima.
It's
Now,
totally confusing it.
unfortunately, the court has heard all of you
Please,
at length
please,
on the
madam.
other day.
So,
Again, on the 19th, it has to begin. You have to come back with what you have argued.
No, man.
so that 6-month time bond may fix.
No, no.
See,
Please,
we'll see,
please,
we'll see.
please, madam.
But if you want 6 months time frame without injunction, we'll grant.
Or otherwise it is very inconvenient to that.
That's why this
Please,
has to
ma'am,
be
please,
covered.
ma'am,
Yes,
please.
next,
Waited for 20 years.
yes.
My lord, I appear for the petitions council. Here is a case, my lord, there was a compromise between the husband and the petitioner hearing. At the time of compromise, my lord, 14 lakh was paid as a permanent alimony. Out of this 14 lakh, my lord, 3 lakh, my lord, was agreed to be deposited in the name of the child.
Hmm.
Now thereafter, my lord, one more case has been filed wherein, my lord, the interim order has been passed wherein to pay 10,000 rupees per month. Now there is an interim order by the Honorable Court, my lord, to pay 5,000 per month. I have been paying that amount. It appears, my lord, on the last occasion, lordship asked my whether it is possible to give some more amount. But I'm ready to, I have,
With regards some health ailments.
No,
you-
my lords, these
my
are-
lord, another 3 lakh, my lord, I'm ready to deposit in the name of the child. If my learned friend is.
Sir, that is too low an amount. At the initial stage, my lord, because of his health condition, they were expecting that there will not be any much expense regarding him. But miraculously, by efforts of the hospital, he is going to a regular school itself. He is slow in speaking, but he is now he is in 6th standard. He is going to the normal school and having a very good academic prospects also. And his expenses will be more than that. It is at that initial stage, it was expected that he will not be able to go to the school and all. But that is not the situation now. It is changed. And every month, every year, I am spending 80,000 rupees for the school fees itself. 3 lakh rupees is very less, my lord. He will not be able to finish another 3 years. That's all. Up to 18 years, my lord, he has to.
How old is he now?
Now he is in 6th standard.
6th standard.
6th standard.
It's a main problem. The thing
What
is,
is the
my lord,
income of the
she's
father?
the
He's
mother is also married, second marriage.
Second
I have
marriage.
also married
He is also
and I
married.
have got 2 children.
He has 2
In
children.
addition to that, my lord, the aged parents are there. The responsibility of looking after the aged parents as well as the next.
What is the respondent doing?
He's an
Now
engineer, he's
she's
an
not-
engineer, man. In
He
the
is a
respondent is a school teacher.
biotechnology graduate, but she is not able to go. She has went for 2 years, but now she is
I'm told, my lord,
not going to the.
she's a teacher.
No, presently she is not. We will file affidavit to that effect. Anyway, as per this case, we have to
I know,
file.
but the responsibility of maintaining that kid is on you because that settlement was not done at that point of time with regard to the child.
Therefore, my lord, another 3 lakh, I'm ready
That's
to
too.
pay.
That 3 lakhs you deposited on.
I have already deposited. In addition to that, another 3 lakh or 5 lakhs, my lord, I will ask my client to deposit.
But 5 lakhs will not pay.
What is then it would be appropriate? You should come over, should say something.
At least 40
Instead of
lakh.
deny.
It is a problem for me also, my
40
lord.
lakh rupees. He has to go to engineering
And,
college. We
the-
don't know which prospect he is having.
the-
Now it is
the-
6th
Court has to
standard.
look at it on the merits of it. Even on the
Yes.
merits of it also.
Yes, madam.
Now, he is already married. Now he has the children out of the second marriage.
2
He has to
children are
take
there.
care of them, the family.
Madam,
Then
he's
it has to be proportionately.
Please.
If that proportionate it is done, I don't think you will get that much of amount.
Please, ma'am, for one
What is
time,
your salary?
Salary, my lord, maybe around 70,000 rupees per month. Government.
let him pay half the expenses.
Madam, what about
until
my
the
family,
age of
my-
18. That's the only thing which I can,
How can he pay?
half expenses for education, madam.
That is your yearly, your, first say your month to 80,000.
No, per
Per
year,
annum
per
80,000.
annum. madam.
So how much it comes per month?
80,000.
Around,
Around 8,000,
around 15,000,
15.
not 15.
No, 80,000 means,
Not on 7.
I think around 8,000 rupees. ma'am.
6,600 it comes,
6,000?
600.
Hmm.
If the deposit, if this amount along with the 3 lakh is deposited, he will get that interest.
No one will.
But that deposit interest is only
Which
1,006,
is what now? What is his age now?
10 years,
10 years.
10 years.
So he requires for another 8 years.
Please, madam.
He's coming around 6,33,000.
Madam, But expenses will be increased as if he gets a better this thing. madam.
Is considered.
What I am saying
It
is,
will not be your 40,000 as you're coming out.
whatever expenses, half of that let him bear. That's all I am asking.
My lord, she was paid 11 lakh. I don't know what she has done at the time of government alimony.
No, for
is
the child,
also-
it is only 3 lakh rupees. It is there in the.
Total 14 lakh was paid. Out of the 14 lakh, my lord, 3 lakh was ordered to be deposited in the name of the child. I don't know.
So when both of you are going to get married, there should have been a full and final settlement. instead of all this.
Yes, my lord, that's,
She agreed for, she volunteered, let the 3 lakhs be deposited, therefore I agreed.
No, but in that, there is a clause that they can always pursue the maintenance as far as the child is concerned.
That is true, my lord. Therefore, I'm saying, my lord, another 5 lakhs I will deposit, 5 plus 8 lakhs would be there. 5 plus 3.
well, 5 lakhs will be too less. Maybe if his prospects, if he goes to any big school after second P or at that time, then expenses will be high. At this stage, it is only that much, but it will certainly going to increase. Apart from medical expenses, every day he has to, every 4 days, he has to appear before All India Institute of Speech and Hearing for therapy. I am taking him by auto and coming back. All those expenses are there. Every year, 35,000-40,000 rupees is the medical expenses.
What was your, settlement?
It was in 17.
17.
He was 4 years old at
18,
Till
2018.
2021, you did not move anything.
No, this was,
When was this petition filed, MC? Not MC, criminal miscellaneous?
MC 2017.
2000?
no, settlement has taken place in 2018.
Hmm.
2/11/2018 is the settlement.
Hmm.
MC was filed on in the year 2020, 7 January 2020.
21,
No, 2020,
not 20. Correct.
7th January.
Considering the fact that he's already married, now paying it monthly, those kind of things will not arise. And you have to come out with some figure which is reasonable, not 40,000. How can you expect him to pay 40,000, 40
40
lakhs
lakhs.
for his 70,000 salary and to maintain so many people? The two children,
2 children, my lord. Female.
parents, a wife,
Daughters.
and 70,000 with 70,000 salary, how would he pay?
Well, let him file.
Even he may not be able to do it even for the kids after the second marriage also. Please come up with a reasonable figure and communicate it to them. We'll pass orders on Thursday. Post this matter on Thursday. Both the council shall get instructions with regard to the council for the respondent shall indicate the amount which the indicate the amount of maintenance to the council for the petitioner. Post this matter on Thursday. And then council for the petition also shall get instructions in that regard. Yes.
Waiting for respondent.
This episodes, how many episodes are over till now?
The last date of hearing, this honorable court has directed whether this writ petition is maintainable or not. The matter was not reached in the afternoon, again posted.
What is against, yes.
My lord, there are 2 applications, my lord.
You wanted to know, no, you wanted to place some judgment that it is
Yes, yes.
maintainable. Please pass on. In a criminal miscellaneous, you filed a review.
I am challenging 2 orders, my lord. Order passed on IA number 2, calling upon me to pay it 17,000. In the meantime,
When is it passed? When is it passed?
the order, my lord, was passed on next year, my lord. On 11 January 2023. That order, I initially, my lord, that order was passed. I did not file my objections, objections and also assets and liability affidavit. Subsequently, my lord, I filed my objections as well as assets and liability application. And also
What is after deciding the application?
after deciding,
Application
after the
decided.
application decided. Then
And
also,
as far as the second is concerned, that is not maintainable, will not consider that.
beg your,
As far as this other one is concerned, seeking review of the order is concerned, it is not maintainable, will not consider that. Now, what is to be considered is this. To consider this, you have not filed anything before the trial court.
my lord, subsequently I filed my objections.
No, when that order is said, this court is not considering, and there was no occasion for the court to consider your case because you have not filed anything.
My lord, even my lord, para number 9 and 11 of the order, the trial court, family court comes to the conclusion that though the petitioner has not produced any document, however, granted this may.
Why I have not produced,
sec.
I filed my
You
counter.
can respond once he completes. Yes.
So they have not produced any document, my lord, to show that even the trial court, my lord, the family.
What he should produce according to you?
They claim that, my lord, I'm a managing director of a company. They claim that, my lord,
Why, who stopped you from placing all that?
my lord, at that point of time, not been represented. my-
About your financial status, you are the right person to
Yes,
place
ma'am.
all that, or she should do it?
I have not been.
That was the old story,
Yes.
when there was no assets and liabilities,
Yes.
that, the burden lies on the wife. No, that's not the case now.
Yes, my lord. That point of time, I was not been represented properly, my lord, before the court. I produced the order sheet. Subsequently, I produced all the documents, my lord, before the court to say that what is my income, whether I'm a managing director of a company, whether I have any, I'm a consultant in
What
Polytechnic
is your
college.
income now?
My income, my lord, as per my assets and liability, at 10,000 rupees. 10,000 rupees,
How much the court has granted?
17,000. I'm a AC mechanic, my lord. I do the servicing of AC and the refrigerators. So therefore, my lord, I filed all the documents before the court. And thereafter, my lord, also filed an application 127, my lord. Please consider, because this is the present scenario, please consider. I'm not saying that I don't want to pay maintenance, my lord, but so far as the child is concerned, 5,000, my lord, undertook before this honorable court also, I'm ready to pay that 5,000 rupees. But so far as the petitioner is concerned, my lord, she is a BE graduate. She's having a sufficient income and she's having her own house. I'm staying in a rented house. So therefore, my lord, requested the court, my lord, based on these circumstances, because I was.
Whenever the advocate changes again, court has to do the the re-exercise.
No, I'm not saying that. I'm not putting blame on
That
anybody,
is,
my
no,
lord.
it's not about the blame.
Only thing, my lord.
This is not how it works out. The court has so many other works to do than again hearing your case after giving an opportunity to you and again saying on some other ground you're hearing the same. Then when will the court decide about other cases? This is what is happening in every RPFC, in every matter of maintenance. What you're supposed to do, you don't do before the court. Again, court has to remand. Why this? Who will answer to this? The judicial time that is spent on this.
My lord, at that point of time, my lord, this honorable court asked me to file an affidavit, my lord, filed. And also, my lord, I undertook that whatever the time spent, my lord, I'm ready to pay 8,000, 5,000 to the child and 3,000 to the respondent, my lord, till this, my application is decided. So then my learned friend, my lord, said that he is not agreeable to that. Therefore, my lord, I also bought the demand draft, my lord, to the first installment.
First installment?
As per the affidavit, my lord, I agreed to pay amount, my lord, on installments. So far as that concerned, first demand draft also, my lord.
8,000 from the date of petition till now, how much it comes?
It comes, my lord, almost 2 lakh rupees it comes, my lord. Of which, my lord, 50,000 I have deposited. I have filed my affidavit.
I filed my counter affidavit, my lord. Because I'm depending upon the money from the petitioner only. I cannot ask for my parents for everything. I filed my counter affidavit.
No, till now he has not paid you anything.
No, nothing has paid.
That's what, please understand.
He is
Yes.
evading from this. I have every documents produced here also that it shows he is having enough income to give
That the court will
maintenance.
take care.
Yes, my lord.
How much?
My lord, total amount comes, my lord, 2,07,742.
Where is that IA?
Affidavit, my lord, para 8, my lord. Para 8 of my affidavit. Date,
We'll allow this, we'll do it on costs. Apart from what you're going to pay to the wife. Because now, why should we waste time? We have already wasted time here so many times. And court has already wasted its time for you. So it won't come free. It will come on some cost. If it's ready to your client, then we will do it.
some nominal cost, my lord, I'm finding it extremely difficult, my lord.
No, my lordship, he is having so much of income. I have.
I understand your
He is suffering
submission.
from starvation.
Yes,
lord,
where is that, your affidavit?
I filed counter affidavit, my lord.
That I'll see. Yes. No, till now, you have not received any, even a single pie from 2023.
No,
50,000.
after this honorable court has ordered, before giving the stay order, ordered for 50,000. Only that 50,000 he has paid.
That's what. So the total amount payable is 2,07,742. Amount paid is 50,000.
That calculation itself is also wrong, my lord.
Well,
In their affidavit also, paragraph number 7, my lord, they have mentioned
Please tell the
22
court about the calculation.
Pardon?
What is wrong with the calculation?
Wrong with the calculation is it will come 2,08,000. Instead of that, something changed, 7,00,000, 7.
So let us take it 2,08,000.
300 rupees. 50.
Then in that 50,000 is already paid.
Not
Then,
2,08,000,
uh,
80,000.
huh?
2,08,000. 50 he has paid.
Yes. Hmm,
1,58,000 is balance, my lord.
yes. Where is the check for DD for how much?
My lord, I am giving a
I
demand.
don't want any, this one, cut and cut, my lord, because I cannot manage also myself.
That I'll consider, that I'll.
Because,
that will
because
consider.
he has to pay from long time and he is taking further leniency here.
No, this petition is from when? Now the calculation is from when?
Which calculation?
This calculation
From
at
the date of,
8,000.
from the date of.
Date of the
application that
application.
order.
From the date of petition.
Yes. I filed, during the time of filing the petition only, application, assets.
Now what will
everything was
happen
filed.
is.
He
now
was
if-
attending the court,
No,
family
if the
court.
court-
He was not doing any work.
Now, if the court remands this matter without you taking any amount, is it beneficial to your client?
No, my lord.
Then, if the court is doing it and your client is getting some money, you should accept it.
No.
On
Child is
cause-
there,
on-
respondent is there.
No, we'll ask the trial court to decide this issue with all your papers, what all that you are filing. And if there is any suppression, let the court take action against him. Initiate appropriate proceedings against the petitioner. Now, all this exercise, looking at what is right, what is wrong, is this a right document, all that, this court can't do that exercise now.
Yes, ma'am.
So we'll remand it, you take that money, whatever, that 8,000, whatever it is giving, let the court decide. Now the whole thing will be calculated right from the date of
Filing the application.
petition. It will be decided from there on, by the court. Once the court, whatever is the amount determined by the court, it would be from that day, and whatever you have taken will be deducted from that.
Yes,
Whatever
ma'am.
you have taken will be deducted from that.
Yes,
What is the check for? DD for?
Demand draft 31,550,
Huh?
31,500,
31,000.
550.
Then again, this amount you will do it in part.
That's what I'm.
My
I
lords
don't
have
want
asked,
like
my
that, my
lord,
lord.
what way I'm going to pay, my lord.
That
because-
is not, you can't have
Possible.
the both. Either your client pay this 1,58,000 and we will remand the matter. Or if he wants it to be like this, I'll straight away dismiss it, saying that now the court is not inclined to
Yes, I need
exercise the
some
discretion.
time, I need some time, my lord. Only my request, my lord. some
Every
leniency.
time, 1 minute,
Some-
my lord.
Please wait, if both of you argue like this, how
No,
would
my
the
lords,
end,
every time petitioner
Please
was
wait,
coming
let it
before the
submit,
court.
let him complete. Yes,
No, I'm not saying, ma'am, need some time, my lord, because I have
you
produced
had
all
enough time from when this petition is filed.
22,
22,
my
my
lord.
lord. 2 years over.
You had enough time. Even after filing this writ petition also had enough time. How
By
much time
keeping
you
the stay
want?
order, he was
And,
not
and
appearing.
first of all, you are enjoying, now you say 8,000, whatever is the admitted amount, why did you not pay till now?
My lord, this was my
The
lord.
council, no more
my- my
arguments.
lord- my lord-
Either you pay this 1 lakh, whatever it is lump sum, then only on that ground we will remand the matter. If you don't pay it, then the court will dismiss it. Please tell your client, get instructions, will short pass over, ask him.
My lord,
my lord, 2
passed over
days.
means again it will not reach the matter again
My lord,
tomorrow.
Not pass over, short pass over, I
Sir,
said, ask him to get.
2 days time, my lord. I'll just verify, my lord.
No, my lord, again they
2
will
days
event
time, my
from
lord.
this.
2 days time. Why should I run away, my lord?
Then
I'm
count
too-
then counsel for the petitioner submits that he is ready to pay 8,000. And he has already, from the date of petition till now, if the amount is calculated, it comes to 2,08,000 and he has paid 50,000 by way of, as per the order passed by this court. And the remaining amount is 1,58,000.
Of which
Land
this may.
Land council submits that, petitioner submits that he has a DD for
31,550.
31,500. They give the DD to him, 31,500.
550.
550. He submits that he'll pay the amount if the time is given in some installments and the matter may be remanded to the court. If the petitioner wants the matter to be considered or remanded by the court, he shall pay the entire amount of 1,58,000 or else this court will not remand the matter and will pass order on the merits of the matter. That amount of 38,000, the DD that is for 38,000 is handed over to the
Not
council.
38,000, 31,000.
31,000 so and so is handed over to the land council for the respondent. Forget, post this matter day after tomorrow.
My lord, have it on 8th, my lord.
Post this matter on 8th. By the time the petition shall get specific instructions, or else the orders will be passed on the merits of the matter. Yes, next. Hmm. 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 It is when. Hmm. 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 So what is this procedure? Let Registrar Judicial come to the chamber in the afternoon. In the chamber in the afternoon. Yes, next.
Till number 10.
The petition on the matter, Lords. The two applications, I filed my objections only to indicate that the matter is pending before the apex court. The client wants to only place that she is not saying that she's not going to come back. She has got some commitments
What
because she
is
is,
pending before the honorable apex court is.
I've
question.
indicated in the objections,
Yes,
Lords.
let's
All
see.
the three orders were challenged is what my instructions are.
But what is the order passed by the court?
Only insofar as 15.3 and 15.4.
Then what will happen to one?
Lords, my instructions are, the honorable apex court had indicated that they let her as well as the child not come, but the client instructs me to state before my lords to say that they are again asking for a clarification before the honorable apex court whether it is there or not, but she needs some time to come back because she has taken the job as of now and she needs to make some arrangements to come back. It is not that she is violating my lord's order or anything of that sort. These are only my instructions. My only request is to give her some indulgence, not to
How
initiate.
much indulgence you
My lords,
require?
I do
From what
understand, my
date?
lords, I am at my lord's hands, my lords. I am not saying that this
So
court has not,
this is something which cannot be entertained.
but this can
And
be
the
resolved is my,
And the parties can't take advantage
I
and
do
take the
understand.
course of the thing for a.
from
right.
March, my lords had given her indulgence
And then,
to ensure
but-
that
but
she
why
should.
did she not question this order then?
My lords, it's the party's
It
prerogative.
shows
I
that
can
she's
only,
playing-
I do
she's-
understand. my
She's
lords.
trying to play with the.
No, my lords, my
process
lords
of
may
the
not
court.
take it that way for this reason, my lords. I was not, the council was, no, I only
How
want to
about you?
make
What
my.
is about your client? It
I
doesn't
understand, my
matter
lords.
which advocate appeared earlier or what you appeared
Please,
now.
please.
Now, what is this is, now when an order is passed in the month of March, giving permission her to leave the country
Please.
and imposing those conditions, why was it not questioned?
Please, if you wanted, you should have questioned it then and there
Then and
itself,
there. No,
rather
when the
than
time
waiting
has
till.
come, half of the order, when it is in your favor, you will enjoy it. And half of the order, when you have to comply, you will question it before the court, and the court consciously not granted the order to return to India. Only because all the wild allegations that are made saying that father is violent, he will do that and this. That's why the court had, honorable apex court had stayed as far as giving custody to the father.
Please.
If that is the intention of the honorable apex, the entire order could have been stayed.
I do
Why
understand. my
not?
lords. My instructions are only this to say
So
that
let us not understand or interpret
in a
the orders
different
of the
way,
court.
in a different way.
So if we will not give any time for them to seek any clarification.
Please.
We have to pass orders on this.
Please, my lords. My only thing is I have brought to my lord's notice as to the objections which the client wants to place before my lords is to say that the matter is pending before the honorable apex court and to kind of give her time till the matter is adjourned.
Yes.
Please.
you
My
please ask.
submission is this.
But
please, your
insofar as the other case, my lords, as a officer of the court, I only want to make this submission because 15.3 state, their application is to indicate that my lord should direct the station house officer to get the child. But the honorable apex court's order in other ways says that not to give effect to 15.3 of this honorable court's order.
The girl will come to the girl.
Yes,
and the
my lords.
mother has to come to India.
That's my lord's
That
order,
would-
but
that
I'm
would
only,
be.
I'm.
But it will not give
Custody,
the
but then
custody
the
to the father.
application is to that effect. The application made by the respondent would indicate that the child should be taken custody and given to him.
No, that will not.
Please, I only wanted to place that on.
Asked it, but
Please.
she should be present unless and until she is present before the court. We will, yes, where is
Yes,
that?
please, your lordships. Now, please, your lordship, even the subsequent orders passed by this court has not been complied with by the petitioner, please, your lordships. Even today's submission, if your lordship has noted, they say that.
Who are the
they-
parties to give that IS? Where are those IS? Here it is, tax. Yes.
applications, please, your lordship. One is filed under Article 215 of Indian Constitution, read with section 11 and 12 of the Contempt of Courts Act. Here, please, your lordship, their application before this lordships would also establish that she has very clearly stated that she doesn't want to come back to India. That is filed in an affidavit, please, your lordships. Subsequently, indirectly, they are trying to impose terms on the court saying that the child should be, the child will not be brought to India, but in turn she will continue.
What do you say about that? Can she say, can she make such
He
a
cannot,
submission?
my submission, she cannot say that. That's my instructions to her also. But then what the client instructs me to state before my lords is, since the matter is pending before the apex court, she would only seek for a clarification of the honorable apex court as to what was the order which the apex court passed, insofar as whether it was 15(1), 3 and 4, or which is only 15(3). The order would definitely indicate it's only 15(3) and 4, but 15(1) also she wants to impress on the honorable apex court to say that 15(1).
File your wakalat in that matter?
No, not yet, please, your lordship, which we were awaiting the order of this.
When
court
is
on
the
this
matter coming up before the apex?
They have not fixed any date on that.
No, 6 weeks or something is there, my lord. May I just read that?
They granted for 6 weeks, that is what it states. But they have not fixed any date, please, your lordships. And further, please, your lordship, they said now the submission made by the council is that they want some more additional time to come before this court. Had it been such was the fact, they should have withdrawn the Supreme Court case, what they have filed from their end, and then sought and made an application before this lordship seeking for some extension of time to keep the petitioner and the child before this court. But again, that is not the intention, please, your lordship. They are still awaiting the order of the Supreme Court to get the 15 clause 1 state before the Supreme Court, please, your lordship. Again, this very clearly established the fact that they have outrightly disobeyed the order of the court, and further they have been continuing to do so. My humble submission is that some stringent action has to be taken by this court against the petitioner, please, your lordships.
What are the two applications that they said? One is the other.
One is seeking contempt, please, your lordships. Other application is filed under section 151 seeking the interference of the local police station, that is Wilson Garden Police Station, to produce the child before this court. Before this court, please, your lordships, not to the custody of the respondent as claimed by the
Where from you're getting
petitioner.
that?
Sorry, my lords?
That where from you're saying that they wanted.
My understanding was, since the child is a minor child, until and unless either the mother has to come back, which she is not able to because of her commitment, if the court or the application made by the respondent is to produce the child, obviously he gets the custody, my lords. Otherwise, the court cannot have the custody, is my submission. Only in that context, I submitted before this court to say that the intention is to say that let the child be brought by the station house officer so that he gets custody. And that is what the Honorable Supreme Court in 15(3) would say, that he would not get the custody till the matter is. Only that intention,
Yes, sir.
not that they have stated.
In fact, please, your lordship, the objections filed by the council on the application filed by me, they said again the orders of this honorable court has been challenged by the Supreme Court, on which there is no further, the stay has not been granted in those matters.
No,
Again, this will
after
establish
that,
that.
There are several orders passed.
Please, my
Asking
lords.
it to come to
Please,
India. What
please.
happened to those orders?
My lords, that is the reason I made this submission at the threshold to say that she needs some time because she has got commitments where she has newly employed third month, she is working over there. She needs to make arrangement and come back. That's the reason I made that as the threshold to
That
say
is
that.
the reason she would have not gone to the Supreme Court. She would have come before this court.
I do understand, my lords. That is the client's prerogative, my lords. My instructions are to state before my lords, to state only this, saying that there is some
Where is your
objections, my lords.
objection?
I filed it on Saturday. Copy
Where
is
is the,
served by way of an WhatsApp message to my learned friend. Physical copy is also given today.
Page number 2, please, your lordship, para number
no,
2
that
and
is-
3.
Where is it? It is not here. His
I'm
objection.
Saturday, I'm sorry, my lord. May I just pass my copy, my lords?
Please.
I had both the objections are in this. On Saturday it was filed. I'm not sure whether both the objections are there in that. Give me another copy. Don't have another copy.
Para number 3, please, your lordships, page 2.
Why have you not implemented yourself in the Supreme Court matter? Why have you not filed your wakalat?
I will go to the coming week, I will go and appear in front of the lordships.
No, there is an order of the apex court, where as far as your custody is stayed, then instead of, why your client is not taking steps?
I will definitely go and dispute,
Been a
I
long
will take a
time that
defense with
it-
respect to
I think it's 2 weeks before the order is passed.
26th, the order was, please, Your Lordship, almost a week, 10 days now. In fact, I have already approached the council there. We are working on that, please, Your Lordships. Now that the contempt is with respect to 15 clause 1, please, Your Lordship, producing the child before this court,
Yes, we'll pass orders.
please.
Post this matter on Monday
Please.
for the councils.
May I make one more copy and have it placed now,
Yes.
my lords? It's filed, but I'll make one more copy and have it.
I can give the copy from my side, you can make it.
No, no, voting.
Sir.
The thing is not
Yes.
come still. Grateful. Just make one more copy, ask them.
11. Cell number 11, C. Shankar Reddy for appellant.
Not, suit is for the relief of partition.
Hmm.
Not the plaintiff is before this honorable.
Where
court.
is the respondent?
Not, he has been served and he has not chosen to engage the services of an attorney.
You've argued the other day this, no?
Not.
Yes.
Not, suit is for the relief of partition.
Hmm.
Not, there are several properties, not, which are subject matter of the suit.
Hmm.
Evidence was sought to be recorded, not, at that particular point of
You're
time.
the plaintiff in the suit.
I am the plaintiff. Insofar as item number 1 is concerned, which measured 1 acre 26 kuntas. But a portion of the property, my lord, was sought to be, certain third parties, my lord, wanted to construct on a portion of the property. Therefore, when the matter was at the stage of evidence of PW1, I filed an application, my lord, let there be an interim order restraining them from interfering or doing anything in the property in question. The defendant number 3, my lord, is the contesting defendant. He files he files objections to the application.
Who are the defendants? Family members?
Defendant number 1 is my father. Defendant number 2 is my brother. Defendant number 3 claims to be a GPA holder,
Oh.
having taken the GPA from my father.
Hmm.
Not, he produces the GPA. Third defendant, not produces the GPA and says that he has got authority, not insofar as this particular property is concerned. He has already encumbered certain portions of the property in favor of third parties. But I bring it to the notice of the court that in the course of evidence, even the GPA which has been challenged in the suit is marked as an exhibit. That GPA, my lord, pertains only to 30 guntas of land. The remaining extent of land, even otherwise,
What is the
1 acre, 26 guntas of land,
1 acre?
26 guntas of land,
And in that he is,
a
he has
GPA, my lord,
GPA in respect of 30 guntas.
30 guntas.
Hmm.
Entire extent, my lord, is 1
Let
acre.
us please see your IA.
Your lordships can find it from page 42, annexure E. my lord. If I am permitted, my lord, I can place on record the GPA also, my lord, which is marked as one of the documents before the trial court.
Where is their counter? Objections?
Not, at page 48, your lordships can find annexure F. my lord. The relevant paragraph, my lord, where he refers to the general power of attorney, my lord, is at internal paragraph 3 at page 49.
GPA is 1992.
Please,
Please come to the order now.
please. Your lordships can get the order, my lord, at internal page 12. My lord, the reasonings, my lord, start from page number
Oh, you
14.
declared, you have sort of declaration that power of attorney is not binding.
Not binding on me. And further, my lord, it is one of the document, it is the general power of attorney is a document which is marked as an exhibit. And this general power of,
Yes.
not, I may permit it to place on record the general power of attorney, my lord, to show to what extent, my lord, this particular property. Not the last document, my lord, in the list, if your lordships were to turn to page 20. My lord, is the very same document, my lord, which the third defendant relies on. And your lordships may kindly refer to the schedule to the general power of attorney that your lordships can find from page 24. Your lordships, my lord, would notice that the property which is now, my lord, in question is land bearing survey number 31/2. And insofar as this general power of attorney is concerned, my lord, at the schedule, your lordships can see two survey numbers, portions of two survey numbers have been given. So in 31/2 and 32/1, 30 guntas is being given in both the survey numbers.
That is 60 guntas of land is given.
60 guntas of land in two survey numbers. But my claim is only in respect of one survey number. My claim, as your lordships could see from the application, it is 31/2. Total extent is 1 acre 26 guntas.
No, it is their case that it is self-equipped, the entire 1 acre and odd, that is first Sue scheduled property is a self-equipped property of your father.
Please, it is their case.
Hmm.
But as your lordships could
No,
see,
the court also observes that.
19, it is not a self-acquired property, my lord. In a partition amongst my father and his brothers during the year 1968.
Already there are so many plots, it's a layout and they are sold long back.
That is what extent, my lord? 30 guntas. The general power of attorney holder claims 30 guntas of land out of the total extent of 1 acre 26 guntas. 1 acre 26 guntas, my lord, in terms of guntas, my lord, it works up to about 66 guntas. Out of 66 guntas.
66 guntas means 1 acre and odd.
1 acre 26 guntas. 40 guntas is 1 acre, my lord. 66.
And 1 acre 20 guntas is the land.
It is into survey numbers. 30 guntas each in each survey number. Your lordships could see 31/2 and 32
Then
bar.
you're not questioning then that is your father's property. GPA is executed by him.
Apart from the GPA that has been executed, the remaining extent still available in the family. Not 32/1 and 31/2 and 32/1 are two properties, two different survey numbers, which are subject matter of the general power of attorney. At this particular
Who
point,
is in possession of the property is the question first.
Lord, it is a vacant area. It is a vacant area insofar as the remaining extent is concerned.
Where is that observation and where is your case? You said that is not even your case.
Not your lordships could see the general power of attorney that has
No,
been
let's
relied
forget
on by
about
the other
general
side.
power of attorney. Let's come to your IA where you have sought for injunction. It is not your case.
But that I have pointed out to the court, not I have, because
Let's come to your IA affidavit. What did you say? According to you, it is like on and off, you are cultivating the land. You don't mention about any of the constructions. Let's please read that IA.
not that IA your lordships can find from page 42 onwards. Not.
Please point out that what is your case? How are you in possession of the property?
Lord, it is the property belonging to my father, which was acquired by him under under an unregistered partition amongst his brothers, is not disputed. Lord, we file a suit for the entire extent of land. Third defendant, my lord, says out of the entire extent of land, there is a GPA in my favor to the extent of 30 guntas. And in the 30 guntas which has been given to him, he says a layout has been formed, sites have been carved out. Now the nobody's case, my lord, that the entire extent has been given under the GPA.
Let's see,
It's a
what is your case? No, you are seeking injunction. So what is your case? That we have to see.
Lord, I have stated, my lord, that this particular property subsequently has become property within the limits of BBM. Because of that, my lord, the agricultural activities have been not being taken place, that your lordships could see from the last line at page 44.
Agriculture operations, but as and when there is rainfall, we have been carrying out agriculture operations and we have been raising crops therein.
That is in respect of the, my lord, the area which has not been given under the GPA. No, my lord, as your lordships would notice, insofar as the property, my lord, which is under the GPA, I have to go in for trial, my lord, and after a full-fledged trial only the issue can be sorted out. But what is the extent of property which is not claimed by the other side? They should not, my lord, further encroach upon the remaining portion of the property and say that I am entitled to, my lord, utilize the remaining property. That is the difficulty I am facing. In so for the
1 acre, 20 guntas,
1 acre, 26,
60 guntas,
66 guntas. 1 acre, 26 guntas would be 66 guntas,
amounts to same.
out of which 30 guntas has been given.
No, 30 guntas each.
That is in two different survey numbers.
But that is your property, father's property.
My lord, one property is a subject matter of the suit. That is because the other property had fallen to the share of my grandfather. My GPA has been executed by my father and my grandfather. Prior to the execution of the GPA by my father and grandfather.
Where did you take such a stand? At least let's see from your pleadings in the plaint.
If your lordship not wants to ascertain whether it has come to the father and grandfather, today, my lord, I have produced the copy of the panchayat partition, which took place amongst my father, my brother, and my father.
No, we'll not go into the other documents now.
No, that
No, what is your case in the plaint?
my case
What is
is,
your case in the, no, you are also sought for to set aside that, to a declaration that the GPA is not binding on you.
please, madam.
Then you must have stated about the GPA, what is the extent, which survey numbers, what is your case? Let us look at your plaint.
My lord, insofar as GPA is concerned, your lordships could find a reference. My lord, internal paragraph 4, that would be paying page 20, my lord, of the plain.
Yes.
20. Last 3 lines, your lordships could see, last 4 lines. Third defendant asserted that he had acquired the scheduled property through power of attorney. Further, he had said that power of attorney executed by the first defendant and his father, H. Moon Reddy, who was the grandfather of the plaintiffs and defendant number 2 in favor of third defendant. Immediately, the plaintiffs made it clear to the third defendant that the suit property is ancestor property and the first defendant and his late father have no independent right to give GPA, not to alienate the scheduled property. After strong resistance by the plaintiff, the third defendant and his henchman left the court. This is where, my lord, your lordships could get a reference.
Para 5.
Para 5.
Hmm.
The plaintiffs immediately went to the sub-registrar office, obtained the document, certified copy of the alleged general power of attorney, and drafted verification of the records. It came to know that the defendant number 1 and his late father.
Here you do not mention about 30 acre, 30 cents, 30 guntas is in this, 30 guntas in some other thing. And you said the entire that GPA is not binding on you.
My lord, the GPA is produced before the court along with the plaint.
Yes.
The prayer is made that said GPA is not binding.
If had you.
I am not claiming any of my grandfather's property. The other portion of the property, which is subject matter of the general power of attorney to the extent of 30 guntas.
Where did you say so? That you please point out. His late grandfather had no independent right to execute the GPA or to alienate the suit schedule.
Lord, my grandfather's property I have not included in the suit. Only my father's share, my lord, I have included. That is the reason, my lord. If I had included my grandfather's property also, then I should have added one more survey number in the suit. One more survey number in the suit. Now that I have restricted myself only to the extent of property which fell to the share of my father.
Where did you restrict? You should restrict it somewhere in your pleadings, sir.
Lord, in the
Not by arguments, sir.
in the plaint,
Yes.
only my father's property is made subject.
Please look at your entire para number 5 you read, and from that you tell the court that you have restricted yourself to your father's share. No, that is not your case.
Your lordships may kindly refer to paragraph number 6.
Yes, please read.
Plaintiff submit the suit property is an ancestral joint family property. Plaintiffs being the joint family members have got right, title and interest equal to that of defendant number 1, first defendant, had no independent rights over the scheduled property to execute GPA or any other documents in favor of defendant number 3. The alleged general power of attorney is void and not
So
binding.
now this theory of 2 survey numbers, 2 things is stated for the first time before this court. Neither you have said so in your pleadings, nor you have said so in your before the trial court.
No, it is born out of a registered document. No.
No, without any pleading, court will look at the evidence.
Not-
No, in the IA also, you don't even ask a categorical this thing saying that, no, I'm not concerned with the 30 cents of guntas of land. I'm only concerned, nowhere it is your case.
Lord, it is a document which is marked as an exhibit already as on the date when they filed this
Any
application.
argument without any pleading, all the court will understand that. Why should the court understand it?
Lord, even before the trial court, Lord, I had
You
brought-
never took the plea. In your affidavit, please look at the affidavit and tell the court.
Lord, even before this honorable court, my lord, in an MFA, specifically it has been mentioned, my lord. There, my lord, by oversight, it may not have been
Not
mentioned.
oversight. What has fell for consideration before the court is what is concerned for this court
My
now.
lord, what has fell for consideration before the trial court is,
And what are the
So-
pleadings of the parties, which you cannot improve it in an appeal.
I do, my lord. But here is a case that if I had included both the properties, the
That is an
property,
equitable order that is granted by the court, and let that continue. Please come.
the first document, my lord, partition deed.
That I'll record your submissions. that I'll
Discloses, my lord,
record,
that
but
my
will not-
father and as well as my grandfather were given different survey numbers.
Had it been your intention right from the beginning, you would have said the GPA as far as 30 guntas of land is not concerned, is not binding on me.
I can make one.
You wanted the entire GPA to say that a declaration that it is not binding on you. That itself shows that you are claiming, and even that 60 guntas of land and 1 acre 20 guntas is one and the same.
My lord, 60 guntas of land in 2 survey numbers. One is to my father, one is to my grandfather.
Then why should it be, why entire thing should not be binding on you?
My lord, because grandfather's property, I am not asking, because amongst my
You
father,
should tell the court, that should be a specific pleading to
I can
that.
make a better application, not by withdrawing this present application.
That this is a OS of 2009.
It is a OS of two
No
thousand nine,
further pleadings now.
and subsequently at the instance of the other,
What is this injunction now in our 2009
because in
application?
respect of the property, a portion of the property, my lord,
When
which is
was IA
subject,
filed?
please, my lord.
IA filed in which year?
When the suit, my lord, was posted for a cross-examination, when the cross-examination was going on, my lord, there was a
No,
interference.
that's why I want to know, where is the, let us see from your application, what is the date of it?
No, it was filed in the year 2022.
Then what is the maintainability?
My lord, what happened was, this honorable court, my lord, has already passed an order holding that it is maintainable, and the office objections to that effect has been kept in abeyance.
No, according to them, why it is not maintainable office objection?
Because the value of the property is less than 10 lakhs. Therefore, the High Court does not have pecuniary
Before
jurisdiction.
which court you have filed this?
It
Before
is
which court you
before
have
the,
filed
before
this?
the senior civil judge, Bangalore Rural District, Bangalore, was the suit in a suit pending. In the said suit, my lord, originally one property was the subject matter of the suit. So when the suit came to be filed for one property only, the suit, my lord, has been valued at rupees 8 lakhs. Subsequently, my lord, item number 2 to 9 were added. After adding additional properties, my lord, additional valuation slip was not produced. Therefore, my lord, I gave an explanation before this honorable court when the MFA came to be listed, stating that the value of the property exceeds more than 10 lakhs. This honorable court has jurisdiction to entertain the same. Just
Where is that? From where?
that
you
has
have
been
said?
recorded in the order sheet.
It's already said that it's maintainable.
Recorded in the order sheet, and the court, my lord, even on the last date of hearing, in the previous.
You
my
have
lord,
placed that document before the court?
That amended plaint I have produced to show that at a subsequent point of time, additional properties were added in the plaint. Therefore, the additional properties, my lord, are also situated in the same village. Therefore, the value becomes more than 10 lakhs was the, my lord, the submission that I made. That submission has been recorded by this
No,
honorable
no,
court.
not the submission. Where is that plaint you have produced?
Plaint your lordships can find the schedule. My lord, is at page 24.
In page?
Page 24, my lord, schedule your lordships can see.
And where do you get the valuation?
Valuation, my lord, is at page 52.
52.
At that particular point of time, there was only one property, that is suit schedule item number 1. The remaining properties were added later. That is the reason, my lord, why the amended plaint has been produced before the court. While the remaining properties came to be added, plaintiff share value, my lord.
Where is amended plaint?
Amended plaint is the document that your lordship had noticed from page 18.
1/8.
1/8. Annexure B, my lord.
Where is it mentioned about the valuation?
Additional valuation slip after amendment, it was not filed. That was the difficulty. Therefore, I made a submission before the court that.
The court will value that.
Not,
No, basing on an advocate filing a slip before the court, how will this court get jurisdiction? It should be as per the valuation that is placed before the court. Looking at it, will understand that this is the valuation.
Valuation, my lord, I can get the district, my lord, the sub
No, it's
registrar
not about
valuation.
That is what is required to be filed. This court will not make an independent inquiry that whether the suit valuation is correct or what is the valuation, present valuation. It should have been before the court, before the trial court. Basing on that, the court will get jurisdiction, not basing on the slip that you file.
Right.
This page number, where is this?
If additional valuation, my lord, was filed before the trial court, it would have been better. We would be in a position to make out, my lord, that subsequent to adding of properties, my lord, the property has come. my
So
lord,
now the court is determining the jurisdiction of this court on the valuation slip filed by you.
But insofar as that particular
Correct
value,
or not, that's what is the court doing?
as on today, my lord, this honorable court, my lord, was pleased to record my submission. and
No,
keep-
please tell the court. Let's go it, not about recording your submission. Let's go it, as per the.
under normal circumstances, my lord, if I had not produced the additional valuation slip, I should make available to this honorable court the valuation of the that has been fixed by the sub-registrar insofar as the other properties is concerned, so that this honorable court would be able
No,
to
in a
determine.
MFA, whether this court will look into all that, whether it is, that's not the issue in dispute. No, you have to come before the court while it is at an office objection. You have to place before the court what is the valuation of the suit. Then only court will, the section will do it. Why the court is doing this exercise? And then giving you an opportunity to file the slip. It is something which you are not supposed to do. No, this is all the court, no, you must have filed the amended copy. There is no difficulty in finding how the court has to again value. it, you have to pay the court
I
fees.
can produce the certified copy of the original plaint. So that, my lord, your lordship would be in a position to make out when the amendment came to be carried out and how additional properties and when they were inserted, whether they were there. in
No,
the-
after the properties were inserted, there that the suit is not valued again. What is the valuation of the suit?
That was additional valuation slip was required to be filed.
You are not filed.
That has not been.
Court is going ahead without even that extra court fees that has to be paid by you.
Not that it's suit for partition, but court fee would not be a subject matter.
Whatever it
because
is, but it has. to
Whatever
be.
the court fee that
Even
has been
if it is
paid,
100 rupees is 100 rupees.
it does not, my lord, once 200 rupees is paid, that's a fixed court fee, my lord, under section 35(2). Not the adding another
Can you,
property.
then I'll record that, the earlier bench has recorded that your suit is basing on the valuation slip.
That
your
is,
suit
that
is
your
written,
lordships can,
huh?
that your lordships can find on the order sheet dated 18/4/2020.
That's what I'll record that. 18?
18/4/2023.
The office objection is kept in abeyance for the present.
Please. And 2 hearing dates back, my lord, it was all once again listed before this court. I brought the notice of this honorable court, my lord, regarding previous court order. Your lordships would also notice, my lord, the previous my lord, the roster bench order came to be passed. Subsequently, my lord, in the month of June 2024.
No, again, one more round of litigation by sending it back. Please come, agreed with the orders passed in OS number, NI number 10, in OS number 977 of 2009 dated September 23rd, 2020. The plaintiff is before this court. The suit is filed seeking partition and also a declaration that the GPA dated, what is the date of the GPA? The GPA dated so-and-so, that is dated 20/2/1992, is not binding on the plaintiff. It is a case of the plaintiff that the first defendant, who is the father of the plaintiff, is a karta of the joint family, consisting of the plaintiffs and the defendants 1 and 2. The plaintiff and second defendant are the sons of the first defendant. The plaintiffs and the defendant 1 and 2 are the members of the undivided Hindu joint family. The property bearing survey number 31/2, measuring 1 acre 26 guntas, which is described in the schedule, is an ancestral property of the plaintiffs and defendants. The same was acquired through a family panchayat partition deed dated 13/6/1968. It is a case of the plaintiff that the third defendant, along with his henchman, came near the scheduled property on 10/7/2008 at 10:30 AM in the morning and tried to trespass illegally into the sued property and tried to dispossess the plaintiff. and he could resist this same with the help of the neighbors. At that time, he came to know that he had acquired the property through a power of attorney. The power of attorney is executed by the first defendant and his father, who was the grandfather of the plaintiffs and defendants number 2, in favor of third defendant. They made it clear to the third defendant that it's a joint family property and they have no independent right to give GPA, not to alienate the scheduled property. Thereafter, he had obtained the GPA and they filed the present suit seeking partition and also a declaration that the said GPA is not binding on them. The suit is filed in the year 2009 and the present IA came to be filed in the year 2018. In the said, in the IA, the plaintiff is seeking a relief to grant an order of temporary injunction, restraining the third defendant, his agents, relatives, from interfering with the plaintiff's peaceful possession and enjoyment of the application scheduled property. That is item number 1, in any manner, including that of trespassing, dispossession, changing the identity, conditions and nature of the suit scheduled property. Item number 1, till the disposal of the suit. In support of that, an IA is filed. In that, it is stated that property is now coming within the limits of Brihat Bangalore Mahanagar Palike. If it is no longer feasible to carry out agriculture operations, but as and when there is rainfall, they have been carrying out agriculture operations and they have been raising crops therein. The revenue records are standing in the name of the elder brother on behalf of the joint family. According to them, the third defendant is making attempts to dispossess and raise unauthorized structures, which made them to file this application seeking injunction. As the plaintiffs are entitled for a share in the suit scheduled property, and in the meanwhile, if the defendant number 3 were to interfere with the possession or create any third-party rights, will be subject to the further litigation and also multiplicity of proceedings. Basing on that, they sought for a injunction. The defendants have filed their objections. In the objections, they have categorically stated that when an injunction is sought, they have to prove that there is that the person they should make out a prima facie case, a balance of convenience and irreparable loss. According to them, the suit scheduled property is a self-acquired property of the father of the plaintiff, father of the defendant number 1, that is the grandfather of the plaintiff, and he had purchased the said property out of his own earnings. The first defendant and his father, in order to purchase alternative properties and to discharge the family debts, have formed a private layout in the suit scheduled property and bifurcated sites of various dimensions. And the defendant number 3 was appointed by them as a lawful attorney since they are busy with the day-to-day activities. The said GPA has been effected on 22/1992 and has been registered in the office of the sub-registrar, Krishnarajapuram. It is their case that the plaintiff, the burden lies on the plaintiff to prove that there is an illegal trespass. And the plaintiff had complete knowledge about the GPA. It is further stated that unless and until it is shown that they are in possession of the property, question of granting a injunction will not arise. It is their case that they have already sold the properties to the purchasers. And the defendant number one and his father have in fact received consideration. All the sale deeds have been executed about 28 years ago. And the purchasers are in peaceful possession and enjoyment of the properties. And sought for dismissal of the petition. The trial court, by order impugned, had dismissed the application. While dismissing the application, the court has observed that on perusing the court records, the stage war for cross-examination of PW1, when the incident application is filed, the photographs, it can be seen that there is no agriculture activities as sites can be seen and weeds. The Kata extract and EC show still stands in the name of purchasers who have not been made parties to the suit. The defendant number 3 produced the EC stays showing that the suit properties are no longer agriculture properties and sites already been formed. The court has also observed about the RTC extracts and the name of the plaintiff's father and the purchase made by him. The court also observed that if the plaintiff succeeds in the suit, certainly they can claim for constructed building, if any, which will be fallen to their share at the time of final degree proceedings. The defendant number 3 should not seek equity in case he suffers a decree. All these aspects are not possible to decide in this IA. It requires a full-fledged trial. And accordingly, the court held that the petition is not entitled for injunction. The plaintiff is not entitled for injunction. Court has also observed that if the temporary injunction is granted, the purchasers of the properties will be put to hardship. Many of the purchasers have constructed residential buildings. And the plaintiff had failed to implement them. If an injunction is granted, it will be, the third parties will be put to lot of inconvenience. And there is no balance of convenience in favor of the plaintiff. And the irreparable loss would be the parties against, if an injunction is granted, and accordingly dismiss the petition. Next, when at the time of registering this appeal, the registry has raised objection with regard to maintainability of the suit. As originally the suit is valued at 8 lakhs, then the appellant, counsel for the appellant had made submissions wherever the said petitioner took it as appellant, where the appellant, counsel for the appellant had made submissions before the court on 18/4/2023, that initially it was 8 lakhs, then subsequently the other properties were added. Now the suit scheduled properties are valued at rupees 16 lakhs. 16 lakhs. As such, this court is having jurisdiction considering the same, the issue of maintainability, the objection with regard to maintainability, the objection of the registry with regard to the maintainability is overruled. Next, the land counsel appearing for the petitioner submits that the GPA is in respect of 30 guntas and 36 guntas in 2 different survey numbers. As far as the survey number in which the suit scheduled property which he is claiming is only 30 guntas of land. the court ought to have restrained the defendant from interfering with regard to the other properties, but the court had granted injunction had refused to grant injunction in respect of the entire 1 acre, 26 guntas. It is submitted that the property is a joint family property, and for the first defendant, that is the father of the plaintiff, has no right to execute a document in favor of the execute a GPA in favor of the third defendant, and third defendant has no right to alienate the properties and to alienate the property. It is submitted that if the injunction is not granted, they would be put to irreparable loss and hardship. Land Council had placed before this court the GPA, and basing on the GPA, he submits that 1 acre, 26, 30 and 30, 66 guntas of land is in respect of two surveys now numbers.
30, 30.
Huh?
30, 30.
30, 36.
30, 30.
30, 30. The 30, correct that, 30, 30, 60. 60 guntas of land is in respect of two surveys numbers. In respect of the other survey number, he is not claiming any partition. It is only in respect of one survey number. And the court ought to have granted injunction in favor of the petitioner in respect of the remaining survey numbers, in respect of the remaining extent of the suit A scheduled property. It is submitted that if the injunction is not granted, the loss of injustice would be caused. And as it's a joint family property, they could make out a prima facie case, and balance of convenience is in favor of the plaintiff, which the court had failed to consider. Next para. Consider and the petition is liable to be allowed, and consequentially, the IA number so and so seeking injunction has to be allowed. Next part. Though notice is served on the respondent, no wakalat is filed on their behalf. Next part. Having heard the land counsel for the plaintiff, peruse the entire material on record. It is a consistent case of the plaintiff, either in the plaint as well as in the IA, that the GPA that is executed by the first defendant in favor of the third defendant is not binding on him. Either in the plaint nor in the IA, he has never stated that the GPA is in respect of two survey numbers, and except 30 guntas of land, that is 1 acre, sorry, not 1 acre, that except 30 guntas of land, for the other remaining 30 guntas, the defendant had no right to execute a general power of attorney in favor of the defendant. He has never taken such a plea either in the plaint or before the court in the IA, and such a case is put forth before this court. Considering the entire nature of the 1 acre 20 guntas of land, court has given a finding that was made into plots, and long back it was sold, and the subsequent purchasers, some of them have already raised structures in the land. The suit is of the year 2009, and the court also observed that the subsequent purchasers who have raised the structures were not made parties. It is a case of the defendant number 3 that already the first defendant first defendant and his father has taken the consideration and having consideration. The suit is filed in the year 2009, and this IA seeking injunction is filed in the year 2019. 18, considering the observations of the court that with regard to that the defendant number 3 will not claim equity, and also that if at all the properties fell to the share of the defendant as per after a full-fledged trial, then the plaintiff would be entitled to the properties. The court had rightly rejected the case of the plaintiff for injunction, as he has failed to make out a prima facie case, balance of convenience, and irreparable loss. Admittedly, the GPA is granted, issued in favor of D3 in the year 1992, and from 1992 till 2009. From 2009 to 2018, much water has flown, and they, at this point of time, granting injunction in favor of the petition is not at play, the appellant plaintiff is not entitled for any injunction, and hence this court finds no reasons to interfere. Same, in the end of it, the observations that are made by this court for deciding this application, and those cannot be construed as the expression of this court, and the court has to dealt with the issue independently. Yes. IA number? IA number 2 of 22 is filed to condone the delay of 88 days, considering the reasons stated in the accompanying affidavit, the delay is condoned. Yes.
Number 12.
12 and 13, I appear for the respond number 2 and 3.
Respond number 4, my lordship.
Not a weak accommodation. In fact, in both the cases, the court commission was appointed, surveyor was appointed. But the survey was affected by the court submission. And he has also filed the report before the trial court. And in fact, I applied for the certified copy of the report before the trial court.
No,
Because
there is only one matter. You said two matters.
two matters.
Next matter also, my lord, connect
12 and 13.
12 and 13.
Both
So you're the, what is the case?
I am the plaintiff, my lord. My case is that they are trying to encroach onto my property. And that they are taking advantage of another decree that they
What
obtained,
is the suit for?
suit for permanent injunction.
Suit for permanent injunction.
Yes, ma'am.
What is your case?
My case is that I am the owner of the property, a scheduled A and B property, and they say that we have obtained a decree earlier in another suit against one Raju. And that is the area that they have
Who is that Raju and the connection of the plaintiff with that Raju?
is our brother-in-law. One brother-in-law, one husband is
Huh.
two cases concerning.
According to you, what is that, that property is a,
They say that it is easement rights is there and therefore there's a road there. We are saying there's no such road existing at all. And therefore our property is there. It's basically a slum area, my lord. Slum area which has been regularized as a slum area.
let's just see your plane. What is the
My lord.
relief you're seeking? Where is the plane?
Annex B, my lord.
Page number?
Page number 32, my lord. 31, sorry.
The entire set has not been given, in fact.
Only
Copy of Chapin memorandum has been served. Because in fact, they have filed all the
We
set of
normally serve
documents
only the
before
appeal
summons.
memo because it's not like a writ petition. I'll serve copy, not me.
to serve copies on him. When do you want?
Monday, ma.
Poses matters on Monday, both the matters. At the request of counsel for the petitioner, counsel for the, at the request of counsel for the appellant, counsel for the appellant should serve the copies of the appeal memo on the counsel for the respondent.
The respondent 4 and 5 have been served that they announced.
Your respondent,
The respondent 2 and 3 appears.
it should be served on
In fact, I have
respondent.
not been served with the
Two and
copies of the
three.
documents. Serial number 12.
For them also you serve,
I'll serve once again, ma'am.
shall be served on all the respondents. Yes, next.
Set of the
Number 14.
set of papers filed before the son, because he referred complaint as well as the other documents.
All the set means that only. Yes, next.
Number 14 adjourned, till number 15. DA.
Respondent.
Pass over. Yes, next 16.
Number 16. Raghavendra C. For appellant.
For the appellant in this case, Milords. Milords, this, the appellant is a bank, Milords. Respondent number 1 is my borrower.
Where is the respondent?
They were in caveat, we have served the copy on them, Milords. There's some emergency in this case.
Inform me, we'll pass over.
Published. Milords.
Pass over. Yes, next.
Till number 16. Till number 17. Raghavendra C.
It's connected matters, same.
Next 18.
Till number 18. Jaiprakash Reddy.
Oh, is it the matter which came up on the last occasion with regard to,
No, this is
not on the
bank's
not
no.
on the maintainability?
it's on maintenance, sir. No, not on maintenance.
Yes.
Till number 18.
For the respondent, my lord, I have
Jaiprakash
to
Reddy.
file wakalat in
Kindly-
this matter. Kindly pass over the matter, serial is in, end up in court all around.
Oh, in the review petition.
Yes, madam.
And you, they have
Your
to come,
lordship,
they have to file their wakalat, they have to file objections also. file your objections to
Please,
the
my
review
lord.
petition. Let grounds for the respondent seeks time for filing wakalat and filing objections. Pose this matter when?
Next week, my lord.
Monday. Monday.
Okay.
Till number 19. Lakshmikant K. Appellant petitioner, S.V. Prakash.
No representation, post after 4 weeks. Give a date after 4 weeks.
Till number 20. 20. Rajeshwari Shankar
No
Gowda. 40.
representation on behalf of both the parties, same after 4 weeks.
Yes.
Yes.
Till number 21. Prasanna VR.
Senior is held up in other court, my lord, kindly pass it over, my lord. Senior is held up in other court, kindly pass it over.
Pass over.
22. Sachin B.S. For petitioner.
For respondents, filing my part of
19, what is that?
19.
serial number 19, my lord, I appear for respondent, my lord. My lord, the petitioner, my lord, did not pay single pay.
So what is to be done?
My lord, kindly next week, my lord.
No, if he is not paying, we have to hear it now.
Please, my lord.
Yes. What is the interim order of this court?
Let's, we are for 22.
22.
He is referring to which case?
19 minutes.
Oh, you have urgency in that.
Please,
That
my lord.
matter, then post for dismissal day after tomorrow. Item 19, post for dismissal day after tomorrow. Yes.
Please.
Yes.
That's in serial number
Filing
22.
My memo of calculation.
Hmm.
For my calculation, it is 8 lakhs is arrears.
Lords, as per my calculation, lords, I will demonstrate, my lords, how 8 lakhs is not, my lords, and 7,52,000.
As per them, it's 752. As per me, it is 8. It is 48,000 rupees difference.
Why, for you, both the calculators are not same.
No, my
calculator.
lords.
For they say
That's
that they
the
have paid, but as per my client's instruction, this is the collection.
No, you have his copy.
Yes, I have given.
So look at it.
My lords, the difference, my lords, is coming in, my lords, in the second column, that is interim maintenance granted
Hmm.
by the trial court to the respondent daughter, that is 5,000 per month and 5 into 5,000, 3 lakh.
No, he says 4,000 per month.
My lords, that is for the wife. Wife for the maintenance that was
This
given.
is a matter the other day you were
Yes,
saying
yes,
that
ma'am.
from that to there.
Yes, my lords. Lords, in this matter, my lords, June 24th, my lords may see first my memo of calculation.
Where
my
is
lords.
your calculation?
The,
Uh,
lords, the order is also there, my lords. Wife was directed to give rupees 4,000 per month from the period of July 2014 to December 2018. That is 4 years and 5 months.
what is, please refer to his
Yes, I am
calculation.
referring.
Now, what is wrong with
No,
this?
that is not wrong. That is
That is
correct.
not wrong.
2,12,000.
Yes, that is correct.
Difficulty in that, which is not paid till now.
Not paid.
Not paid. my
Next.
lords. Next, my lords, that comes to be paid to the respondent number 2. That is 5,000 per month as ordered in criminal miscellaneous. That is not paid. As per order in MC 41 of 2014 to the respondent number 2, that is rupees 3,000, which is already paid. I say, my lords, that it is already paid for the period of 60 months, that 3,000 rupees in MC case, for which 1,80,000 has been paid. The arrears that is to be paid now is 1,20,000.
What do you say on this?
They say, my lords, that we have only
Tax, I have stated that totally 9 lakhs 42,000 total was balanced, wherein 1,42,000 has been paid by the
No,
petitioner.
in that, my lords, I say,
Complicated. Now, serial number 2.
Yes,
Only look at this calculation. What is wrong in this calculation?
as per me, it is, the arrears is 3 lakhs. What they say that they have paid 1,80,000, balance is 120, they say.
Yes.
As per me, they have paid not 180, it is only 142, it has been, they have paid as per my contention.
They are saying they're only paid 1,20,000.
no, my lords, 1,20,000 is arrears.
Arrears,
You
One
paid
lakh
1,80,000.
yes.
1,80,000 we have paid in MC.
How you paid 1,80,000?
My lords, in MC we have paid, my lords, which is in the order sheet of the revision petition, my lords, which says that,
But
No, how did you pay to her the money?
My lords, in the court, my lords, in MC case.
Where is that calculation of
My lord,
considered by the court?
No, my lords.
Unfortunately, both the parties, it has been stated in the judgment only. It has been paid, but how much paid by him, he has not stated that one. How much received by my client has also not been mentioned in that one.
No, there can't be any confusion. There must have been some record in the court, how much you have paid.
Both have not produced any records to that effect in that how much amount that
They
has
have
been.
received the money.
Lords, in the MC case, my lords, they say that we have paid that 3,000 amount
My only humble submission.
By bank transfer.
by in the court, my lords. We have paid it in the court.
My only humble submission. As per my clients, it is 8 lakhs. As per them, it is 7,52,000. Assuming for the
This
purpose.
is only 50,000 now.
Yes.
Only 48,000, assuming for the purpose of the arguments that his calculation may be correct.
Hmm.
But let him pay first as per him, what is he's owing. Let him pay first, deposit that amount. Then we can look into whether there is a difference or not.
Lords, my client, my lords, is ready to pay that amount within 8 weeks, my lords. There is no confusion, my lords, that may be recorded also.
We'll
My-
do one thing, let your client pay within 8 weeks. Then we will dispose of this petition on that.
Yes.
Lords,
On
now,
similar grounds. Well, I'll record it that he's also agreeable to him, provided your client pays 7,52,000.
it may be decided, my lords, regarding the other modified, which I'm seeking.
No, that will pass. Court will record, we'll make it a parted.
Yes, my lord. My lords,
We'll
then
make
in
it a
that case,
parted.
yes,
And according to you, no, this is I'll just record that according to you, the arrears
yes,
as per this calculation is 7,52,000.
Yes.
According to them, it is
8 lakhs.
8 lakhs.
yes,
Now, the 7,52,000, you're ready to pay in 8 lakhs,
8 weeks.
8 weeks.
Yes.
Provided this 7,52,000 is paid in 8 weeks, the court will pass an order
Yes,
considering your request.
yes.
Where is that you are stated in this?
My lords, in the memo of calculation itself, my
Well, you have
lords,
stated.
I have made a column, my lords, where the amount of,
Please come. By order impugned, the trial court had passed an order that the husband is directed to pay a sum of rupees 4,000 per month to the wife from the month of July 2014 to December 2018 for 4 years and 5 months. And is directed to pay an amount of rupees 5,000 per month to the daughter for the month of December 2015 to December 2020, that is for 5 years. In the court also observed that in said amount, rupees 3,000 per month, which is already paid in MC number 4144 is to be deducted.
yes, ma'am.
Land council.
4/1/2014.
Uh,
MC 41 of 2014.
MC number 4141 of 14
Yes.
is to be deducted. The land council for the petitioner submits that
Lords, there is also another, lords, in the next page, 10,000 tiller marriage.
and also an amount of rupees 10,000. Oh, that's continuation is there.
Yes, yes.
And the father is directed to pay monthly maintenance of rupees 10,000 to the daughter from the month of January 2021 till her marriage. Now, where did you say, what is your case in this?
My lords, in the memo of calculation,
Ah.
my lords, the second column, which I've stated, my lords, that seeking modification of order in respect of only that
10,000.
10,000
Land
of the period in which we have to pay, my lords. Only that we are
There
seeking.
are 3 components.
Yes.
Wife, 4,000,
Yes, ma'am.
daughter, 5,000,
Yes, ma'am.
and 10,000 continue to pay.
Yes.
Which one you want
In the
modification?
10,000 column, my lords.
Uh,
From, they have given, my lords, from January 2021. What we are seeking, my lords, from June 2023, tiller management. That is the only modification, my lords, we are seeking.
It is, land council submits that as per the order, the father has to pay from 21st,
January 2021.
21st January 2021, as he is already paying the maintenance to the daughter and the mother. That order can be, if it can be modified and the father may be directed to pay an amount of rupees 10,000 from 23rd
June 23,
Ah.
tiller marriage.
from June 23 till her marriage. when this, on the last occasion, when this court, when the matter came up, this court had directed the husband to pay the calculation, the arrears that are, that ought to be paid. Now he has filed a calculation memo showing that the arrears runs into 7,52,000 as per the modification he is seeking. As per the
As
modification.
per the total arrears as on day, my lords.
No, 10,000 is not, 10,000 you have not calculated.
I have calculated it as on today, my lords, it is also
What is the
calculated.
10,000 you have calculated?
My lords, in the fourth column, my lords. From
It is
third
a-
and fourth column.
But if
if-
you also add to it,
If my lords, if there is a modification, it will come around 6 lakh rupees, my lords. Now, if it is not modified, it is 7,52,000. So I am seeking, I'll deposit up to 6,02,000 my lords, and rest of the matter, my lords, can be decided the disposal of
And,
the petition.
if, so on such, if the order is modified, modified as requested by the petitioner, the amount would come to 6,02,000. According to the learned counsel for the respondent, it would be 6,50,000. If in that calculation, it would be 6,50,000. Learned counsel for the respondent submits that right from the date of order, a few amounts are paid. And it is it is literally difficult for both the mother and daughter take care of their day-to-day necessities. Considering all this, this court deems it appropriate to direct the, and counsel for the petitioner submits that he'll deposit the amount within 8 weeks. Considering all this court deems it appropriate to direct the petitioner to pay an amount of rupees 6,02,000 within 8 weeks from today. And if the same is deposited within 8 weeks, then then this court would pass appropriate orders on the modification as the wife had not received any amount. Post this matter, give a date after 8 weeks, give a date after 8 weeks, and 8 weeks, post this matter as part heard. Part heard on that day.
Back to modification, I will consult my client also.
No, this is a court order.
No, no.
I'm not saying that you have consented for it.
Lords, it may be directed, my lords, that to pay the amount in the deposited in the high court.
And the amount shall be deposited before this court. Yes, next.
Grateful.
Number 23.
I am for the respondents' daughters in this matter, my lords.
Ramesh.
But the maintenance petition,
You for the respondent, petition is here.
yes. They have not paid the cost and also they have not filed these also, my lords.
Non-filing of affidavit of assets and
That's
liabilities.
regarding
Not
cost.
filing of costs paid.
Cost I have already paid before trial court. The certified copy apply ಮಾಡಿ, will apply it.
He says that they has already paid.
No, not to me. The advocate
Not
has,
to, not to that person.
Whatever it is
not
that
to
he
me
says.
or my client.
He says he has paid already.
Before court only, before
Yes.
trial court. only.
Then where is the acknowledgement for
And
that?
assignment I have applied a certified copy of the order sheet. Produced in list.
My lords, it was ordered to pay to me, in the respondents, not to the trial court, my lords. Last order.
Where is the
2,000
order?
rupees to each of the daughter within a week. Last order, kindly peruse the last order dated, my lord. Not to deposit in a trial court. Just 2,000.
Payable to each of respondents within 1 week from
Correct,
today.
my lords.
If you paid to them, they understand that, won't they know that you have paid the amount?
We advanced the matter before trial court and try to trace out where is the daughters.
Where is the?
Daughters, respondents. We don't know where is she, where is the respondents. So that is why we.
Counsel is appearing here.
I am the respondent here. My
Yes,
learned
I'll-
friend has called me. I asked.
Trial court lawyer has
number.
trial court
2,000
lawyer has
rupees.
deposited the same.
Where will he deposit? Where is where is that order to deposit in the trial court?
It's not the,
And then,
but trial court advocate has done.
no, don't tell, you are appearing here. Don't tell about trial court advocate. An order is passed on 18/7/2024. According to an order is passed on 18/7/2024, condoning the delay on cost of rupees 2,000 payable to each of the respondents within 1 week from the date of order. Learned counsel submits that he filed before the trial court.
Trial court advocate has received.
Now, what is this, my lords?
Trial court advocate. Yes, I will produce the order sheet.
Now, who is
Request
trial?
the- I-
This
I request
honorable
this
court
honorable
ordered it to the given the
Court
respondent.
advocate has received, this court has specifically directed the
My
petition
learned friend called me, my lord.
to pay the amount to the respondent. Learned counsel preparing for the respondent submits that they have not received the amount. Pose this matter day after tomorrow. By the time if the amount is not received by the respondent, the appeal will be, the revision, the RPFC will be dismissed. Yes, next.
I have one more submission, my lords.
Yes.
The calculated amount they have deposited is wrong, my lord. They have.
That we will
deposited-
see, that we will see.
Yes,
There's the next step.
Great, grateful.
24.
Day after tomorrow, grateful.
Regarding the maintenance amounts that is been allowed is, my lord, 20,000 per month from the date of order
Hmm.
and 15,000 from the date of filing of the petition and till the date of order, my lord.
Hmm.
The respondent, the husband is a driver, my lord. He's
You are
not-
for the,
My lord, I'm
you
for
are-
the husband, I'm for the petitioner husband.
Hmm.
And he is not drawing the salary of 60,000 rupees, and the adverse,
how much is
Fine.
his salary?
his net salary is 30,000, my lord, and he's in the verge of retirement, due, his retirement is due in the next month. Now he'll be retired, and now the award amount is 20,000.
Pay 10,000. Arrears, how much?
Arrears is as on today, my lord, 3,60,000, my lord.
When will you pay? 8 weeks.
My lord,
8 weeks.
please, ma'am.
Then counts for the petition submit, then counts for the petition submit that the court had granted 20,000 maintenance from the date of order and 15,000 from the date of application. It is submitted that the husband is working as a driver and is on the verge of retirement. And his salary itself is 30,000, and it would be very difficult for the husband to pay 20,000, considering the submission of the learned counsel. For the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that he shall deposit an amount of rupees 10,000 by 5th of every succeeding month. And the arrears of maintenance at 10,000 would come to 3 lakhs. At 10,000, it comes to 3,60,000.
No, my lord, 10,000 it comes to,
How many months?
it's been 2 months for 20,000, my lord.
Date of petition,
From the date of, it is 22 months, my lord.
that is 2,20,000.
Please, my lord.
It comes to 2,20,000. The arrears shall be paid within 6 weeks from the date of receipt of the copy of the order. Either the 5th or this is not complied with. The order granted by this court stands vacated without further reference to the court. The petition is permitted to take out notice on the counsel appearing for the respondent before the trial court. No, there is no trial court.
They have initiated
Notice,
recovery
no,
proceedings.
notice to the
Please.
respondent. Yes.
Highly obliged.
Rajita Rajashekar.
Appeal for petition.
Appear for the respondent, my lord, kindly pass over, my lord.
Yes, next. All the lists pass over.
Cell number
Yes.
26. Content of for the petitioner, kindly pass over the matter.
For the respondent.
Yes, pass over.
Cell number 27. HV Praveen Gowda.
For petitioner, my lord, prays for 2 weeks' time.
For respondent in this case.
Why you want 2 weeks' time?
Your senior is not in station.
Pose this matter. You have any urgency stays there in this?
No, my lord.
Oppose this matter after 8 weeks.
My lord, sir.
No, if there is no urgent, if there is no stay, what is the difficulty for you?
Okay, my lord. A date.
Pose
may
this
be
matter
given.
after 8 weeks, give a date.
8 weeks.
Yes.
Cell number 28. What's the date? Satish
Go for the
Tejas.
respondent.
Yes, for the petitioner, my lord. We only have a 1 week time, my lord.
Why 2024 matter, you want 1 week?
My lord, ಇದರಲ್ಲಿ stay ಇದೆ, deposit ಮಾಡಿದೀವಿ amount ಅನ್ನು.
You didn't deposit it. You didn't deposit.
Deposited, madam. 65,000.
Deposited.
Yes, madam.
So it shouldn't be heard now.
Whatever the order passed by the trial court is very reasonable.
How much is granted?
10,000. Now he is
My lord, in
taken
this
the
case,
house in Lays in his name. now the lease period is expired. The landlord is.
We'll have him,
forcing
we'll
me
give him
to-
that 1 week time and we'll post this,
My lord, in
post
this
this
case,
matter on
the lease-
Monday. Monday, this, post this matter for disposal. Yes.
For 29. Manjunath Prasad HN.
Okay, the respondent.
Last date of hearing.
Xerox copy of the passport not filed. Take that. You have a copy of it?
I have not given.
Not
it to them,
furnished.
Because my client has given me strict instructions not to give it to them. They may misuse it.
Show it to him.
I showed it, madam. That day itself I showed it.
It's a new passport, 2009.
Oh, why your client is not understanding what is placed before the court, you will also have access to that.
But it's a personal this thing, madam. That's why I also can't tell him to insist upon, madam.
This is a new passport, as your lordship is aware. Passport is issued, validity is only 10 years. So 2019 onwards, he has intelligently produced.
It's not
Even-
even, my lord, I have been
Eh,
asked to
yes.
produce the copy of the passport. I've asked him, yes, furnished, my lord. No, my friend
So
said,
according to you, what is this? What did you do?
my
from
lord, in
19?
this, my lord, in this, my lord, the 2019, my lord, he had been to Finland.
Uh,
On 10/4 he left and he came back on 23/6, just for a period of 13 days. And
Just
then,
13 days.
my lord, I'll tell my lord, because it's not on his personal expenses, he has gone. My lord, the golf club, my lord, they have taken him. That's what the submission that has been given to me.
So to play the golf membership also, you require a lot of
It's not
money.
only just playing, my lord, it will be, he has been taken as an assistant twice
Assistant?
to assist the players from the golf club. And once it says that he has gone for.
Went to Finland, then?
And then in 2022, Cambodia and Thailand.
That
It-
also
it
they
is-
only take, they only
At
took him.
the same time, this thing he had gone there. And then 2023 has gone to South Africa.
Every year, at least every year is leading.
Not every year, my lord, in this 4-5 years, my lord, he has gone thrice. My lord, now, in this case, my lord,
1 minute, sir, 1 minute. Your lordship may kindly see, they are not fair to the wife and children, respondent. Men and women may lie, but not the records. This is the objection he has filed for MC petition 3507. Kindly see what are all the trips he has made. Because the records is more than sufficient to say how fair he is. Kindly turn to page 31. 31. This is the objections filed by respondent before the trial court. It starts from paragraph 56. 30, page 30. This is objection regarding para 26. It starts, my lord.
Para 26.
56,
my lord, 56, my lord,
56,
page number
56,
30.
page 30. Page 30.
the foreign trips, my lord, that.
Sir,
that has been mentioned.
sir, kindly allow me to speak, sir. This is my petition. Regarding the government that petitioner submits that respondent, though proclaimed that he is financially weak, it is only a farce. He is hereby denied as false and petitioner is put to strict proof of the same. The further government, as the petitioner observed that respondent visited many countries abroad for holidays and for playing golf is aptly true. Aptly true, and most of the trips were sponsored and not out of the expenses of the respondent. Government that respondent visited the following countries, name a few, not all. 2005, Amsterdam and Sri Lanka. 2008 and 9, Scotland. 2013, October, Vietnam. 2014, May, England, Scotland, Ireland. 2014, October, Bangkok. 2018, Europe golfing. 2018, Bhutan. 2018, December, Northeast biking. 2019, June, Finland biking are true. This is his admission. This is the admission of the respondent.
How much is the maintenance granted?
I have sought a barest minimum of 50,000 at that time in 2015.
15,000.
50. 50. And for children, I sought 10,000 rupees at that juncture because children were small. From 2000 to 2024, now much water has flown. My two daughters have already become major.
And trial court has directed him to pay the entire educational expenses. It is there in the, but in the operative portion of the order, it is not there. Kindly see the
That is one aspect, educational expenses.
100% court has said that he has to bear it.
What is the age of the children?
Age of the children, the first two daughters have attained majority.
How many children?
Three children are there. Only
Daughters have already attained majority.
they have already attained majority.
When they have attained?
They have attained majority during the pendency of the Simis petition
Year.
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 The first daughter, my lord, in 2020,
20.
because 3/2/2002 is the date of birth.
20 she
20
attained
she attained.
majority. And the other one?
The second daughter, my lord,
It should be the
2005,
Second, 2005.
2020, which
What?
month?
my lord, February.
February 2020.
And
Then the other one?
The second one, my lord, 3/11/2005 is the date of birth. She attained majority in 23,
20, which month?
November.
November.
And younger son is born on 3/6/2008. He is only the minor now at this stage.
3/6?
3/6/2008.
So his age is now?
Now 15 years, for 7K, maybe 16 years.
And whatever the maintenance that is granted, is he paying regularly?
My lord, this
He has
court
not, that has been stayed. Not
No,
even a
not
point.
the entire this thing, my lord. My lord, in the Simis petition, there are two petitions now. In one petition, my lord, it was granted 10,000 to the mother and 5,000 each to the three children. My lord, the eldest one attained majority. The court has stayed only in respect of the wife's maintenance, 10,000 rupees.
Why?
Because she is earning, that's what I'll show it to you.
What is her earning according to you?
My lord, she owned a company. She says that it has been closed, but no documents has been produced before this court.
If their company is there, what is her income according to you?
My lord, income according to me, my lord, I don't know exactly what is the income in respect of that company, what she has owned. My lord, apart from that, her own statements, my lord, she has several bank accounts. All those statements has not been produced before the court, saying that are jointly with the father. My lord, she has income because every year, according
Now, when are these MC proceedings initiated?
not MC,
2015.
my lord, it's
MC petition, this is
125.
Simis in 2015.
2015.
15, it was initiated at Mysore Family Court.
From 2015 till 2024, what is paid by the?
Not even a single pie is paid to the wife.
My lord,
No
apart from-
educational expense.
My lord, for the children, whatever that order is there, we have paid. Till date,
What
there
is
is
the
no
order?
arrears at all.
What is the order?
10,000 rupees per month.
5,000, initial 5,000.
ಅಲ್ಲ ಈಗ ಇರೋದ್ರ ಪ್ರಕಾರ.
ಈಗ 5,000, earlier it was only 5,000.
15,000 per month.
Yes, ma'am.
Then what will happen to their education? Who will, with 5,000, you'll get, you can educate the children and they live. And you happily go around on somebody's,
My lord,
like you say,
my lord,
like somebody's sponsorship.
My lord.
You go around the world and you leave the child, you don't take care of the
my lord,
responsibility.
the education of the children, my lord. Children were there in Mysore.
Uh.
My lord, there was an order by the family court at Mysore that they should not be removed from the Mysore. My lord, without by violating the orders of the court, she brought the children to Bangalore and she got admitted here. My lord, till 2014, he has paid. In their own statement, they have said that till 2014, he has paid the educational expenses of the children. Well, after initiating these proceedings, my lord, he has not paid. Only the maintenance, whatever that has been ordered, he has been paying.
No, he has to pay. So from 2014 till, the majority one is like February 2020.
Yes, ma'am.
February 2020, and the other is 2023, that is 2014 to November 2023. And the boys right from his date of birth itself is 2008. So from 2014 to till date.
2015 to
Till date. What are the educational expenses?
that they have to furnish the.
That they have furnished according to my affidavit also I have furnished, and recently also as per the request.
Where did you say so? about the educational expenses?
They are not stated anywhere, my lord.
No. Put it.
So you
Specifically, they
should
are not.
say,
They have acknowledged, even in 2021, court directed me to reduce the expenses incurred by the wife for herself and 3 children. There is an acknowledgement by the other side also. Here are copies, there are 2 copies.
no, how can it be 20,000 for each and
That is
per
the affidavit,
month?
that is the affidavit I have filed because they are going for tuition and badminton class. It is in my affidavit. As per the affidavit, I have furnished the information.
4,50,000 annually for 3 children.
3
including
children, that was the educational expenses.
this-
And
Any
I supporting documents, everything I have filed in the previous writ petition.
You're fine.
Yes, I have the copy also were furnished. Your lordship can summon that writ petition also. Originals I have filed.
No,
I will
here
not
what you
question.
did is badminton coaching and everything, you have given it separate heading.
Separate
number
heading, in the
4.
affidavit I have given.
No, but apart from that, why, what is the maintenance of 20,000 for each child every month? It won't be 20,000, that
No,
is on the higher side.
Kindly see the affidavit I have filed, my lord, that is in writ petition number 11736 of 2023.
Where
That
is
is the
that?
affidavit I have filed. That is another second writ petition. That is the writ petition filed by the husband challenging the 10,000 rupees order to me. I have filed the
How many
affidavit.
writ petitions are there?
There are totally 3 writ petitions.
Take the third writ petition, 11736 or what?
11736.
Take that. No, thing is when you're asked to give the particulars.
I have given annexure.
Reasonable particulars are given, it is easy for the court.
Yes,
and it
yes, that is the
also-
reason by court has not
Respondent
looked
will not
into.
deny it. At page number?
The page number, pagination has not been done.
No, 11736.
11736.
ಯಾವ order ಅಲ್ಲಿ sir?
11736.
ಯಾವ್ದ್ರಲ್ಲಿ?
ನೋಡಿ, ನಿಮ್ಮ writ petition.
ಯಾವ್ದ್ರಲ್ಲಿ?
11736.
ಯಾವ್ದು annexure?
Annexure.
ನಿಮ್ಮ assets and liabilities.
ಹೌದು, assets and liability.
My lord, it is at page number 83, my lord. 18 respondents, 89, my lord.
Next page, your lord. Monthly expenses, column.
Where do
Rent
you get?
rupees 25,000 rupees. My father has an understanding with my brother that he pays
No,
him
where is
half,
that?
half the rent.
Page number 90, my lord.
Page number 90.
90.
Hmm,
What he's reading is at page number 90 now.
hmm.
My father has an understanding with my brother that he pays him half the rent as the apartment stands in both their names. I am only staying there at their mercy.
Hmm.
Electricity and gas 4,000. Maid, I paid for my maid 10,000 rupees every month. Car, petrol and maintenance 7,000 rupees. Apartment maintenance 3,000. Food provisions 20,000. Medical expenses 3,000. Personal expenses 20,000. I will not leave lawyer's fees and all, I will not take into consideration. It may be this one, totally. Details of the legal process.
Yes, it is. Personal expenses, say 20,000 and lawyer expenses, 25,000 for hearing. If you deduct that, how much it would be? 25 plus 4,
70,000.
9 plus 10. 39, 49, 59, 69. Around 70,000.
Yes, ma'am.
Next page, kindly come, details of dependent family
1
members.
minute. 70,000 for all the 4.
Yes.
Hmm,
Then educational expenses I have mentioned, my lord. Next page, 91, my lord.
yes.
Details of dependent family members. Ananya Muttana, female age 18 years. Samana Muttana, age 15 years. CM Bopanna, nil. Approximate annual expense. This is annual expense, educational expenses,
Oh, what
rupees
are whether the
4.5 lakhs.
receipts for this?
Pardon?
Receipts.
Receipts I have produced. I am ready to produce also. In other writ petition, I have produced it, and this is the compilation of entire summary.
For receipts, sir.
I can produce it, there is no problem, I can produce the writ petition itself. In the writ petition filed, in earlier writ petition,
Really not present immediately.
Yes.
I have produced all the
Now,
receipts.
right, now even if the court comes to the finding that the wife is also earning, then you have your 50% responsibility towards whatever the school fees that has been paid by her.
My lord, yes, my lord, I do admit, I am not disputing
So
with that.
now 50% subject to, like basing on what is it, whether she's doing.
I am unemployed, my lord, I am unemployed, I have nothing.
I'm just indicating, if you're unemployed, it is 100%. If you're employed, 50%.
No, that they have to demonstrate, I am
Uh,
not.
So if that 50% educational expenses and the maintenance for 4 of them, as per your status where you don't stay in the country at least for a couple of months in a year. So considering
Not
that.
couple of months, couple of days, my lord. It's only 10, 15
So,
months.
so basing on that, how much is going, no, the maintenance for this 4 people.
My lord, the eldest daughter, my lord, she is a model.
No, that will, 1 minute, right from 2020, what is the date?
Till 2020.
February 2020 will not consider. Will not consider for the first one from February 2020, second one from November 2023. Will not consider for both of them from there. And the younger one, you have to.
The elder one has filed a separate suit claiming maintenance. Even that also a challenge wherein 15,000 advice has been granted to her.
So now, please now tell your client to put an end to all this. Otherwise, he has to pay much more than what he.
My lord, now my submission, my lord. According to my client's this thing, my lord, because she is earning, she is not entitled. My lord, for the children, my lord, they have asked only 10,000 rupees, my lord, per month for each child. My lord, voluntarily, my lord, without consulting my client, I can say that, my lord, let him pay 15,000 rupees per month each child.
So that 15, that would be 55,000.
55,000 rupees.
Medical, I mean, educational expenses.
But including that, my lord, I'm saying, but my lord, separately, my lord.
Can be, no, if the school expense for per annum, it is 4,50,000. How do you
My lord-
equate it at 55,000, 15,000 per month?
My lord, she is also earning, my lord, because
That's why, that is.
that
This
is
is
my lord,
second.
calculating
No,
that.
now,
my lord,
now
I'm
if
saying.
you can prove before the court that she is earning.
My lord, our own state, my lord, our own this thing, my lord.
So then
accepted
in
that.
that case, as I indicated, it would be 50-50. Even 50-50 also, it turns into lakhs of rupees.
My lord, 15,000 rupees, my lord, it comes to 1,80,000 rupees per, my lord, per child per year.
That is school.
That is cool.
And then what about they have to live? Only live, they can't go to
But the-
school and they don't do
My lord, the
anything else.
children are not ready to even see his face, my lord.
Now, this kind of statements, in fact, I filed GNW issue at Mysore itself. It was pending in the family court at Bangalore. We have waited for 5 to 6 years. Let my learned friend submit one document to show that he has sought visitation rights from the court. I'm ready to withdraw the entire writ
They're
petition.
all 14, 15 years.
I'm ready to withdraw the entire writ
Possibly
petition.
You can't go and see. My lord, whenever.
Should have made some effort.
My lord, that's
If
correct, my lord,
it
but
is,
because.
if it is the intention of your client.
He has abandoned as a wife. He has abandoned his children also.
No, he's busy.
He is busy. He has clearly stated that there is only de jure relationship. De facto, there is nothing in this marriage. He has stated before the MC court. He is seeking divorce also.
No, as far as the medical expenses are concerned, the educational expenses are concerned, that he has to pay and subject to whether you are considering your employment.
I'm an affidavit. If I am doing any business, any company, any other transactions where I am getting independent income, I am not telling that I don't have money. My father has invested, I am getting money. Everything I am defending upon my father.
That you are getting.
That he has made, that is also I'm an affidavit. Kindly look into that affidavit, my lord. I have not hidden anything from this court. Whatever my father has invested,
What would be your monthly or yearly?
I don't have that monthly expense. Only
income, how much?
pardon me.
Yearly
Income, he has made some investment in the name of the children and myself.
How
I'm
much you will
getting
be
around
getting?
per annum around 1,80,000 or 70,000. That he claims that I am rich.
And according to you, apart from that, there are no other.
There is no other this thing. Let them demonstrate that I'm employed, I'm getting independent
And you will file an
income.
affidavit also that you do not have.
Pardon me.
You will also file an affidavit.
I have
that-
already filed. I am before the court. I have already filed. I have nothing to file.
Well, let them produce all the bank statements, what is in it.
He wants me to file the bank statements of my father. He wants me,
But he has joint accounts, I'm saying not that the father's account. Well, joint
in that
account-
case, let him also file all the joint accounts of his mother and sister and brother. I will also file. Is he ready for that?
Every year, he is paying 10 lakhs premium to the insurance.
No,
policy.
no, sorry,
Not
sorry,
this thing.
sorry.
You know, in her own statements.
Produce Babuli Swami. Any such policy?
Please come. Both the parties shall file their independent and joint accounts they are holding before this court. Pose this matter when
Should we produce the bank statements also?
bank statements of both your joint and your separate accounts.
Separate accounts, if any.
And joint accounts.
Joint accounts.
If
Right.
any.
If any.
Both of you. And that should be from, when is this MC started?
2015, see, miss, 2015.
From 2015
15.
till now. And an affidavit in support of that.
Yes.
The wife shall file an affidavit stating that she is not having any other occupation. She is not earning. She has
Employed,
no,
she is not.
She is not doing any business or she is having any job and she is not having any separate income for herself.
Yes.
When do you want?
Yeah, whenever, I'm ready to file within a week's time.
A week's 10 days time.
Pose this matter on 21st of August. Finally, no further adjournments on that.
I'm not seeking it.
Yes.
Number 30.
My lord, I represent the petitioner, my lord.
Yes.
Kishore Kumar.
My lord, this is the wife's petition, my lord. My lord, respondent is the husband of the petitioner herein. My lord, he had filed diverse proceedings against the present petitioner. My lord, in which, my lord, the petitioner had a counterclaim. My lord, I have produced the counterclaim at page number 35, my lord. Page number 35.
He has filed the MC for divorce.
Please, my lord.
Your counterclaim is for restitution.
No, my lord, it is also for divorce only, my lord.
What is the ground on which he filed?
My lord, on the ground of cruelty, my lord.
You filed on the ground of?
On the same grounds. Same.
40?
My lord, 35 is the statement, my statement of objections and counterclaim, my lord. Page number 35. It starts from page number 35. But the prior column is at page number 48. My lord, wherefore the respondent humbly prays that this honorable court may be pleased to dismiss the petition filed by the petitioner with exemplary cause and to allow the counterclaim filed by the respondent. My lord, the trial court had passed the judgment allowing the petition filed by the petitioner. My lord, your lordship finds the judgment at page number 50. Page number 50. The petition filed by the husband was allowed. My counterclaim was dismissed. It was dismissed only on the ground that your lordship may kindly come to page number 106. Page number 106. Page number 105 may kindly be seen, my lord. Page number 105.
No, why you are before this court?
Lord, now I have sought for amendment, Lord, in order to include a specific relief that the marriage solemnized between the petitioner and respondent dated 29/1/2015, which was solemnized at Radhabai Timappa, Bandari Kalyan Mandapa, Bantu Sangha. In order to include that only, my lord, I had filed an application before the family court. My lords may kindly turn to page number 105, my lord. 105. 105. Point number 2 and 3. As there is no specific prayer by the respondent with regard to counterclaim, that is, there is no specific prayer of counterclaim, hence petitioner having proved point number 1, his marriage with respondent has to be dissolved by decree of divorce, and point number 2 is answered affirmative. On the other hand, there being no specific prayer in counterclaim, point number 3 is answered in negative. But only I have came across this fact after passing of the judgment by the learned family court judge. But thereafter, my lord, I had appealed to this honorable court by way of appeal, my lord. Your lordship finds at page number 111, annexure E. But this honorable court set aside the judgment passed by the learned family judge remanded the matter to the learned family judge in
When
order
is
to.
that order?
My lord, page number 111, annexure E, my lord. 111. But the operative portion is at 115, my lord. The judgment passed by the learned family court judge was set aside and it was remanded to the learned family court in order to consider afresh, as IA number 10 was not considered, my lord.
When was IA number 10 filed?
IA number 10 was filed much prior to the passing of the judgment for the very same relief, which was of a different amendment, my lord. Which was for different amendment.
Hmm.
Well, it's now.
No, the judgment or the decree of both of you want divorce.
Please, my lord.
Your grounds of cruelty, her grounds of cruelty, that's
Please,
what
ma'am.
it is. No,
Please,
because
ma'am.
your grounds of cruelty are not considered. No,
Please, ma'am.
the divorce decree that is granted is set aside.
No, my lord, not on that ground, my lord. As my IA number 10, which was filed much prior to the passing of the
What is
judgment.
that IA number 10?
For the amendment only, my lord. For
Seeking
amendment. Amendment of counterclaim, my lord. Amendment of counterclaim.
When did you file that IA number 10?
My lord, that was filed. In the year 2022, my lord. In the year 2022.
When did you file your counterclaim?
My lord, I had filed the counterclaim on 3/11/2016, my lord. 3/11/2016.
Counterclaim 3/11/16, amendment in 2022.
2022, my
Because
lord.
that amendment is not carried out, now again the suit is the judgment is set aside to
Please,
consider
my
your
lord,
IA
in
number
the count, in the amendment, my lord, I had sought for marriage expenses and permanent alimony, my lord, which was not considered by the learned family court
No,
judge.
even otherwise also, while granting divorce, court has to consider it.
My lord, court has not considered. No maintenance was awarded. No marriage expenses were awarded.
Let us
Permanent
see.
alimony was also
Now,
not
what is the
granted.
impugned order? Let us see.
Please, my lord. Third, your lordship finds impugned order at page number 15, my lord. Page number 15. But relevant portion, my lord, your lordship finds at page number 25, paragraph 12. As held in the above referred case law, as per the proviso to order 6 rule 17 CPC, amendment can
Now,
be
why
allowed.
it is remanded is for IA number 10.
10, my lord, please,
Where
my
is
lord.
that IA number 10?
My lord, IA number 10 is allowed by the family court.
No,
my lord.
again, one after the other, why are you coming up with this application?
My lord, since, my lord, no specific relief, no specific prayer was sought in my counterclaim, my lord, for that reason, my lord, I filed an application. My lord, I came to know that aspect, my lord, only after passing of the judgment by the learned family court judge.
What are these kind of applications? 2016, your counterclaim.
Please,
And
my lord.
on some application, again, the judgment that is delivered is not set aside. No,
Please,
again,
my lord.
after that is allowed, you will come up with this.
My lord, now the, my lord, if this my application is allowed, nature of the case will not be changed.
We will not the nature of the suit. That doesn't mean that if the nature of the relief is not changed, you will do it for years together, whenever you feel like asking it.
Now, my lord, this honorable court has remanded.
Cost has
This
to be
honorable
imposed.
court has remanded. My lord,
Cost has
this
to be
honorable court.
imposed. Cost
This
has
honorable.
to be imposed.
My lord, nominal cost, my lord, since my lord, she
Nominal
is
will not be.
unemployed.
Yes, what do you
She
say?
is unemployed, my lord, since from the date of marriage they have
You
been
can't be
separated.
permitted to go on
My
filing
lordship,
this kind
page
of
number 115 may be perused by this honorable court. 15, my lordship. Where the division bench of this honorable court clearly mentioned that therefore the matter requires to be remanded back to the trial court for consideration of IA number 10. So the matter was remanded back to the trial court only for the consideration of IA number 10. And my lordship, like the counterclaim was filed in the year 2016 and the amendment application like which IA number 10 is filed in the year 2021, my lordship. And further, the prayer, my lord, the affidavit like which is filed by the opposite party, my lordship, that is in page, my lordship. 118 paragraph number 3, she says that I state that I came to know about the proposed amendment when I received and gone through the judgment and decree passed by this
honorable court. My lordship, it is a false affidavit sworn by the petitioner herein, my lordship. Why I am coming before this honorable court with this one is, they have never mentioned in their MFA petition saying that like this, they have come to know about this one. And further, my lordship, and before the judgment has been passed by the honorable court in Fourth Additional Family Court, the petitioner herein filed one more case, MC number 1888 of 2023, asking for the divorce. Because like the prayer was not there in the counterclaim, she has filed a petition, MC number 1888 of 2023. And later, like once the judgment is passed in the trial court, since it is and it was purposefully posted before the Fourth Additional Family Court, and the reason like which they are taken before this honorable court, after the judgment and decree only they came to know there is no prayer, is absolutely false, my lordship. And further, that MC 1888 of 2023 came to be withdrawn by the petitioner herein later, my lordship. So from the beginning, that is like when they filed MC number 1888 of 2023, asking for divorce, they were very well aware of there is no such claim in the counterclaim, my lordship. And further, my lordship, when they were very well aware of the counterclaim like which they have filed, and now like after the judgment and decree, and without making a specification before the MFA in the division bench, now the honorable division bench has clearly passed an order only for the consideration of IA number 10, which is clearly mentioned in 115, my lordship. And page number 115.
Yes, I see. Now the scope of remand is very limited. How can the court go beyond that? Look at
My
page
lord, this honorable court had remanded the matter in order to consider IA number 10
only that
afresh.
when the matter is remanded, the scope of remand, beyond that the judge cannot go. Look at it, question that point number 3 in page number 105.
Please, my lord, please, my lord. The matter is remanded to the trial court. The trial court shall record evidence in IA number 10 and an amended petition, if any, dispose of the matter afresh.
That's it.
My lord, once the matter is remanded, my lord, the trial court gets the right to consider any of the applications which are filed by the parties.
In every case of remand, the court will specifically say what should be the exercise done by the court.
No, my lord, with the
Sometimes
proposed.
matters, no. If it
No,
is
my lord, with the proposed
generally the
amendment,
order is
my lord.
set aside, please listen to the court.
Please,
Generally, if
madam.
the order is set aside and said that the matter is remanded, the court shall consider all the, leave it open to the parties to adduce evidence and every issue, then it's a different case.
Please,
Now,
madam.
only for IA number 10.
Please,
it is
madam.
only that is remanded. So beyond
Please.
that, the court cannot consider any other case. Come.
My lords may kindly peruse page number 117, my lord, the proposed amendment which I have sought. My lord, by allowing this proposed amendment, no, my lord, with the proposed amendment which I have sought, my lord, the nature of the case will not be changed. Under that circumstance, my lord,
The present writ petition is filed, agreed with the orders passed in IA number 2 of 2024. In MC number 1266 of 2016. The petitioner before this court is the wife. The respondent herein had filed the MC seeking divorce in the year 2016. The wife had filed her counterclaim seeking divorce on the ground of cruelty. The trial court, by order dated, by judgment and decree dated
28th July 2023, my lord.
28 July 2023 had allowed the petition filed by the husband and dissolved the marriage between the husband and wife dated 29/1/2015. And when it comes to the counterclaim of the wife, the court has observed that as there is no specific prayer with regard to the counterclaim, there is no hence the claim of the wife is rejected. Aggrieved thereby, the husband had, the wife had preferred MFA number MFA number 6717 of 2023. And the division bench by order dated 6th March 2024 had remanded the matter to the trial court and with the specific direction that the trial court shall record evidence in I number 10 and on amended petition, if any, and shall dispose of the matter afresh. The land counsel for the, now after the matter is remanded, when IA number 10 was allowed and he was permitted to amend the petition. No, he has come up with another application under Order 6, Rule 17 to permit him to amend the counterclaim by inserting after prayer B. Which is as follows, page number 2 of the order, the amendment is there. The trial court, the family court had dismissed the said Order 7, Rule 17 petition on the ground that why this amendment is sought after the commencement of the trial. And if that is so, the valid reasons have to be stated for the said delay. And the court by judgment dated 28/7/2023 had dismissed the counterclaim. And the court do not find any reasons to consider the prayer of the applicant respondent. Land counsel appearing for the petitioner submits that, petitioner wife submits that the petitioner wife is not making out any new case. And by allowing this amendment, no prejudice would be caused to the husband unless and until the prayer is amended. The purpose of remanding the matter itself would be defeated, it would be frustrated. It is submitted that the court, without considering all these aspects more on technicalities, had dismissed the application filed by him on Order 6, Rule 17 to amend the prayer of the claim petition. Next para. Land counsel appearing for the respondent, husband submits that this is an MC of 2016 and the court had allowed the MC and granted a decree of divorce that was questioned before this court. And the division bench of this court has remanded the matter to decide on IA number 10, the amended petition, and any evidence to be let in with regard to the said amendment. And now again, such an application filed by the petitioner wife is not maintainable, and all these applications are filed only with an intention to protract the proceedings. And the trial court the family court had rightly dismissed the petition, and no grounds are made out seeking interference with the said order passed by the court. Next para. Having heard the land counsel on either side, peruse the material on record. The husband had filed an MC seeking divorce on the ground of cruelty, and the wife had also filed a counterclaim seeking divorce on the ground of cruelty, as stated by her in the said the counterclaim. And the court had dismissed in the earlier round of litigation that there is no specific prayer in the counterclaim. Thereafter, when the wife had filed MFA, and in the MFA, as there was no specific MFA, the court felt that, the revision bench felt that the IA number 10 is not decided and remanded the matter to decide the said IA and the amended petition and to pass a fresh orders. Even by the date that MFA is filed, that order of the court with regard to the prayer not being stated in the counterclaim remains to be the same. Now, the purpose of remanding and amending, passing orders on IA number 10 will be of no purpose unless this amendment is allowed. No doubt, such an amendment is made, such a petition is filed in the year 2024, when after the remand by the division bench, The while looking at the procedural aspect, this court also cannot lose sight of the substantial justice to be done. And also this court has to weigh what is the prejudice and the loss that is caused to the petitioner to the respondent husband. Now, the remand by the division bench by setting aside a judgment decree of divorce would again be, or now if this application is not allowed, and again that would lead to another proceeding, and the party would not be, this litigation would not reach to any conclusion. At the same time, this court is also conscious of the manner in which the wife is filing the applications, and the reason for this delay, even after the remand. All these things show that there are laches on the part of the wife. In that view of the matter, in the substantial interest of both the parties, this court deems it appropriate to set aside the order passed on I number 2 of 2024, dated 13th June 2024, on the condition that the wife shall pay an amount of rupees 10,000 towards costs.
That nominal amount may kindly be imposed.
My
Madam.
lordship,
Nominal
like,
amount. She is unemployed. She is
the wife
unemployed.
is very well aware of the
Madam, she
judgment
is
before
only
the judgment and
depending
decree, my
upon the,
lordship.
she is depending upon the maintenance of rupees 5,000 being
Why
paid by
is
her
she
husband.
coming up, why is she abusing the time
But
of the
she is
court?
not, she is not abusing. Malad, earlier council, Malad, she has not inserted that relief. Malad. For that reason, Malad, an application was filed.
5,000.
Nominal cost may kindly be
Yes,
imposed.
5,000.
Please.
My
Malad.
lordship, like, ಅದು MC 188 ಅವರು ಒಂದು ಕೇಸ್ ಹಾಕಿದ್ದಾರೆ. They were very well aware of that, like there is no prayer.
That is true. Now you are the one who had to pay when the MFA order is in the MFA, the court has set aside.
Yes, my lordship.
Now, again, another round, what do you want? It is not about like adversarial litigation that what the order that is granted should be set aside.
Yes, ma'am.
Ultimately, no, that is only what she is asking. The counter claims you also wanted divorce, that
Right.
prayer is not sought.
Yes, my lordship.
No, again, the same thing will repeat. Why do you want that? It is, now the matter will be disposed of. It is not on technicalities. Yes, next.
Much of
Now that 5 o'clock, that chamber, disposed of, the chamber interaction is there. Let it be at 4:45. Tell the advocates, because I have a meeting at 5:30. Call the passwords.
Passover matter, serial number 1.
This is a different issue. It's a different issue that they should appear before the party in person committee. No, it is only about the requirement of the party in persons to know about it. It doesn't say that in every case, you have to issue notice to them to come and appear. No, which rule? Generally, party in person is also like any other party. What is a circular and what is a special privilege given to them? That is, it is unconnected. It says, so that they will come to know about the requirement. They have to fulfill and comply the same, causing any further delay. That is about the committee and other things. First of all, he has to come before the court. Do that. This petition is of the year 2014. And the matter is still pending for complying with the office objections. The registry has also tried to contact the party in person. And the notice is also sent. It appears that the party in person is not interested to pursue the matter. Accordingly, the petition is dismissed for non-prosecution. Earlier when the matter has come up, this court had adjourned the matter, directing the registry to communicate the same. This should be before that, Mega. Yes. As per the office note, they have communicated. Yes, and not responded. Yes, dismissed.
Serial number 15. Serial number 15, Passover matters.
Respondent, kindly pass it over.
How many passwords?
He's on his legs in total 24.
Morning also Passover, sir. The whole list is Passover today now. Any interim order is there?
No.
Was this MFA on 21st of August
Serial number 16,
at the request of Land Council, the petition appellant. Yes, next.
Raghavendra C.
What's this fresh matter, my lords?
Have you informed them?
We have informed them, my lords. In fact, they had filed caveat, we had served them copy as well.
Yes.
Lordship may kindly may take my submissions.
Please
Lord,
argue.
the plaintiff, the appellant here is a bank, my lords.
Hmm.
The respondent is my borrower.
Hmm.
My borrower will file a civil suit before Honorable Session Judge. A claim challenging my actions initiated under the Sarfaesi Act. My borrower happens to be a daughter of a primary borrower. One Srinivas is a primary borrower. The respondent number, the plaintiff in the suit is his daughter, Bhavana, who is a plaintiff. And the wife of Srinivas is power of attorney holder for the daughter. Lord said, expert interim order was granted. A suit was filed seeking a permanent injunction against the bank, against the proceedings initiated under the Sarfaesi Act for recovery of my loan dues. The loan account of the plaintiff before civil court is chronic defaulter to the extent of more than 36 crores is the loan dues.
When was the Sarfaesi proceedings were initiated?
Nine 6/2021 minutes. There's a very long history, lords. Later suits were filed. I'll bring it to the lordship notice.
Suit was filed in the year 2023.
2024 minutes, 2023. Before that, lords, for a moment, I'll file it in the counter only for the reference of this court. I'm just passing on the written statement along with documents filed before Honorable Session Judge. Lords, expert interim order was granted. I appeared we tendered our appearance. We filed written statement, memo adopting our objections for the two interim stays granted for A number 1 and A number 2. A number 1 is for not to alienate. I number 2 is not to dispose of them from the property as against the bank. After hearing both the parties, my lords, the Honorable Sessions Judge was pleased to grant temporary injunction by wide order dated, where he confirms the interim state granted against me. Where he says, the order is, your lordship has got petition number 4902. There are two connected petitions.
I'm looking at 4728.
47. Page 15, the orders, IA number 1 and 2 will start, my lords. Only take your lordships to save the time of the court. Para 15 of the order.
1 minute.
Para 18. Para 18.
What is the suit for?
Suit for permanent injunction against the bank. Under section 34 of Sarfaesi Act, civil court's jurisdiction is directly barred, my lords. And all these factors, including the earlier cases filed by the father of the plaintiff, as well as the power of attorney holder of the present plaintiff, was also brought to the notice of the court. Lordship will find all those cases where the civil court had dismissed the case of the father by imposing cost of 20,000 rupees in the bunch of documents which I have submitted to your document, lordships. The documents are there in that.
All that are not necessary.
2 times cases were dismissed. In fact, the power of attorney holder of the plaintiff, who claims to be a mother, had filed a suit against her very own daughter, where the bank was a party. And the Honorable Single Judge Civil Judge says that he will decide the matter of under section 14 of the Sarfaesi Act, where the Honorable DRT is empowered to do so.
What do you say, page number 25?
So far as allegations of fraud is concerned, my lords, I may just rely on this case laws.
Take that.
This is discussed by this court, my lords, in Mahila Cooperative Bank, where the Supreme Court in Honorable Supreme Court in the case of electro-castings has held that just a mere allegation of fraud.
This is the Judge 2004 for SCC.
Para 34 of the judgment of this, where this court exactly on the same point, my lords, where bank is the appellant, borrower was a respondent. Of Honorable Justice Mahila Cooperative Bank versus Venugopal N and others. Lordship got it. First one is the Supreme Court, Jagdish Singh here, that which says that 34 civil courts are barred to entertain any suits or any matters pertaining to. Para 34 may be kindly looked into. This was held by Supreme Court that mere making allegations would not suffice.
Where do you get that?
Para 34, my lords, para 34.
Which judgment?
That Mahila Cooperative Bank versus Venugopal. MFA 3157 of 2022. High Court, our court.
Looking at the Supreme Court judgment.
I'm just referring that judgment has been referred here with us exactly on this point, what your lordships, para 34.
Why can't we look at the Supreme Court judgment itself?
Para 8.
What are the facts of this case?
Plus, here civil suit was filed alleging fraud. Because in Mardia Chemicals, it was stated only in cases of where the fraud is alleged, civil courts are can entertain civil suits. This court says without substantial, para 8 may be kindly removed. Para 8, the subsequent judgment after Mardia. Similar circumstances was taken before. Para 8, my lords. Having considered the pleadings and averments in the suit, more particularly the use of fraud, even considering on the case on behalf of the plaintiff, we find that allegations of fraud are made without any particulars and only with a view to get out of the bar under section 34 of the Sarfaesi Act. And by such a clever drafting, the plaintiff intends to bring the suit maintainable despite the bar under section 34 of the Sarfaesi Act, which is not permissible at all and which cannot be approved. Even otherwise, it is required to be noted that it is a case on behalf of the plaintiff appellant herein in view of the approved resolution plan under IBC and thereafter the original corporate debtor being discharged. There shall not be any debt so far as the plaintiff appellant.
It all, that is with all regard to the
Yeah.
facts and circumstances.
Yes. In this case, my lords,
Okay.
borrower has played a fraud on my part. Lordship may kindly pursue the documents.
So no, as far as that aspect is concerned, that when a fraud is pleaded, it has to be decided by the civil court in spite of a surface.
Yes. In this case, father.
No, let's see, demonstrate from the papers before the court that what is that.
The OS, my lords, by the time of
Let us
filing,
look at their plaint,
plaint is at page
46.
46 minutes. I only want to show one document to your lordships. Civil court has dealt this matter filed by the father where both plead the same pleadings. Civil court has dismissed the case as well as imposed.
This year,
Yes. This.
was it not brought to the notice of the trial court?
This was brought to the notice. In fact, this was a document part of WS. The civil court did not consider it. Lordship
number.
will find all this, the plaint
Page number.
in page number 62, document, page number 62, my lords.
It
OS
is
4,
for the very same property.
different the district court, not before the very. Yes, very same property, very same loan, everything is same.
Huh.
And he's a father of my borrower. of
OS
plaintiff.
401 of 2020.
OS 401. Lordship may kindly look into the pleadings.
Now his daughter has filed this suit.
Yes. Kindly look into the pleadings, my lords. Everything is same, fraud. What civil court had to say, I will direct.
Come to this, this plaint in OS number 401.
Yes, my lords.
Where the allegations of fraud are made.
Yes, it is very much there. Each and every para is almost in 5-6 paras, yes.
Why the daughter has come into picture now? What is our case?
Same allegations.
No, what is her case? She has nothing to do with the property.
She has nothing to do with the property. She is a co-owner of the property along with her father. Where a father, in fact, civil court, I'll just, your lordship may kindly look into para 14, page 69, para 14 of the plaint.
We'll have it tomorrow for judgment.
Yes.
Heard the land counsel in part, morning. As there was no representation on behalf of the respondent caveator, the matter is passed over. Even in the afternoon also, there is no representation on behalf of the respondent plaintiff. This court heard the learned counsel for the appellant bank. Pose this matter tomorrow for judgment. We'll dictate the order tomorrow.
Obliged.
Number 16.
So 16 and 17 both.
Cell number 21. Kanna VR for petitioner. Rupesh.
Lord, wife's petition, Lords, seeking enhancement of maintenance awarded by the family court under section 125 of the CRP.
How much is granted?
Lord, 25,000 is granted. Lord, the declaration affidavit filed by both the parties are before the trial court. Lord, in which, my lord, the husband has filed a declaration, Lord, in which he has declared that his gross income salary is 13,027 of Singapore dollars, my lords.
No, no.
Virtually, my lord, it
No.
amounts to,
What happened on 1/4/2024 is recorded that he'll pay all the arrears. That is clear.
Lord, arrears, my lords, according to my client, my lords, still 1,64,000 is due, my lords.
Hmm.
Because, my lords, trial court, my lords, interim maintenance of rupees 15,000 was used to be paid by the husband. Then it was enhanced to 25,000. Then, my lords, there is arrears of 10,000. There is some, my lord, arrears payable by the husband, my lords.
Hmm.
Therefore, still, my lord, the husband is required to pay.
How much you claimed?
Lord, I have claimed, lords, 1 lakh rupees, lords, because considering
Initially?
initially 1 lakh, lords,
No, when
considering.
the court had granted you 10,000, that time how much you
No.
claimed?
No, what, Lord, Lord, moment I filed a petition seeking a maintenance, Lord, he filed objections stating that he is voluntarily paying 15,000.
Hmm.
Therefore, Lord, he continued to pay the amount of rupees 15,000. Then, my lords, the court after trial,
25,000.
yes,
Now, according to you, that 10,000 difference has to be paid
Yes,
from the
has-
date of petition.
petition, yes.
Hmm.
Then, my lords, correspondingly, my lord, the maintenance has to be paid. Lord, according to my claim, my lords, he is still due for a sum of rupees 1,64,000, my lords.
1 lakh?
64,000.
Hmm. Now he's continuing to pay 25,000.
Yes, yes.
Hmm.
But not regularly, in the sense once or 2 months, Lord, he used to pay.
So now, what is the income of the husband according
But
to you?
according to his own affidavit, my lords, gross income, Lord, the 13,027 Singapore dollars, my lords.
13,000?
27,
Hmm.
not Singapore dollars, virtually, my lord, 7,88,133 rupees of Indian currency,
7,88,000,
133.
133. And what are his liabilities?
Lord, liabilities, my lord, he used to say that, my lord, income tax and house rent, all, the ultimate take-home salary would be 42,592 of Indian currency. If such being the case, Lord, no one will work in Singapore, my lords. What he claims that he is only retaining a sum of rupees 42,592 of Indian currency.
And now please come to the order. What is the
Please,
finding of the
Please,
court?
note. Para number 11, my lords, after calling out the facts of the case.
Yes.
Para number 11, page number 18, my lords, internal page number 10.
Please read.
The petition has filed the declaration of assets and liabilities and mentioned as housewife, and the date of marriage is 27/2/2005 and the date of separation is 7/1/2008. Whereas the respondent in the affidavit of assets and liabilities has also mentioned the same date in his similar declaration. The petitioner is not earning lady and respondent has stated he is employed. He is employed at Singapore with monthly income of rupees 42,592. The respondent has not adduced any oral evidence and has not produced any document of income. No doubt PW1 has stated not to have the document pertaining to the income of the respondent. Therefore, the assets and liabilities filed by the respondent is not supported by any document of income. Both the parties have in their declaration affidavit of assets and liabilities stated that the date of separation as 7/1/2008 and qualification of the respondent is Bachelor in Technology and employed at Singapore. The above petition is filed on.
What is the qualification of the wife?
The diploma in fashion design, Lord. Now, Lord, she is unable to get any employment. That is the problem she is facing. She is,
Until she was working.
earlier, Lord, before Lord, the marriage, she was working, and Lord, she left the job. She was taken to Singapore. She was made to reside, Lord, for about a few months. Then, Lord, she has sent back again. Again, she rushed to Singapore, Lord, since he has not taken her. Then, Lord, she was made to return to India. And para number 12, Lords, after referring the judgment of the Honorable Supreme Court, Lords, para number 12, page number 20. In view of the nature of the evidence, the nature of the admitted fact that the parties are under litigation from 2012, the date of separation being
What is 2012? Right from
Lords, as a matter of fact, Lords, earlier he filed a petition for divorce, whereas Lords, I filed a petition for conjugal.
Are you trying to say that right from 2008 she is not able to get any employment?
No, Lords, Lord, she is not.
2008 to 2024.
Yes, Lord.
Okay.
He is not employed, Lord.
How can it be?
Blood.
If she's not choosing not choosing to
Yes.
work, then it is something not
Blood.
right. When a person who is, any children out of the wedlock?
No, my lords,
Then-
because now, my lords, her mother and father, my lord, are aged, my lord, ill, my lord. Therefore, my lord, she
Going
is
from
made.
2008.
Yes,
It is not that you completely wait for your husband to
Yes.
maintain you.
but compared to, my lords, there is other proceedings, my lords.
That is another
Yes,
aspect,
yes,
whether the
yes.
wife or husband has to maintain the wife
Yes,
or
I
not.
understand.
But she being
Yes.
an educated lady, why is
Yes.
she not working from 2008?
Yes,
That is something the court has to consider. That is one aspect.
yes.
Then now coming to now what happened to the proceedings pending?
My lord,
between them?
proceedings, earlier, my lord, I filed a petition for conjugal rights, whereas my lord, husband filed a petition for divorce.
Hmm.
Divorce petition was dismissed, against which, my lord, he filed an appeal. Before this honorable court, my lord, in the year 2020, my lord, 21, his appeal was allowed, disposed of, with liberty, disposed of, not reminding the matter with liberty to amend his pleading so as to invoke provisions of section 13(1)(a), my lords, seeking divorce. Lord, he got amended the petition, then that was allowed. Now, my lord, I preferred,
Was it allowed?
my lord, it was allowed on, my lord, 20th January 2022, my lords,
30th January 2000?
22.
Permanent alimony is granted.
My lord, no alimony is granted, my lords. Therefore, my lords, my lord, the MFA has been filed by the petitioner, the appellant, my lord, petitioner, in which, my lord, there is an
Why the
entry.
permanent alimony is not granted by the court while granting divorce?
No application was
It was not sought by the petitioner itself, Your Lordship.
Lord, because, my lord, I wanted to join him, I wanted my husband back, my lord. That is why, my lord, I have not sought for any maintenance.
It should have been considered by the court when the
should
court
have,
is deciding the
but
issue of divorce.
I was already paying a sum of rupees 15,000 per month regularly, Your Lordship.
Now, what about your, how can per person work in Singapore for 42,000 rupees?
It's only the savings, Your Lordship. I will take your honor through the chronological order, Your Lordship. First of all, from 2009, both of them are not living together as husband and wife.
Hmm.
And on 30th of March 2012, MC petition came to be filed by the respondent for divorce, Your Lordship. And then to that one, restitution of conjugal rights was filed by the present petitioner in respect of with that one. Both were clubbed and her restitution of conjugal rights was allowed and this divorce was dismissed, Your Lordship. After that one, this respondent approached the Honorable High Court. No
I
stay,
understand, he told all the facts.
no
That is
stay
true.
was granted, Your Lordship.
Hmm.
No stay was granted to him in respect of both the appeals. Then, at the time of merits of that one, this Honorable Court has considered that one, since no stay was granted in favor of the husband, he is at liberty to file a petition under section 13(2)(a), where restitution of conjugal rights was not enforced. Based on that one, he filed a fresh petition, Your Lordship, not amended petition. It's a fresh petition direction given by this Honorable Court. Based on that one, he filed a fresh petition.
Oh, what
And from
how-
2009
how
to
this will
2024,
also- From 2008, what has not happened? Oh, how where is the
not even a
scope?
single penny was sought by
Where is the scope
the
for,
petitioner.
scope for?
only after the
settlement?
stay. I'm sorry, Your Lordship, I'm sorry.
Lord,
Scope for settlement, where is that?
Yes.
How can she expect for a restitution of conjugal rights?
We are ready for a permanent alimony, Your Lordship. If she is ready for that one,
But,
since she
that's
was running a
possible, that's
boutique.
possible, Lord.
Huh?
That's possible.
Then tell her,
If-
ask her to come out
if-
with
yes.
something.
She's present.
And then even that petition which is pending before the court can also be settled.
Yes.
Only, that's the only issue.
Certainly, Your
The
Lordship.
parties
We
who
are ready for a permanent alimony, Your Lordship.
The parties who are residing separately from 2008,
Yes,
what is the order that you're going to get in MFA of 2023-22,
Lord.
which is yet to be
The
heard for
intention of, Lord,
it will come up after another 5 years, 6 years.
what, my lord, she strongly believes that, my lord, husband will take her back, my lord, again. Still, my lord, in the lunch
every-
break, my lord, I have discussed,
Possible.
my lord,
Your Lordship.
kindly see, my lords, I have discussed with her
Possible,
in
Your
the lunch session, my lords. Still, my lord, she has a fond hope.
No, it is
that,
hope is what is
yes,
bhakti, what is the reality is one
Yes,
thing.
yes, I
So
understand.
like, so that
I
she can have her, the whatever that permanent alimony, what is required and also that you can put a quietus to this.
Yes.
He is also 52 years old, Your Lordship, and also is working in a private firm. Now recession is going on in Singapore. He might be,
How much your client is ready to pay?
my client is ready to pay up to 15 to 20 lakhs, Your Lordship. In one settlement.
For which my client may not agree, my lords, because I have already
Ask
had a discussion. What she says, she is mentally disturbed because of separation. So she want to join again. That's what she strongly believes. That is the.
Irretrievable breakdown has
The
already
court
gone
can't
down, Your
accept-
Lordship.
Yes. No, we will decide on the merits of it if that's what she wants. Tell her that the court has to consider all other aspects with regard to
Yes,
why she's
yes,
not
yes,
working.
yes.
Once being a educated lady and she's not working, and when granting maintenance also, all these things will
Yes.
bear
Yes.
its own.
Yes, as a
weight,
matter of fact, I have already, my lord, informed her about the pro and
She
cons. of
understands
the-
what's happening
Yes,
in the court.
yes.
So now,
Yes, yes,
accordingly, the order will be passed.
yes.
Until the stay has been granted by this honorable court with regard to my divorce petition, Your Honor, only in respect of with regard to nullity of marriage, she did not file any kind of maintenance petition from 2008 to 2024, 23, Your Lordship. Now, after the stay has been granted by the honorable court in MFA, then only she filed. The synopsis only says, their own synopsis says regarding that one. Now, this is nothing but an harassment to the
No,
response.
no, please tell the court what is your income under?
I
What
believe.
is your income?
The same thing, because now, because of the recession, his income has also been reduced and is likely to be removed also. He's 52 years. And now again, getting an employment is almost impossible. If any increase has been made, Your Lordship, again, he has to seek before the learned trial court for reduction of maintenance itself, once he loses the job. That is his plight now. Because Singapore is going through a very big recession, Your Lordship. From his company, only almost 50 to 70 employees have been removed now. And all the top management has been removed by them because they have to pay
You are
extra.
receiving an amount of rupees 7,88,133.
Out of that, he has got a age,
He has got a,
he has got a age, this one also, father and mother, and
how much
they-
you are spending for them?
he is spending on, that's what, he has already given that to Your Lordship. Isn't it? In his declaration of possession liability only, liabilities of parent with regard to the 500 Singapore dollars, Your Lordship. And also
How much?
500 comes to, what is the rate of Singapore dollar? I think it must be around 20. No, I think it's around
60 rupees.
Huh?
$1 means 60 rupees.
60 rupees. And then with
So you are
regard
spending how much?
So-
30,000.
500. 500.
30,000.
30,000. And so also house rent is much more expensive there. Even he is in a single bedroom apartment, he's paying 4,750 as a, this one, rent for that one. And electricity and transport and all those things, because he is alone, he has to take care of the food also, he cannot prepare by himself. So all those things have been taken into consideration. That's why.
Where did you
it's,
give that breakup?
in the assets and liabilities, Your Lordship, on,
Page number?
on,
No, it is not filed, my lords. May I pass on the?
no, I think LCR has come, sir. LCR has.
Please.
Last time, it was ordered for this one. This one is on,
Yes.
before the notary public at Singapore, Your Lordship. It was valid, no, the date has not been mentioned there. It was in the year 2020.
Hmm.
5th day of April 2023, Your Lordship. That notarial certificate which has been furnished along with that one says before the signature of the notary public says 5th day of April 2023, Your Lordship. Now from there on, the decision is going on, almost 50 to 70 employees have been removed from his company already. All those persons who have aged above
But
50.
able to see that statement of assets and liabilities of yours. Sujata Shantakumar is the wife.
Please.
Where is your record is there or this is the only one?
fourth page of the declaration of assets and liabilities, Your Lordship.
Hmm. Gross income is 13,027. Income tax 1,09,973.
That's a fixed one, Your Lordship.
4,750,
That's also a fixed.
400. Transport 1,500. Food upkeep 2,500.
Medical insurance he is supposed to take by himself. That's also $450. Parents and also his maintenance, another $250.
All exaggerated figures.
No, Your Lordship, because Singapore is a very expensive city. There even.
No, you already given all the maintenance. Again, you
Yes,
say
yes, Your Lordship.
another maintenance.
No, I was giving 15,000 per month. That has been shown there, Your Lordship. That's all. Whatever I was paying that maintenance regularly, even after the divorce also, even without any order of from the learned trial court, I was paying that regularly, Your Lordship.
Yes.
Considering the, my lord, income of the husband, my lords, if 42,592 was the savings, my lord, no person will work, my lord, at Singapore. My lord, India, my lord, they can work more and, my lord, earn more, if at all.
No, with all that, with all the expenses that he has shown, unless and until you tell the court that how it is bad. So the court cannot say, because court can't assume things.
Yes.
You
Therefore,
should tell
my
the
lord,
court, you should tell the court that, no, this is not the whatever is the lifestyle or whatever are the expenses.
At the time of marriage also, Your Lordship, he was in Sharjah. From there, he was by the company only, he was transferred to Singapore. At the time of marriage, he was in Sharjah. Both of them were living together in Sharjah. Then she came back to India. And Your Lordship will certainly appreciate with regard to the judgment of the learned trial court, page number 19, Your Lordship. PW1 in the course of cross-examination.
Page 91 of what?
19, Your Honor. 19 of the trial court's judgment, Your Lordship.
Yes.
PW1 in the course of cross-examination stated that the respondent to have been voluntarily paying a sum of rupees 15,000 as maintenance to her, and specifically stated that she did not seek for maintenance and that she wants to be with her husband. The parties have been under litigation from 2012. The maintenance amount paid at rupees 15,000 after the filing of the petition in 2022, the learned counsel for the respondent has referred to the following rulings. And then, Your Lordship, the benefits of these citations cannot be availed by the respondent as there is no document of income of the respondent. In view of the nature of the evidence, the nature of the admitted facts that the parties are under litigation from 2012, the date of separation being 7/1/2008, the growing inflation, the nature of the evidence, the age of the petitioner, 45 years, standard of living of the parties, it is appropriate to grant maintenance amount of 25,000 to the petitioner. It is also to be noted that the petitioner is not an earning person, and merely because the respondent is said to have paid the maintenance after filing of the above petition, and that only in 2022, the maintenance amount is said to be paid. Thereby, there is neglect on the part of the respondent to provide the maintenance to the petitioner in spite of the sufficient means. So 25, that's why based on that one, it was increased to 25,000, Your Lordship. Even though admittedly it is being paid by the respondent 15,000, it was increased to 25,000. And if the same is increased again, he will be under much problem with regard to that. And this is nothing but vexatious one, because if when the order is with her with regard to that one, the restriction of conjugal rights, she did not exercise, no execution has been filed by her at any point of time. And based on that only, this honorable court has granted a permission for me to file an application and petition, fresh petition under section 13 subclass 2A for non-implementation of the order which has been granted in favor of the petitioner herein. Until that time, she did not have any grounds with regard.
Initially, wife had filed for restitution.
Restitution of conjugal rights.
That an appeal is preferred.
For that, I preferred an appeal. No stay had been granted by Your Lordship. And she did not file for execution at all. That's why.
The court had permitted you to move an appropriate application.
Yes.
Then you filed a petition for divorce.
Yes, petition was filed and it was allowed. And now they filed an MFA on that one, taking a stay with regard to dissolution of marriage. And after that only this petition came into existence. Until that time from 2008 till the stay has been granted by this honorable court, no claim for maintenance has been sought by her. Suddenly, this has come into existence. What it shows, your lordship?
Please come. Agreed with the orders passed in criminal miscellaneous 639 of 2022, date 27th of April 2023. The present the present revision is filed whereby the revision by agreed with the order of the court. Whereby the court had granted maintenance of an amount of rupees 25,000 per month from the date of the petition till a lifetime. The husband is directed to pay the future maintenance as and when it becomes due to the petitioner. So due to the wife, the litigation expenses fixed at rupees 1,000 to be paid to the wife by the husband. Agreed with the said order. The wife is before this court seeking enhancement of the maintenance. The wife, in view of the disputes between the parties, right from the year 2008, the parties are saying separately. In the year 2009, the wife had filed an MC seeking restitution of conjugal rights. The same came to be allowed when?
30th/3/2012 minutes.
30?
30th/3/2012.
33/2012. Agreed thereby, husband had preferred MFA and this court had permitted the husband to move an appropriate application seeking divorce. Thereafter, he had filed MC number
249 of 2009.
249 of?
I'm sorry.
MC.
No, it's correct. 249 of 2009, your lordship.
No, it is not 249.
That
it
is
can't be.
amended minutes. The honorable court division bench
No.
directed him to amend the plea.
No, we filed a
Like-
fresh petition, sir. We filed a fresh petition. It
Then
was
the
not
fresh
amended.
petition is filed seeking divorce. The court by judgment dated had granted
20th January 2022 minutes.
20th January 2022 had granted divorce.
2022.
The wife had carried the matter before this court by filing MFA number
2179 of
279 of
22.
2179 of 2022. This court had granted stay and the matter is pending consideration.
But MC is, the earlier one is 679 of 2021, your lordship. MC,
679 of 21.
679
And
of
the
2020.
same is pending consideration before this court.
2009.
Then after the MC for restitution of MC for divorce is allowed, the wife had filed this petition, that is criminal miscellaneous number 639 of 2022, seeking maintenance of an amount of rupees 1 lakh. It is her case that the petitioner is working in Singapore and deriving a handsome salary. And in spite of that, he failed to maintain her. And without any reasonable cause, he had deserted her. According to her, the income of the husband is how much is 7,000?
7,88,000.
7,88,133 as per the Indian currency. The next part, the husband had filed his statement of assets and liabilities and also his objections. It is stated that after spending all the amounts by paying taxes and taking care of the rental accommodation and all, he's left with 44,000 as per the Indian currency, Indian rupees. It is his case that the wife had never asked for maintenance right from 2009 till 2022. And it only shows that with an intention to harass the husband, she has come up with this application and it is a vexatious litigation. It is their case that the wife is a graduate and she was also doing job as a fashion designer and, and why she is not working and why she is not able to earn. You want this? Why she is not able to earn? All these facts were not stated. All these facts were not stated, and it is submitted that it is a case that the wife is not entitled for maintenance. The trial court, considering all these aspects, and also the fact that he's paying 15,000 per month, even during from when you are paying from 2012.
Yes,
No,
sir.
it's 22.
No. I was paying that 15,000 from the beginning itself, when the interim maintenance was granted.
It is
After
stated-
filing the petition.
After filing the
From the date of filing of the petition itself, without there being an order from the court, that he is paying 15,000. And the court had granted an amount of rupees 25,000. Learned counsel agreed thereby the wife is before this court. Learned counsel appearing for the petitioner submits that when the husband is earning lakhs of rupees in Singapore, and the court had granted only maintenance of 25,000 when she had sought for a maintenance of an amount of rupees 1 lakh. The court had failed to consider the income of the husband and all the expenditure that is stated by him is cannot be believed. And for an amount of rupees 44,000, nobody would work in Singapore. He submits that the wife's petition for the wife's appeal before the court is before the division before this court is pending, and pending consideration of the same. She requires money to take care of her basic necessities, and amount of rupees 25,000 is not sufficient to maintain herself. Next part. When counsel appearing for the respondent submits that in view of the rescission, there is every likelihood that he may lose his job, the respondent husband may lose his job. Further, is now, what is the age?
It is 52 years.
Is 52 years. 52 years. It is submitted that he will not be in a position to pay more than the amount that is granted by the court.
She has also admitted in the cross-examination that she does not want to maintain, she want to be with her husband.
No, why she has not asked for maintenance?
Does
That was
not
the
want to?
question.
What she
She
does
said,
not
it
want to?
states that I did not seek for maintenance as I
Yes.
want to be with my husband.
Yes.
In the cross-examination and also in the, judgment, page number 19, your lordship.
What did you know? Granted by the court, it is submitted that the court has considered all the aspects and granted the maintenance, and no grounds are made out seeking interference with the well-considered order passed by the court. Next part. Having heard the counsels on either side, peruse the material on record. In this case, both the parties are educated. The wife is a fashion designer and was working and was also working for some time before the marriage or after the marriage.
After the marriage also, she had a boutique itself, according to my husband.
She had, even after the marriage also, she was working. The husband is working in Singapore. Disputes have started between the parties from the year 2008, and the proceedings were initiated in the year 2012 or 9.
12
But,
years. 12.
12 minutes.
In the year 2012.
But proceedings firstly, my lord, initiated 2009 minutes. MC
First
249 of.
initiated in 2009. The parties are living separately right from 2009. When the matter came up, this court when the party was present in the court, as the parties are staying separately right from 2008, is there any scope for settlement? The online counsel for the petitioner on instructions from the client submits that she is in the fond hope that the husband would take her back, and she wants to join the husband. Land counsel for the respondent husband submits that absolutely there is no scope for settlement, and the husband is not interested to take her back. Next, the right from 2008 till 2022, the husband had not paid any maintenance to the wife, and at any point of time, she has never sought for maintenance. It is a case of the husband. It is a case of the wife that as she was seeking restitution of conjugal rights, she has not sought for any maintenance from the husband. When this court on a specific query to the counsel for the petitioner, why the petitioner being a qualified woman is not working, he just said that he is not able to secure any employment. In considering the strained relations between the parties from the year 2008 and till 2022, no maintenance is asked and no maintenance is granted by the court. And also the fact that being a qualified lady, she is not working, considering the income of the husband, his expenditure. It is a contention of the counsel for the petitioner that those are all the exaggerated figures that are placed before the court. This court cannot assume and presume things unless and until evidence is some material is placed before the court that such a figures placed by the husband are not correct. So considering all these aspects, this court is of the view that the amount of maintenance that is granted by the trial court is perfectly legal and valid. This court finds no reasons to interfere. Yes, next.
Cell number 25.
Division petition dismissal. Arrears.
My lord, is that occasion? My lord, is that occasion on the previous date of hearing to hear the matter at some length.
For any
My lord
settlement.
recons, this is, yes, my lord. So if my lord,
Have you given them the
these are my
particulars?
instructions. My lord, sorry,
Have you given them the particulars?
of the, no,
Settlement.
no, this is, so when I had last learned senior, after the last date of hearing, the learned senior had stated that until the arrears are settled, he would not even consider any discussion on settlement. But as I had submitted on the last occasion, the affidavit filed before the court shows that his income is 8,000 rupees. It remains undisputed as on this date. Now, on merits, my lord, in terms of 125(3) and the interpretation of the coercive power available to the magistrate, my argument stands that that power is not available and there's no infirmity with the magistrate's order. But given the fact that given the nature of the dispute at hand, I have obtained instructions. What they are saying is that 19,000 plus 36,000 of arrears, of maintenance obligation, which the magistrate has found, they're able to clear that they will clear that within a period of 6 months. That's about 55,000. Within a period of 6 months, they'll clear it. Thereafter, they'll pay 5,000 rupees per month, every month, until the main matter, 29/13, 2013 is decided. That is all that they can do, barring which, unfortunately, my client is in the position where he will have to face jail time, which will render both his infirm mother and his children destitute. He is not able to do more than this money. So if they want to continue the adversarial litigation, then the only option available.
If the husband is sent to prison, she will not get maintenance.
Problem is this, my lord, it's a case where he has income to pay 3,000 per month. He's a driver earning about 25,000. And now the arrears as on today is 3,31,000. Now if he goes on paying like this.
Or to dispute the affidavit that I have filed before the learned magistrate, that amount remains undisputed. 8,000 rupees per month is my
According
income.
to you, how much are the arrears?
There is, my lord, according to us, the only arrears are 55,000. That is 19,000 in one case and 36,000 in a case which is not the subject matter of these two petitions. In these two petitions, the only amount that I have not paid is.
No, because all the amounts must be given to you on some account or some.
No, in only by account, no, not by account. It's in the court through the advocate. Every time it's written in the.
The memo of calculation that they have filed, my lord.
Everything is
They
written
have
in the.
included arrears which have been disallowed by the learned magistrate.
Yes, that's
My
the
lord would
question.
appreciate in the wholeness of the circumstances, there are two maintenance orders, substantive orders. One is an interim maintenance order in 29/13 of 3,000 rupees per month, and one is another one in 21/2016, which is a final order for 3,000 rupees per month. Now, there are two recovery petitions as the subject matter of these proceedings. They have initiated other recovery proceedings, and the fact is they themselves have placed material and record to show that I have been making payments from time to time. Now, as of now, in accordance with the orders of the learned magistrate, I have an outstanding sum of in 33 of 2023, 17,000 rupees, and 24 of 2024, which is not the subject matter of the present writ petitions, there is 36,000. That is a total sum of 55,000. On instructions, I'm able to submit that they will clear this entire sum of arrears within a period of 6 months. Thereafter, they will pay 5,000 rupees per month, every month till the date of disposal of 29/13, subject to the petitioner cooperating with the proceedings in 29/2013, because in the last 2 years, they have not participated in the evidence at all in the proceedings. And also subject to them not pressing any other recovery claim. This is what my client is able to do, barring which I'm in the very unfortunate position of having to contend before this honorable court that he can go, that he will, I mean, jail time is the only option left to him.
It's
It
like
is
a-
only going to render the other members of his family destitute in order to, if the logic of this argument that 125(3) power is available, my lord, is to protect the wife from destitution, he and his other members of the family will have to suffer destitution.
Yes.
No,
Vila.
that I only wish to say, the matter is of 2017, 3,000, now the child is 10 years old. Now threat is, if you don't agree for this, I will go to jail, etc. This actually is not proper. The
No,
question
but,
before the.
what she says is 53,000, you say is 3 lakhs. Where
No,
is the?
as on, that's, see,
where is the parity
kindly
between the
appreciate, the problem is with some of the honorable magistrate, despite the honorable Supreme Court's order, they insist an application being filed every year.
That is
And
not
every
the
year,
case. Let's forget about that.
No, this
I
is
am
covered.
no,
What's
no,
covered
I
in
am
this?
on the point.
Please.
But the arrears.
Please.
There can't
No,
be,
there
there
are-
can
there-
be 10-15,000 difference, but not lakhs.
It is
difference.
like this, as far as the present case is concerned, it's for the two execution petitions filed, which is
So she
before
was
the
telling
honorable
about
court.
public, with, I mean, the consolidated amount of both the petitions.
That's not correct. These are all such pleas are urged because they're the beneficiaries of such pleas, and because of that, even the trial courts matters are being adjourned from time to time, and years together it goes on. Because kindly also appreciate, once such a plea is urged, the trial court adjourns it. They're the beneficiary of this adjournment, and they're not going to lose anything. Like other suits where there can be interest on the amount, no interest, even if it is 5 years old, they can go on paying 1,000 each, 500 each. This, what is happening is
There
this in the present
what is
case.
where is this problem lying with regard to the calculation is the first question.
Calculation, the problem, actual problem lies is not with the calculation. Problem lies is the dilated tactics by the husband to avoid the payment. That is the problem here. Continuously dilated tactics, and to see that the
When
poor
did you
woman
pay, when did
loses.
you pay the last amount?
My lord would just appreciate the, there are two recovery petitions. One is, sorry, the substantive order is
Recovery petition.
29/2013.
Recovery.
29
Till-
29/2013.
May I pass on with permission, my lord,
82
the calculation which I prepared, kindly.
This
they are not
calculation,
stitched
my
in.
lord would only see.
Please,
Have you given it to her?
we had been furnished.
Please look at it.
Yes.
Please,
No, no,
kindly see.
give the calculation.
The simple one, simple, there's nothing
Give it to her.
that has been
Because the
furnished.
court can't say anything on that.
As per, in my lord's question to us is, my lord's, total, as per order dated 25/3/2013 in MC number so and so, 3,000 per month. We fund to 11 years, so and so, that the amount actually to
I
be
think
paid.
some calculation problem.
There cannot be any calculation problem.
No.
They want to,
No, for example, 3,000
there's no calculation problem.
per year, how much it comes? 36,000.
Total amount has to be paid is 4,11,000 from there onwards, from
It is
that.
11 years, sir.
Oh, 11 years, it's pending, matter is pending. What is totally paid, last page, the honorable court may kindly peruse. Pending is this. Only paid is this in the first page.
My lord, may I just clarify?
What the,
Here, what has happened
now all
is-
these matters I beg to submit. Now what is happening is, I am told in a civil case, the problem starts actually not with the decree. Actual problem starts with the execution. The same is happening. Unless the honorable writ court in some case decides and gives some direction how it should function despite the Supreme Court's decision, this will go on continuing, and the poor woman will not be able to recover anything. All sorts of pleas will be urged. The only way is, I beg to say, not only in this case, I pray the honorable court that the guidance to the trial courts that whenever the execution petition, main petition is disposed of, there should not be one more execution petition for that. And it goes on. execution petition after execution petitions and issue notice, doesn't appear. So who will?
Then according to you, how it should go on?
It should go on like this, my lords. As in a now this on the Supreme Court is laid down in a suit, once the preliminary decree is laid down, there's no other fresh application for FDP and fresh application for execution. Same matter continues. And the same matter should continue where IA should be filed for recovery. Recovery is a continuous process and there should be a direction that the amount should be deposited to the bank account so that the courts are not burdened on that. If that is not done, the steps can be taken. Otherwise, every time issue notice to him, notice will never be served, coercive steps will never be executed. This will be the problem. It should be a continuous process. The problem with the trial magistrates, this Honorable High Court on the administrative side will decide the number of cases disposed of. So they want the statistics for the disposal numbers. So the trial courts are also anxious to see that each case being disposed of one more number. This has to be evaluated at the administrative side so that the trial court, when they decide the case, though it's not closed, but it's disposed, matter is decided by way of a judgment, first case. That should be taken into their account.
For example,
Please.
now you file this execution petition after 12 years from the date of
That is not the
order.
case.
No,
That's
no.
not, please, please.
If it is, for
Please, please.
example, you
Please.
file it after 12 years. So all the records pertaining to that case should be kept.
No, I beg to submit. There's no question of filing the execution petition after 12 years. As the Honorable Supreme Court said, there's no need to go on filing one after the other execution petition. On the administrative side, then this procedure has to be evolved.
Then how?
The matter which is, once the judgment is rendered, in the same case, it continues for execution case. In the same case,
Every
IA is filed
matter-
for
Every
recovery.
matter that is disposed of.
Matter
all
should
the-
not be disposed of, is my submission. Matter cannot be disposed of. Then high time that the matters are never, matter should not be disposed of such cases because our rules and the procedure, the machinations should help the distressed. Once you disposed of, the problem is this.
This will create
No,
all the more
no, kindly, now,
problem.
kindly take the example of how the Honorable Supreme Court now issued direction for the civil suits. Once a civil suit is decided, it's not disposed, they continuous, then the FDP in the same suit, same IA is filed in the FDP. And that's what the Honorable Supreme Court has also laid down in that decision.
In every suit, there won't be final decree proceedings.
It will not be there. It is only in 125 proceedings. In such cases, it should be a continuous process.
See, now with regard to that whatever calculation they are saying, how you're paid, what is the mode of payment and all, please tell the court.
May I just make a submission, madam? One, on the submission that learned senior counsel has made is completely misappreciated the scope of a partition suit in a recovery proceeding. My lord would see that there's FDP.
No, that will not go into, please
All
file.
right, file, my lord.
A memo of calculation is filed by the petition saying that an amount of 4 lakhs and all.
Amount
lakh.
of 3,31,000
3
Madam,
lakh
that is
31,000.
till
is
August
pending.
24, yes.
3,31,000 is pending land comes for the respondent husband says, and the amount is only 53,
55,000.
55,000. 55,000. The respondent shall file an affidavit before this court, how and when the amounts are paid. Yes, pose this matter on 21st. Yes,
Please.
Number 26,
20?
26.
Hmm.
Rajendra Kumar Sungai for petitioner. Sandesh P. Nadiger.
Yes,
Lord, in this case, I apply for the petitioner.
yes.
Lord, it is against the order passed in the execution on the IA. Filed, my lord, the petitioner, my lord, is the wife. There is a joint petition filed before the local Adalat for compromising, my lord, for a mutual consent for a decree. On the condition that 10,000 rupees to be given to the wife every month till she gets a job or remarried again. That was the thing. My lord, the husband, my lord,
Placing on the divorce is granted.
yes, yes.
Hmm.
Divorce was-
When is that?
My lord, divorce was granted on 10/5, 22/4/2018.
22/4,
2018.
2018. Hmm.
Then my lord,
How much she should pay? 10,000.
10,000 per
Till she
month,
gets remarried.
remarried or till she gets a job.
Then what happened?
That was, then my lord, he never used to pay. Then we used to file execution petition and collect, recover the, one of such execution was filed, my lord, during the, on 4/7/2020.
Hmm.
For recovery of this 10,000 rupees. Then my lord, what has happened? For that, an objection was filed on the ground that during the 2 months period from November 2019 to January 2020,
the petitioner had worked in some school and she drawn some salary that was not disclosed here. So because of that, my lord, the petition has to be dismissed. Then IA also has been filed under section 340.
So why did you not
28.
disclose that?
Lord, that was by mistake, my lord, it was not mentioned.
How can it be a mistake?
Lord,
Now the order is till you
No, no.
marry or till you get employment.
No, on the date of, no, only for 2 months she worked there as a trainee teacher, my lord. As a trainee teacher, she got some 16,000.
So there is every scope that you can have employment and you are not having it.
No,
To get employment, you can get, but you're not getting.
No, Lord, that particular was that period, my lord, only 2 months it was there.
Let's see the order.
Thereafterwards, my lord, she has
Let's see
resigned.
the order.
Yes, madam. That is at Annexure E.
Hmm.
Page number 47, my lord, it's there. The judgment debtor has filed IA number 4 section 341 of CRPC.
With effect from 4/11/2019 and taken a salary of 20,000 per month. The moment she joined as a trainee teacher and drawn salary, she is not entitled for any maintenance. The court has also observed that they committed perjury under section 191 of 193.
So, my lord, now, my lord, my submission is, my lord,
Hmm.
she has left in January itself, my lord, she is not working. Thereafter, my lord, she has joined as a guest faculty in the, I am not claiming anything. Only, my lord, for this 20,000, my lord, that amount, my lord, we are ready to give back that amount. My lord, let this, my lord, because this direction which has been issued to register a case against her, my lord, might kindly be set aside. That's the only grievance I can have, my lord. I have no other grievance against her.
Perjury proceedings are initiated.
That is the order to be initiated, which has been stayed by this honorable court, my lord, in this proceeding. The 20,000, my lord, whatever is there, but my lord, I am ready to pay. Was it?
How much amount you have received in these proceedings?
Lord, the execution was filed. I just.
How much you have paid in these proceedings to her?
Execution was filed for recovery of 90,000.
90,000.
How much you
For
paid?
filing of application under 340 subsection 1 of.
Uh.
I have to verify how much amount has been paid. After payment of certain amount, the warrant was recalled. Then this application was filed because the respondent got to know that the petitioner is working in a school.
Even as on the date of filing.
Letter, now we'll set aside this order and as far as that perjury proceedings are concerned, provided you return that money which you have received.
Yes.
How much is the money?
I'll seek.
20,000, my lord, that's what
You're sure?
time basis.
So I have to verify.
2 months, my lord, the maintenance said.
For judgment tomorrow? Day after tomorrow?
Yeah.
Day after tomorrow, heard the councils on both sides for judgment. Day after tomorrow, post for judgment. Yes, next. Huh? Two-30 months, let's call it 4 o'clock. Call the next part.
Serial number 31. Krishnan.
20?
31. Appellant. Krishnan M for appellant.
MFA of 2019. What is that? Unfinished. Why the office objections you are not complying for a 2019
My lord, what happened, my lord,
MFA?
is that there were a series of appeals, more than about 100 appeals. We complied in about 99 appeals. I think one odd case, my lord, there was a delay. What happened, my lord, is that the reference petitions were sought for, we would not get it in time. So in that confusion,
So
my
what
lord,
are you going to do now?
my lord, what has happened, my lord, is that in this matter, though the court has said that there's a delay of, Registry has raised an objection that's a delay of about 3,000 days. That may not be right because after the order was passed by the Honorable Civil Judge, we filed a review. The review petition went on for about nearly 6 years. And after which, my lord, when a review was dismissed as not maintainable, that we have come before this.
No, what are the objections that have to be
But we have
complied?
complied everything now as of now.
Except what?
We, as of now, we have complied.
The counsel for appellant has partly complied the office objections on various dates.
Yes, my lord.
And finally complied the entire of so and so as per entries made in the so and so.
As my lord, what I
No, it
request.
is IA is coming up.
Yes, my lord, a notice may be ordered, my lord, on this because they're about
Who are the respondents?
respondents, my lord, are the landowners, my lord, who have lost their lands. So it was acquired for the rare material plant.
Commissioner Mysore Subdivision. Registry that issue notice to respondent 1 and 2. Post after service of notice.
Nice.
Yes.
32. Manjunath SV. 32.
With my lord's permission.
It is not pressed by the council, the prudential time.
The
Yeah.
matter was listed on Friday.
Huh.
My colleague was pleased to argue the matter before my lord. My lord
Hmm.
observed, if an affidavit is filed that will not seek equity, then appeal may be allowed. My
But the
sub,
difficulty is.
yes, my lord, that is what I
That's what
wanted
I'm telling him.
Please.
No, there is an ex parte order.
Certainly,
As far as this application is concerned, you are not a party.
certainly. Therefore, my
With
lord,
order, you are questioning it before this
if my
court.
lord permits me, kindly permit me to file necessary applications before the trial court, including order 917
Hmm.
and recalling the
No,
order.
but you already filed.
Not yet, not yet. I think it is day after tomorrow.
But then I will direct the court to entertain that.
Please, ma'am. And early disposal of
But
this.
very assertively you are saying that only this MFA will be maintainable.
No, no. I
No, but if it is coming up day after tomorrow, we'll say that you file it, it has to be considered first.
And direction to the trial court to dispose of my IA within a period of 15 days at least. ma'am.
The present petition is filed, the present appeal is filed, agreed with the orders passed in I number 1 and order 39 rule 1 and 2 CPC by the plaintiff 1 and 2, whereby the court had granted injunction
Against the appellant only.
injunction restraining the defendant number 14 or anybody claiming under them from putting up any construction in any portion of the item number 2 of the suit scheduled property. You are 14.
Yes.
The agreed thereby, defendant number 14 is before this court. The facts of the case are the respondent herein had filed a suit for partition. What is the suit for?
Suit for partition.
Suit for partition. And he has sought a suit for partition. The petitioner, the appellant herein, wherever I say petitioner, make it as appellant. The appellant herein is arrayed as defendant number 14, who is the purchaser of the property. What is that? Oh, that is for that AE. No, when the dictation is on, it should be green. What did you write? Property. The defendant number 14 who is a purchaser of the joint family property is arrayed as is a defendant number 14. He was set ex parte on
No, please, ma'am.
What, and 16/12/2018.
He was set ex parte on 16/12/2018 and later. And on 2nd April 2024, the present injunction order is passed. The Land Council appearing for the defendant submits that he has raised a structure, a huge structure. And if at this time, if this order is passed, it would cause a lot of hardship to the defendant number 14. As such, the same has to be set aside. He has not filed any, it is also undisputed fact that he has not approached the court to set aside that ex parte order. And without questioning the same, he has come before this court seeking to set aside this order. In the considered opinion of this court, the petitioner, the appellant cannot maintain this appeal. And first he has to go approach the trial court and file an application to set aside that order where he has been placed ex parte. In that view of the matter, as this court is not interfering with the order that is passed with the trial court. This court is not proposing to issue notice to the respondents. However, the petitioner, the appellant is at liberty to file an appropriate application under Order 9, Rule 9 before the court. And the trial court shall decide the said application within 15 days from the date of filing, accordingly disposed.
39 Rule 4.
And thereafter, the court can deal with the application filed by the defendant seeking to vacate the interim injunction granted. Yes, accordingly, the appeal is disposed of. Yes.
Within 15 days, please.
Huh? 15 days, I said.
Both ways.
How both, first application has to be heard, then once you have to be again taken on record, then the other application. First application 15, other application 15.
Publish. Question, Lordship, you kindly issue the hand delivery of the order.
Huh?
The day after tomorrow, the case is posted. I'm requesting the hand delivery.
Yes. Yes.
Jail number 33, 34 adjourned, number 35.
I will switch on this. Yes. What is this?
This is regarding maintenance, my lord.
The other day the matter.
Yes, I have to
Why
file
it
a
is
memo.
adjourned?
Memo has to be filed. I'll file it in the office because I've got the statement and his employment resignation today morning. I'll file it before the office and
I have filed my detailed objection.
they have filed it on Friday.
Assets.
Yes,
You have received the objection?
I have received the objections. I'm filing the memo with the statement of the bank statements and his resignation letter.
There are a number of infirmities in the affidavit which has been filed.
That can be argued, my lord.
No, these points were not raised. It was only stated that
30?
certain documents were not
35.
produced.
30? Why this, the problem is all that is supposed to be done before the trial court in the year 2021.
It has.
This court is doing it in
The
2024.
affidavit of assets was considered and a considered order was passed by the learned trial judge. 75,000 was ordered to be paid. The matter came up they filed a writ petition here. And in the writ petition, though my caveat was present I had filed a caveat. On the eve of the matter, I was asked to take the copies. When the copy was served to me, there was nothing, no date, no time. The matter came up the next day and in my absence, they have obtained an order reducing the maintenance to 30,000. From 75,000, it was reduced to 30,000 in my absence. And it was also I was permitted to modify this, given permission to seek modification. I have sought modification. That application is pending for 4 years. That nothing on every date of hearing on some.
No.
Either the matter would not reach, I'll be very honest with you. Either the matter would not reach or with great difficulty when the matter is posted for hearing, some reason or the other, it would get adjourned. And ultimately what happened, it is because of my insistence that even arrears were not paid, a certain amount was directed to be paid. That also order. Another 13 lakhs is still pending as
4 lakh
arrears. 4
lakh 30,000.
4 lakhs.
This arises out of what proceedings?
Under 13(1)(a).
24,
filed the
section
MC?
24.
The wife filed the petition again.
Both have filed, madam.
No, both have filed. After the order of maintenance was passed, the counterclaim came to be filed.
Wife filed for divorce and husband also for divorce.
Filed for
No,
divorce.
husband
Yes.
files for divorce after an order of maintenance was passed. Till then, he's participated in the proceeding.
Husband, but you filed for divorce.
Divorce.
You also filed for divorce.
Yes,
I
much
filed for
later.
divorce. I initiated the divorce
That I
proceedings.
understood. After that, you also filed for
Yes.
divorce.
Yes,
Yes.
Today it's set for judgment in the lower court.
because my application
Please
for
come to the
permanent
order.
alimony is
Please
also
come to the
pending.
order. Is it happening?
Order is at. It's at page 13. The court had granted. The respondent is directed to pay interim maintenance of rupees 50,000 to the petitioner from the date of application till the date of order of IA and 75,000 from the date of order till disposal of the petition. The respondent is directed to pay 50,000 as litigation expenses. Here, my lord, she had paid for 2 lakhs as the alimony, interim alimony.
The
Filed the
petitioner-
assets and liabilities also when the application was filed. It's at Annexure F. Page 100.
In his affidavit of assets, he states that his general expenses is 95,000. So when he is entitled to have expense, his expenses are that. It can be assumed that she
was running a school.
The school was closed. The ITR has been filed showing that she has been incurring losses. And because of which she closed the school. And now, to be very fair to the respondent, respondent wife, my lords, she is undergoing training for obtaining a pilot license. She is equipping herself so that she does not have to depend upon she's not at the mercy of the petitioner. So she is equipping herself. She has spent huge amounts for getting this commercial pilot's license. Both her father and her sister are pilots. And both of them have been assisting her. The respondent was also.
She has a job.
Now she does not have a job since 2019. She does not have a job, but she's pursuing these avenues which are open
She
to her.
was running a school which she closed. She states that she took a loan of
When was she run, when she started,
She started in
2011, she started and closed it in 2019. It's a place.
1 minute, 2011 she started.
Yes.
2019
She closed.
She closed. When she sought for maintenance?
Maintenance was sought in the year 2017.
2017.
Yes.
So till 2019, she's having her income. How much she's earning?
She was not, and it was running at a loss. I've produced the ITR also, where she has obtained 65 lakhs from her father and sister to assist her to set up the whole, for the capital expenses and thing. And since she was not recovering any amounts and was running at losses, and the income tax return discloses that, that is the reason she was compelled to close down the school.
For 6 years, she was running the school. She was running a nanny service. She's got quite a few qualifications. It's not one qualification. She's done hotel management. She has done.
Yes, she was.
Yes, she's got quite a few qualifications. They have hardly stayed for 18 months. They got married in 2014 Feb and separated in 15. No children out of this 16, I'm sorry. 15 to 16, about 19 months they have stayed together.
There were a number of issues because of which he had to leave. And
now
in-camera proceedings were held, my lords, in the trial court. And there has been evidence which has been produced to show what is the cruelty she suffered at his hands. It may not be appropriate for me to mention it in open court, and hence this court can look into the orders. My only point is
Even now he's willing to settle the matter for a lump sum one-time settlement, he said. He has resigned from his job in April 2023 and it came into effect from, it came into effect from September 2023. Now he doesn't have a job. His mother is very ill. He's the only child. His mother.
He is not having job.
From 2023 September.
His income tax return shows in 6 months, he's got 10 lakhs a month. His salary.
Which year?
In the year 2024.
Last year.
By their own records.
That is 2023.
2023. Now he has resigned from the job in September 2023.
So
His
from
mother's-
April to
because he has
23.
stated very clearly in his affidavit that he's mentally very upset, depressed, because of all these cases which has been going on. His mother is fallen ill. She had a bypass, multiple bypass. So he has to look after her and he's not able to do because a pilot's job is very high risk and a lot of tension. He's not able to continue. He's a senior pilot and he's not able to continue. So he
There's-
resigned.
That may be true. There should have been some, this thing notice given to the DGCA for mental disability you're required.
He's
to-
resigned. I've got the resignation.
Resignation
application.
letter and acceptance we have not seen.
That
Because
I
let
wanted to file
Let
it. I
all the
wanted-
documents be filed. We will
I will
argue
file
the
it. In the
matter.
beginning of the
You-
matter, I said I will file it. I got it today morning. So I was not able to file it before. I'll show you.
And also they, in their own bank statement, it shows that on a certain day, on 25, 26 of last year,
No, the she says it is September. That is-
September, he has resigned. And subsequent to that, what I'm trying to say is he says his parents are dependent upon him.
Yes.
The father has deposited 4 lakhs in his account and the mother has deposited another 1 lakh. These
Because
are all,
they
document.
had a heart attack in a pilgrim center or Kedarnath or somewhere. They had to airlift her. They had to bring her to Dehradun, do the surgery, then bring her to Bangalore. There were a lot of amounts which were spent. So they returned some of the amount because she would not get insurance. So they returned some small amounts. The father is a ex-bank employee. He has a pension. And now since he's not working, they had to return because from September 2023, he's not working. This happened in March, April of this year.
But he has worked as a commercial pilot, a senior captain for the past 12, 14
He's
years.
also got
Sufficient,
equal.
sufficient savings have been made because he had stated in his previous affidavit, which was in the trial court, that he does not have any dependents. And his salary, though he says he produced his conduct has to be observed, please, my lords. He produces a salary slip of the year December 2020 when his pay was at the lowest because of the COVID times. There is a document known as the pilot employment agreement, which is in his possession. He has admitted it in his cross-examination. There is no impediment to produce that. I filed an application under Order 12, calling upon him to produce that. There was no response to that. Even those documents which are in his possession, he is not producing because he wants
No,
to.
before going into from 23 September till 23 September, he was working.
He was
working, so he was getting at least 7 to 10 lakhs a month.
No, not 7 to 10 lakhs. It was at the time when they were living together, it was some 1,97,000. Over the years, since the matter has progressed, over the matters, it has increased. 4 lakh was the time when they were passing orders. Now, last year, the year before last, he had a pay cut because during COVID, they did not have much income. It was
So
after
as
COVID.
on, and when this IA is filed in the MC?
Yes.
2017.
17, his income was only 1,97,000. We have produced those documents.
That was only for 1 month.
Not for 1 month.
Where are the other documents to say that it is not for, it's only for 1 month? No.
His own documents speak.
We have
The
produced
document
it.
which he has produced is only of December. Though he says
You
it's for
says
6
100
months.
and,
I will demonstrate to this court the kind of
She has
suppression of
not even
material facts.
produced in her assets and liabilities before the lower court. She has not even produced the statements, 1 year statement she has produced.
No, all.
And
as
says that
required by-
it's, can anybody who's taken a loan of 67 lakhs pay a nil ITR? That is what they have done. There's lots which has flown under the bridge. It is
ITR,
just that
Let them take it up with the tax authorities. Let them come and raid my house, do whatever has to be done.
even
But
now
in
what she
these
has
case,
filed,
an
she
ITR
spends per month in Marks and Spencer's
Please come.
18,000.
All this, let the court decide, let the trial court, the family court decide with all this suppression, whoever has suppressed the facts and filed an affidavit before the court, let there be an action initiated by the trial court.
Yes, please.
The,
And stipulated time may be
Yes.
fixed so that the matter can
the,
reach a quietus.
agreed with orders passed in MC number 4797 of 2017 dated 24th May 2021. whereby the family court had granted maintenance of an amount of rupees 50,000 to be paid to the wife from the date of application to the date of order, and an amount of rupees 75,000 towards litigation expenses. or
No, no, 75,000 from
75
the
is
date
from
of order
an amount of.
and 50,000
1
of
minute.
litigation expenses,
To
which
pay-
is not
pay
being paid.
maintenance, interim maintenance of rupees 50,000 to the wife from the date of application till the date of order, and rupees 75,000 from the date of order to disposal of the petition. And also court had granted an amount of rupees 50,000 towards litigation expenses.
That also has not been paid, my lord.
The
One submission, my lords, may be directed to produce their pilot employment agreement. During the.
He has
during
produced
his-
all his documents. Pilot employment agreement is not an important document.
That shows his salary, what are the perquisites he's
Has
entitled.
been produced. The salary certificates have been produced.
this court, by order dated 7/3/2023, had modified the same to 30,000 per month.
Yes,
Yes,
30,000.
With permission to.
And also
modify.
an amount of rupees 10 lakh shall be deposited for this court on or before 4/4/2023. Both the council, this matter has come up before the court on a couple of occasions. Both the parties have filed several documents before the court. According to the husband, the wife had suppressed her income, and she has not come out with the true facts. According to the respondent, the wife had, according to the wife, the husband has not placed the correct facts before the court, and is in fact drawing a huge income, and all these aspects were suppressed. What is that?
Somebody has connected.
No, before you're disconnecting him, who it is, we should know which number he has logged in. Ask the computer people. What did you write? The income was suppressed. And considering this rival stance taken by both the parties, this court deems it appropriate to remand this matter to the trial court. Before the trial court, the parties have to file all the statements of all the particulars as per the judgment of the Honorable Apex Court in Rajneesh versus Neha's case. And considering those documents, if the court finds that any of the parties have suppressed any material before the court, as per the law laid down in Rajneesh's case, appropriate proceedings initiated against the party who has suppressed the facts and find false statement before the court. This application shall be decided by the court within 1 month from the date of receipt of the copy of the order. The parties shall file, no, within 15 days from the date of receipt of the copy of the order, the parties shall file their respective statements of assets and liabilities as per the judgment of the Honorable Apex Court in Rajneesh versus Neha. From there on, within 30 days, the court shall dispose of the application.
So the fresh application, affidavits have to be filed.
Yes. Yes.
Cell number 36, Praveen S.
For the petitioner in this case, my lordship,
Yes.
on the last date, my lordship, this honorable court had passed necessary orders directing the petitioner to facilitate visitation of the respondent between 11 a.m. to 5 p.m. on Sunday, my lordship. That was yesterday. The needful has been done according to my client, my lordship.
It is my resource to present, my lord. There was a direction to pick up the child from the clinic. Anyway, the place was not the same place, but agreed upon direction by this.
No, whatever it is, not to the
10 to 11
technicality.
to only 2 hours he was permitted.
It went on.
No, so that is what he.
What has happened?
The moment I entered the place, she asked me that,
You speak, otherwise the council can't hear you.
yeah, my lord, the moment we entered the play area, she said she wants to, he wants to have discussions with me. He wants to speak to me. The son, my son, he wants to speak to me before start playing. So they said, we can, we can also talk once you finish the, the games. He said, no, I want to speak to you now. Then he said, you promised me that tomorrow when you go to the court, you tell the judge that, don't drag me to the case, and he's getting stressed out, and just tell the judge that only if he's interested in meeting me, you should come and meet me. And otherwise, he is not ready to come. He's asking me like, only if you promise that I will play with you. Then after convincing him, almost he's spoke to me around for half an hour. And he was saying the same thing, like about the court case. So I said, see, this is not not your age to talk about this. You only focus on like, let's play, have some good time and we'll go back. But he was insisting me to, tomorrow you have to go to the court and tell this, then only I will, come and play with you. And the most, worrisome part was, she told me that he's very stressed out and he's saying that he may take his life in front of him. So I said, you should not talk to, the child in front of him. You should not even, this kind of communication
Have
should
you
not
heard,
happen.
Mr. Counsel?
My lordship, I am not aware of this, my lordship. None of this was informed to me, my
Please
lordship.
put all this in an affidavit and
Please.
file before the court.
Please, ma'am.
This court has ordered.
And only
Place
till
all
2
that
o'clock.
on record. This court has passed an order permitting the father to exercise the visitation rights, and the father is present before this court, and he has has stated how the visitation has went on and what all the mother and the son has stated in the course of visitation. The father shall place all these things on record by way of an affidavit, and the respondent shall come, the petitioner shall reply to the same. Pose this matter on 21st of August, and on 10th, 11th, and on 18th, the father shall exercise the visitation rights. What was there in the order?
11 to 5, madam. 11 a.m. to 5 p.m., my lordship.
Shall exercise the visitation rights between 11 a.m. to.
And moreover, lordship, may kindly see in his present, she is also joining, accompanying, he is also scared. That is what instruction C says.
What is happening?
In her absence, probably you'll allow me to, because that is what, allow him to take the child somewhere out so that.
But that is what was the order.
No, it is not allowed. She was there, throughout she was there.
No, what was the order, Mr. Counsel?
My lordship, my client tells me that the child insisted on her presence, so she left them in a park and she was sitting outside the park, my lordship.
No, not park. It's a play area.
It is a play area.
She
not
was
even a
sitting
park.
outside the park. She was not in the park with the respondent. She was sitting outside the park. They were playing in the play area.
She was throughout with them. At least this time, allow the child to be, allow him to take the child, drop him back.
The petitioner, the father shall pick up the child from the clinic and shall again drop him at the clinic by 5 o'clock. By 5 o'clock. After looking at the affidavit that's going to be filed by the father, as stated by him today in the court, what has transpired, then the court would pass appropriate orders. Yes, post on 21st.
Oblige, my lordship.
37 Rajesh case. Srinivas case.
I appear for the petitioner in this case, my lords. Lords, in this case, I would like to humbly submit before His Honorable Court that the petitioner was before the trial court by seeking the custody of the children. That was the only prayer which he has sought. That was rejected before the court, and that is why we are before His Honorable Court, because being a biological father, he is having a right to visit the children. And my lords, just I'm refreshing the points. So in the year 2020 and before that 2019, when the RCA, Restitution of Conjugal Rights, was filed, when the divorce case was filed, the respondent was not bothered to appear before the court. Neither she has questioned that before any higher court, nor she has filed any maintenance case before any court of law, my lords. That is for your kind information. Meanwhile, in the GNWC case filed before civil court by the petitioner, in that, the objection which she has
What is
filed,
the age of the children?
no, my lord, I would like to submit as a petitioner because I was not allowed to submit till date. I would like to say state few points, and then definitely I'll answer to your question with great respect.
Present, the eldest
great
is
respect, my
about
lord,
8
I
or
have
9
not
years.
completed. I have not completed.
At present, the eldest is 8 or 9 years, and then the other one is much young.
My lords,
4, 5 years.
children are like one child is 8-year-old and one child is 10 or 11-year-old, I think.
From how long you have not seen them?
Children were not allowed to see them since 2016. When the second child was born, she abandoned. This petitioner is suffering from diabetes and he is a heart patient. We have brought the medical report also, which he is regularly visiting to the Jaideva. That also, by even not bothering about that, she left, she abandoned, and she was not bothered to appear before any court. She has not claimed anything before any court, my lord, till date. And my lords, this petitioner is working in a private company and his job is very
Oh,
insecure.
this is the case, yes, sir.
We have met there in the
That's okay.
chamber also.
Huh.
My lords, he is having a very insecure job where job can go at any time because it is a target basis job. He is working in a travel agency and he is earning only 50,000 rupees salary. In that, most of the expenses will go to his EMIs that he has purchased one vehicle, one two-wheeler, and also for his medicine.
No. When the court has asked him what is the maintenance, he says, I understood the first part of the order that he has to visit the child. But all the clients are not understanding the part of the order which they have to do. All their duties and all, they're not able to understand. As far as the rights are concerned, they're understanding and executing it.
My lord, even the respondent is also not aware about her right.
First of all, that
She
you
never
should see.
claimed any, my lord, my lord is taking a volunteer interest in this by mentioning about the maintenance, whereas the respondent is not bothered to knock the door of justice anywhere till date.
No, that is not the issue. What
But
about
my lords, what we are mentioning.
The father shall submit before this court. What is the maintenance he is going to pay for the children?
My lords, I will
This
mention.
also will be considered while passing the further orders.
My lords, she is paying 1.5 lakh to one child and another child 1.5 lakh. 3 lakh she is paying every year to the school. She is getting 40,000 salary. And she is the one who has to answer that where is she is getting that source of income. One thing. And my client certainly he can't bear that amount because he is not that rich. He is holding a BPL card and he can't pay that much amount, my lords. As per his strength, he will pay 6,000 rupees to the kid monthly. That is what his strength, my lords. And also otherwise, even otherwise.
Both the kids.
My lords, even otherwise, others.
Please answer to the court's query. I said
Sorry.
both the kids or one kid.
One kid.
Why the other kid is not?
No,
concerned with-
3,000 they can, otherwise they can adjust 3,000, my lords. 6,000 he will pay.
What is the salary?
His salary is only 50,000. In that, as I told my lord, it is based upon the target basis. If he reach the target, then he'll get that salary. Otherwise, he'll not that much also. And he's having lots of pressure. He's a diabetic. He is a heart patient. So he has.
Out of 50,000 salary you are getting, you will pay 6,000 to
Yes,
the
my lord.
children.
Yes, my lord.
That's what you're saying.
Yes, my lords.
Yes.
And my lords, we have a school. I have brought this school details to your notice, my lords. These schools, like one is St. Joseph's, one is St. Teresa. These schools, my lords, in 60,000 or 50,000, children are getting a CBSE central syllabus education in these schools. I don't know what made her to pay 1.5 lakh, 3 lakh every year and make children to study there. And for as she herself has declared that she is getting 40,000 salary. How she is maintaining that, she has to answer before this honorable court. Then why this much exorbitant demand after this many years when she has not approached any court anywhere till date? When we came to ask for the children visitation, She come up with all these demands before this honorable court.
And you will only want to see the children on and off.
No,
for
no,
at
no,
least
no,
for-
we pay as per our strength, we pay
What is
6,000.
your strength is 6,000.
6,000. Also, my lords, kindly, it may be considered to send the children during weekends because he's having his old and ailing parents. They are eager to see the children during weekends, my lords. That may be considered. Kindly.
Yes.
May I? See, may have raised a number of points, all of which are refutable. The first thing is, as I mentioned earlier also, and even in the chamber, she allowed him to divorce her and not even claim maintenance, saying, leave me in peace. And there's one important fact on his side, important, which is beneficial for him. The fact is that they took care of her until the delivery. When the child was a girl child, they treated it as an untouchable.
It's a cooked up story.
Please let me finish, then you enter, okay?
Say, he was listening when you're arguing.
Yeah, yeah. Okay.
So they treated it as untouchable, even when your lordship told them that they could go on for visitation. And right that day, though you had not dictated for that day, right that day, he himself said, let them talk. I said, fine. So they went there, but they made it a point to talk only to the first child and avoid the second child altogether. The mother, the sister, the father was sitting separately. He's quiet. He's not really listening. They're not that they are all that unhealthy. They are quite capable because I've seen them in person and they were also outside their chamber. So with all this thing, they are avoiding the second child, and this gave rise to a number of insults. I do not want to go into that regarding the child. And ultimately, they ensured that she was driven out of the house. So she had to go. Now, in these 5 years which he's talking about, where he could have gone, he knows where she's working, where she's staying, where the mother is staying, everything he knows. All this has been done. They went to the church everywhere. During these 5 years, he did not bother to meet the child at all. He went once, came back, he could have gone through the proper procedure, or he could have raised it to the court also, whatever it is, even without that, with the church also he could have gone to. Nowhere they asked for the child. It is only afterwards that he wanted now to harass her. Because she said, I don't want anything. In fact, even if you look at the maintenance claim which she has put there, it's not in the standard format of Rajneesh and Neha. It isn't just a random thing telling that this is my expenses. That is all she has mentioned, that this is my monthly expenses. She's given the fact the bills, whatever is necessary is there. But she says, I do not. I want to be just left alone. 5 years I've been left alone. And now he wants to visit. Let him visit. But it is all, like you can take a horse to the water. You cannot make it drink. I'll take my child to the park. Let him come. Let him talk to them. Let him do whatever is the time. But if my child says, no, I want to go back, let him try again to see whether he can keep her with him. Then you tell me what I should do. I said, you just see as per, and then we'll repeat it to the court. And we, in fact, the very first day, though I had advised him, in fact, he is also in touch with me. I advised him, go and have a peaceful meet, try and see how you can resolve this visitation issue. But the first day itself, when he saw somebody else, one of the relatives there, he went and, tried to shout at him. And all those things are there, and abuse him. And then those people were anyway recording everything, that this is the way you are. Ultimately, he did manage to meet for some time. The child is frightened. Now, the net result of this is visitation. We are not saying no. Let him come. If he's willing to meet, let him meet her for as much time as possible. But throughout all these days that the court has given permission to visit, the second child has been untouchable. Stay away. This is the only one I want to meet. They, of course, say that we only know this child because she ran away with her. It's not a question of abandonment. No middle-class woman would leave her husband and risk a loss of reputation, everything, just like that, abandoning. She did not have any job. Now also, she is working. They know where she is working, Vaidehi Hospital, as a temporary executive there. She cannot come to court every time because then they'll say your productivity is useless. You lose the job. That is the case. So she's working there, the salary slip, everything. So she's just put them in a school where it can be taken care nearby. You can have schools all over the world, which are very cheap. You also want a certain standard to be maintained for your children. Everybody does, even an auto driver. I should not use that statement, but even the low class people want to go and put their child in Bishop Cottons, which is a very costly school. Every parent has a desire. So even now, what we're saying is, please let her take care of the children. Don't try to break the bond which the mother has built up over all these 9 years with her daughter, the elder daughter, try to take her off, whatever it is, and brainwash her, or whatever it is, forcing against, because neither the mother should push the child, nor should the father pull the child. If she wants to go to the father, that's a different matter for whatever time, but it should not be forced on any side. At the same time, the fact remains that when they are not willing to look at the second child, if you take away the first child, what happens? The second child raises the question immediately. Why am I not being considered even now?
Lord,
1
I
minute,
would
please,
like
let
to
me
inter-
finish.
I
Let me
would like-
finish.
So let him respond to that.
Right.
I would like to interfere here. My lord, our learned counsel is making he's trying to bring all the allegations to separate the children and father. And he is making all bald allegations, concocted stories before this honorable court. If the second child is, as he's telling that he's concentrating only on first child is also a female. Second, he is not that child is not a male actually. What is these allegations? That's the baseless allegations. That doesn't
The
make
other day
any.
Also, the father was also saying about paying the fees or anything about, he was referring to only one child.
No, he, as per his strength, he has mentioned my lords. He never said that he will, with both the children, he has taken the photos in the park, he has showed me, and he told me that this is because of the court. This is because of the honorable court, I'm able to meet my children. That is what he has conveyed.
My lord, there's another thing which I need, very important point I need to
Very
mention.
Telling concocted stories, my lord.
Yes,
That is
No,
what I.
there's a very important point. I mean, whether he calls it concocted, let him prove it.
But he's very
That's a different
storyteller,
matter.
Please
Storyteller.
wait, yes.
Another important point is, in the course of this litigation, he has also made it known clear that I wish to remarry, and the other day
That
I
is
mentioned
none
it to
of- that
you.
is, my lords, he has moved on from the marriage legally. What is this point? Why we are here before to claim the children custody? Regarding that, we are before.
No, if you
My
have a-
lord.
And my lords, the
If you
second,
have a right to submit what your client gives you the instructions, don't he have?
my lords, he is talking out of the topic.
Then you
He is
can
beating
submit,
around.
then
he's-
you can reply to that.
My lord, he's.
You can't stop him from
My lord, I
submitting.
never stop, my lord, with great respect.
Let him say,
with-
let him
yeah,
say, you
yes.
can submit, yes.
My lord, here I'm having a document from the Metropolitan Tribunal of the Church, which says that Mr. Naveen Prakash has expressed his intention to get married. If you have any objection, you may come, and that's to the wife, the ex-wife,
When was it?
23, last year.
Then what?
I
is
have it here. Now, the question is, whether he is able to get a bride or not is not our problem. He has expressed his intention. Assuming that he does manage to get a bride, what happens if you take the child over and already the bond between the mother and the elder child gets broken, the bond between the elder and the younger sister gets broken, and then when the new woman comes in, is she going to go look after this one like the same way as the first mother?
My lord,
Human, it's human.
my lord, it's not.
There is
happening.
a difference. It's not happening. It may happen, and that is the reason for this application.
My lord, it's an assumption. Anyhow, my lord, even otherwise, he has moved on legally from his first marriage. He can't stay alone in his lifetime, but it doesn't bar him to meet his children, biological children.
We are not objecting to
How-
meeting. We are not at all objecting to meeting.
Is there anything, meaningful, what our.
We are
legal
not
counsel is
objecting to
submitting for this
meeting.
honorable court? How it will stop meeting his biological children? He has moved on legally by taking the divorce. She never questioned, there are so many laws for women. She has never gone anywhere by either it may be domestic violence, either it may be a maintenance case.
See, domestic
Nothing-
violence, if you raise, I have proof here.
Nothing she has filed so far. She has not questioned the RCR.
My lord.
Restitution of conjugal rights, she didn't join.
My lord, there are two
Divorce, she
points
didn't join.
which I
She
need to
never
mention.
exercised her legal rights, my lords, whereas she knows everything. She's an educated woman. She's working. She's very well aware about her rights. Why she's keeping quiet all these days when we come here to claim the children in the custody, at that time, why she's coming up with all these exorbitant demands?
What
before this
demands?
honorable court?
What demands?
So many demands you only stated,
What?
no?
No, my lord, now there's two important points which he raised in the chamber and today again.
Why you are becoming obstacle to meet the father to children?
I have not said
Why you are troubling? Why you are-
visitation, I have not objected to.
This is enough of it. This is not the way the court proceedings go on.
Sorry, my lord.
What is this? How many times I'm repeatedly telling, let one advocate argue and the other can respond. There's a limit to that.
Okay, let him, my lords.
No, the court time is very valuable. I just can't, one on the other. If you keep on making submissions, then the court will hear.
But when he is making false submission, I have
Then
to.
you can respond to that by a reply.
That is
What
what-
is here? Court is ready to hear you.
That is why I'm
And the
telling.
court cannot
My
cannot
lords-
hear like this, arguments of any advocates like this.
My lord, My lords, I would like. to-
I'll hear you. Yes, what do you
My
want to
lord,
say?
he mentioned about violence not being a part of his thing.
All not the concerns. No,
No,
we are on the visitation.
Visitation, we have
Whatever
not
he
objected.
submits- No, whatever he submits or whatever you submit, I'll not record it.
Ah.
It is not relevant. What is relevant will be considered.
We-
And advocates are also supposed to be mindful of that point.
Very
That
much.
unless and until that which is relevant, only those facts have to be submitted and the court's time shouldn't be wasted.
Very much, my lord.
But, and he says one, shouting on another and what is this?
My lord, if he's
That
trying to
should be
drown me
done.
out,
Advocates,
I am waiting and I'm saying I'll wait. But he raised 2 points for which I have the proof against his word.
Answer, because court is not going to
Okay,
consider
fine.
all that. Please come.
But I am not objecting to visitation.
Yes.
Not at all.
He has paid 1
Agreed
lakh.
that the orders
rupees.
passed in I number 2. In GNWC number 12 of 2022, dated 10/4/2023. The father is before this court. The father had filed GNWC 12 of 2022, seeking custody of the children. And he filed an application seeking temporary custody of the minor children during weekends and holidays for visitation till disposal of the petition. The court has observed that earlier IA number 1, which is filed by the father, was rejected as per the order dated 4/2/2023. On going through the affidavit filed by the petitioner in support of the present application, the court do not find any changed circumstances to entertain and allow the application. And accordingly, the court had rejected the application. Agreed thereby, the present writ petition is filed. This court
May I
On
make
24th
one small submission?
Yes.
That visitation be done in her presence. That is all.
on 24/4/2024 and on 25/4/2024 and on 8/7/2024 had passed the orders, extract all those orders. Today, when the matter came up, learned counsel for the petitioner father submits that the mother at any point of time had not raised any claim with regard to the maintenance. And she has been taking care of the maintenance of the children. And now when the husband has come before this court, seeking interim maintenance, seeking interim custody, oblique visitation, the mother had come up with these kind of applications. It is submitted that the father is getting a salary of 50,000 and he can pay a maintenance of 6,000. He has some health ailments and he cannot afford to pay the school fees of the children, as how the mother is maintaining, as she's paying 1.5 lakh for each child, which the husband cannot pay. It is submitted that the father is interested to meet the children and that right cannot be denied. And the trial court on the ground that, the family court on the ground that there are no changed circumstances, are dismissed the petition which is legal and contrary to the settled law. The father being the father is entitled to have the visitation for that, the changed circumstances. There need not be any change in circumstances and such a finding of the court is bad. And the father is entitled for the visitation, particularly considering the grandparents and they want to see the children. Next para. Learned counsel appearing for the respondent mother submits that all through mother had been taking care of the children and the father had never come up, had never voluntarily came up and never taken care of the expenses, day-to-day expenses of the children. It is submitted that then they are never objecting for the visitation of the father. It is submitted that according to the learned counsel for the mother, they're only showing interest in respect of the first child, but not in respect of the second child. This kind of a tendency would create
Psychological disturbance, Your Honor.
It's
Psychological
a mere
disturbance.
allegation, my lords. 1 lakh he has paid.
I'll record your contentions also, please wait.
I'm sorry.
It's a psychological disturbance.
It
for
will
both
it will
the
create
children.
psychological disturbance for the second daughter, for the second daughter. According to him, in all the photographs that are filed, they're only showing interest as far as the first girl is concerned, but not the second one. The father had not seen there was no interaction between the children and the father from when?
2016.
From 2016. Suddenly, if they are made to take home and as of now, the children are not interested to meet the father. And in fact, they are not able to recognize him as it's been, the younger one is,
The younger one is, I think, about 4 or 5 years younger to her, the elder one. Elder one is about 9 years.
as the younger one is immediately.
I'm not
after
too
the-
sure.
after
I
the-
have to see that.
She was thrown out of the house. And it is submitted that as far as the visitation is concerned, in the presence of the mother, absolutely they have no
Fear is-
objection.
Fear is the main reason. Fear of losing the children. That's
That
why.
in her presence, she has no objection for the father to exercise the visitation. In response to that, land counsel for the petitioner, father submits that only with an intention to prejudice the mind of the court, such as submissions are made, and the father is not showing any difference between the first child and the second child. Second child, next para, having heard the counsels on either side, peruse the material on record. Right from the year 2016, the children are staying, two daughters are staying away from the father. This GNWC is filed in the year 2022. From 16 to 2022, no efforts are made by the father. And in 2022, earlier when he has moved an application for visitation, that was dismissed. Now questioning the order that is passed on 10/4/2023, he is before this court. After the orders are passed, and this court on several occasions has interacted with the parties in the chambers, and on orders passed by this court, the father could exercise the visitation rights. When the mother is taking care of both the children, whether she has filed an application or not, when the father wants to see the children, when he shows a lot of affection towards the children, it's not only about the duty that is right as a father to meet the children, but he has an obligation to maintain them. The contention of the learned counsel of the father that the mother had never asked for maintenance is not a ground. This all shows about the conduct of the father. Now, a submission is made before the court stating that the father is earning 50,000, but he'll pay an amount of rupees 6,000 towards the maintenance, and he should meet the children every weekend. That is after 8 years, to as his grandparents, as his aged parents wants to see the children. Nobody can deny the right of the father to meet the children, and also the right of the children to have the love and affection of the father. But unfortunately, in this case, the father is only speaking about his rights, but not his, not about his duties.
Sorry for the interruption. 1 lakh he has paid now. He has paid 1 lakh. They have taken it.
That is there in the order.
Yes,
That will
yes.
be there in the order also.
Yes, yes.
When the court has insisted, he had paid an amount of rupees 1 lakh. 1 lakh. The 1 lakh and for 1 lakh, and he submits that he'll pay an amount of rupees 6,000. The mother had not filed any application so far, and the liberty is given to the mother to make an appropriate application before the family court. Pending disposal of that, the father can visit the children in the
Presence of the mother.
in the presence of the mother in any public place, on every Sunday between what is the time?
I think 4 to 5 or 5 to 6.
4 to 6.
Because she has also got home duties which she has to take care of.
Between
Only 1 day she
between-
has.
Between 4 to 6. The father has stated that he can take care of, he can pay 1 lakh as for school fees for annum. the father shall continue to pay 1 lakh as school fees and shall till further orders are passed by the court, as it is submitted before the court, that he is ready to pay 6,000 per month, he shall continue to pay. Accordingly, that petition is disposed of.
Much.
Yes.
Yes.
For the respondent, Your Lordship.
Lordship, we file this petition seeking to quashing the proceedings as against the petitioner in criminal miscellaneous number 314 of 2022 under section 125 CRPC, Lordship. Respondent herein filed the criminal miscellaneous petition under 125, which is not at all maintainable because she is a sister-in-law. And since she is a female member of the family, it's not maintainable against her, against the petitioner. Even if for the sake of argument, if we say she's not liable to pay.
Please, first of all, what is this petition? What is this writ petition filed?
Memo
Writ petition is filed questioning what?
for passing the order, Your Lordship.
Where is the order?
For, not order,
Say-
the notice, Your Lordship. For passing the notice in criminal miss 314 of 22.
Page number 11.
Why can't you tell the court when a notice is issued, you can tell the court that an application can't be maintained. Why should you come to this court and why should this court exercise jurisdiction?
Even the respondent requested the court that she want to withdraw the petition against the petition. But the court did not allow.
Why?
They have already approached the High Court, you go to the High Court.
The present petition is filed.
Interim order may be vacated, Your Lordship.
No, when the petition itself is going to be disposed of, why the interim order will be here? The present writ petition is filed questioning a notice issued to the
Second.
brother-in-law.
Petitioner is a sister-in-law, sister-in-law.
That is.
No, you are
I am for the petitioner, Lordship.
She's the
She
respondent
is-
number 2 in.
sister-in-law.
Yeah,
And
I'm
who is the applicant?
Before trial court, I am the respondent number 2. Applicant is actually brother.
Respondent of
Bro-
the.
Brother of respondent herein. She's a wife. Respondent herein is a wife.
Your Lordship, respondent, this first respondent is the husband of the petitioner, Your Lordship, in criminal miss 314 of 22. Here, the respondent is the wife of the this one.
The
this one.
notice issued by the court in a criminal
Yes,
miscellaneous
this one.
number 314 of 2022. Seeking, after receiving of the notice, the present writ petition is filed to quash the case in criminal miscellaneous numbers 314 of 2022 on the file of the second additional principal judge family court. It is the case of the petitioner that the respondent herein has filed the petition claiming a sum of rupees 80,000 per month for her food, health, shelter, and marriage expenses of 5 lakhs, and written the gold and silver gold and silver jewelry. The parents are given at the time of marriage, directing the respondent to pay a sum of rupees 50,000 towards litigation expenses. According to the petition, the said petition is not maintainable under 125 CRPC. The petition is filed, the respondent has filed the petition on the premise that she married the brother of the petitioner. And the brother of the petitioner has challenged the said marriage in various forms, including the MMTC1 Court Bangalore, while defending a petition under section 12 of the Domestic Violence Act. And the sister-in-law cannot, and it is submitted that the petition cannot be maintained against the petitioner herein. When this court on an interim order was granted by a coordinate bench of this court on 15/11/2023. Thereafter, a memo is filed by the respondent before this court stating that when they have approached before the court, and when they wanted to withdraw the criminal MC itself, as a matter is pending before the court had permitted the petitioner, had not permitted the respondent to withdraw the matter pending the criminal miscellaneous number. And, the miscellaneous number. This court having heard the counsels on either side, pending some material on record, when a notice is issued to the petitioner ought to have approached the court and ought to have submitted before the court that such a criminal miscellaneous proceedings are not maintainable against the petitioner. But instead of doing it, he has come before this court. Considering all this court finds no reasons to entertain this petition. Accordingly, writ petition is dismissed. Dismissed, giving liberty to the petitioner to put forth his case before the trial court. Yes. Briefly. Dismissed.
Permission, my lord.
We'll call the numbers. 39,
Tell about 39.
Some data,
39.
Any date, my lords. We are saying, my lords, the time is the restraint. It's all right. Any date, my lords, may kindly.
So when is the next day that you were telling the dates?
And that is the next.
This week, Monday?
It could be
Monday.
repeated.
40? No, that I've seen, by the time you have filed that, this writ petition before this court, this MFA, by the time it has come into force.
No, but the Supreme Court says that the relevant date to be taken into consideration is not the date of the order, is not the date on which you file it here, but the date on which the proceedings have been commenced. There's a
No,
judgment.
it is like this. That is, under now, as far as this amendment is concerned.
Amendment is prospective.
Amendment is prospective.
Amendment is
For
prospective.
example.
The order
amendment-
that is challenged here is October 2, 2023 order,
October?
2023.
No, by the time you have filed this MFA,
No, no, by the time I filed this MFA, the order that is challenged in the MFA is the October 23 order. Your lordship knows, my lord, under Sarfaesi Act, civil court has no jurisdiction at all.
Oh, that is true. No, the same order you can question before the appropriate court.
No, your lordship sees what is to be taken into consideration. Constitution bench judgment is there arising from Andhra Pradesh, Bapatla matter.
No.
It says that
About-
what is the
about this
relevant date is the
particular-
date on which the proceeding started, not.
Let's see. I think today it's not possible. I have a meeting. Otherwise I would have completed it.
Your lordship have it, because there is absolutely no jurisdiction as far as the.
That is, as far as that on the merits of it
Merits
is,
is
there is a clarity that I've seen.
Very well.
So only thing is if it is not.
Whether it's here
maintainable,
or elsewhere, that's the only thing.
That's the only thing.
Any day that is convenient to the.
Monday, this is all Monday, or can it wait till Monday?
Monday,
Yes, Monday. Yes, next.
41.
could I request on Friday, my lord?
Friday may not be possible.
Friday may not.
May not be possible.
Is it possible tomorrow? Top of the list?
Tomorrow, because there are so many top. So which top is your case, court can't say.
No, because I am coming for the.
Wednesday, post it on Wednesday.
I'm not here,
also.
my lord. I'm Wednesday, Thursday, I'm not here, my lord. I'm going to Hyderabad.
So let it be on Monday.
Monday.
Yes, 41.
So I appear for the petition. This matter, my lord, is ready for the final hearing, my lord. Since, my lord, before the trial court, warrant is issued, my lord. My lord, we have challenged, my lord, seeking for
Interim order
modification.
is not there.
Interim
My lord, I am appearing for the
Day of
respondent.
the, my lord, order that-
My lord, repeatedly warrants are avoided. My lord, 9 lakh, my lord, 6,60,000 amount is paid, my lord, both to wife and child, my lord. Repeated warrants are
Why
been
should
avoided.
the court hear it?
3,80,000 rupees, my lord, already paid, my lord, by the
My
father.
lord, 6,60,000 as on due, my lord, from 2016 onwards.
One also next Monday is 42.
Please.
For petitioner, issue notice to advocate.
Punishing of so-and-so, notice to unserved respondent for second time. Unclaimed.
Execution case all appear ಆಗ್ತಾ ಇದ್ದಾರೆ ಸುಮ್ಮನೆ family court ಅಲ್ಲಿ.
Unclaimed notice to The respondent number second time returned as unclaimed. Sorry, which respondent? Only sole respondent. To the respondent is returned as unclaimed, and the notice to the respondent is deemed sufficient. Pose this matter for preliminary hearing. Yes, 43.
I appearing for petitioner, my lordship.
Yes.
I have taken substituted service. I file it in office, my lord.
When did you file?
No, my lord, today I'll.
Today we will file. The pose this matter on next Tuesday.
Yes, ma'am.
Yes,
Interim
please.
order may be extended.
Interim order, whatever, wherever it is there, extend it for the next date of here.
Much obliged.
Yes, 44.
Appear for respondent here.
For the Wednesday or next Wednesday? This Wednesday or next Wednesday?
Or,
On rectification of first, what do you say about that
next Monday.
office objections
They have to.
for respondent? Office objections,
We
comply with the office objections.
will do it next.
You appear.
Yes.
My lord, I'd already heard the matter and passed orders in 2 IAs. There's only with regard to the maintenance, that's a jewelry matter between the husband and wife. We had filed the affidavit that of that email where the wife has sent the kulla and the jewelry. Your Honor had directed us.
So that final order is, oh, this is the one where.
Those
for
3
what
IAs,
it is,
three IAs, yes.
Order is also dictated.
It is kept pending.
Order is dictated only for this aspect, it is
With the
pending.
jewelry, it is pending.
44, then Wednesday, we'll have it on Wednesday.
Wednesday.
Yes. Next 45.
45. Lord, I have paid the process. Hand summons is ordered. She is not taking the hand summons. That may be eschewed. And if she
It
is
is
not,
submitted that the hand summons are not accepted with the respondent.
process is paid.
As process is paid, registry is directed to issue notice. Yes, next 46.
My lord, would your lordship call it sometime next week, my lord? Because twice she is claiming maintenance. If
Interim is not granted.
There is not, it is not granted.
Pose this matter on next Wednesday.
Please, my lord.
46.
Sent to the party's address, Your Honor, on 22nd August 24,
Hmm.
and is through courier service, 21 2 days time, or 10 days time, madam. To furnish the copy of this servicing regarding acknowledgement.
Have you sent the notice?
I sent them, my lord, 2nd August
Pose
24,
this matter after 1 week,
10 days, madam.
10 days?
Please.
Yes.
Number 47.
My lords, I have paid process fee, my lords, and also I have sent the notice to the trial court advocate through RPAD. Even that is served on them. My lords.
It is
By,
served?
I have also, yes, my
Have you
lords.
filed the memo?
I have filed on 27th of July, I have filed, my lords.
It's okay. You file a
I filed the
memo
acknowledgement. I have already filed, my lords.
Look
I
at
have
it.
filed the acknowledgement.
And whatever the advocate's name, learned counsel as per the orders passed by this court, had taken out notice on the counsel appearing for the respondent before the trial court. Print the name of the counsel and pose this matter next Wednesday.
Please, my lords.
49.
I appear for 48.
48.
I appear for first respondent.
Wednesday, my lords.
Tomorrow there are any 2:30 matters?
Wednesday.
Tomorrow, I think.
You want Wednesday? Next Wednesday?
No, coming Wednesday.
Wednesday, 2:30. I don't think there are any matters. 48, 49, 2:30.
49, my lord.
49 is
Well,
the
49,
matter
appear for respondent.
where your lordship directed them to pay as per the old maintenance granted by the trial court 2.6, which he has transferred. This is a matter which is on merits ordered being, enhancement being ordered. Your lordship said after you pay the money, I will hear it. He has filed an application for recalling that order on merits. So matter has to be heard. now.
Tomorrow.
Submission, my lord, submission. my lord.
But,
Tomorrow.
In the meantime, yesterday they had a discussion, my lord, 1-to-1, where they agreed for the settlement, my lord. I think it matter has been settled.
No,
Both the
no, it
parties
was
are before
not.
the honorable
Party is
court.
right here.
Both the court, yes, it's okay.
Isn't,
no, if there's a scope, you can discuss. If something, there's a scope for settlement, you can talk to the advocate.
Except the maintenance amount that is given because it is not exceeded. Pay her fees, I have to pay the loan and I have to take it.
Anyhow, it will pose this matter on Wednesday. In the
Wednesday.
meantime, if it is any.
Anything is there, they let them.
Land counsel appearing for the petitioner, wife submits that as per the orders of this court, the respondent had transferred an amount of rupees 2 lakhs.
2.6 lakhs.
2.6 lakhs to the account, to the
Account of the-
petitioner, to the account of the petitioner, wife. It is land counsel appearing for the respondent submit that there is a scope for settlement between the parties considering the same pose this matter on Wednesday. On that day, the appropriate orders will be passed. Please, ma'am.
Can we give it tomorrow, ma'am? Tomorrow.
Tomorrow it may not reach, even the court can give.
I would want to say like. by
Post
top-
tomorrow, whether it reaches or not, the court can't say.
Much of it.
Delete from 2:30, post tomorrow.
My lord, small submission of serial number 24, my lords. I miscalculated the months as 22, my lords. It is supposed to be 35, my lord.
35, then it will be 3,50,000.
Please, my lord, but it may be. Kindly-
35 that morning Mega has taken, instead of 2,20,000, it should be 3,50,000.
It should be 35 months, my lord. but,
That's what,
my lord,
35 months that,
3,50,000 would be little quite.
8 months,
Yeah.
8 weeks.
My submission, my lord. What
There
is
we said 6 weeks, let it be 8 weeks, yes.
14 in my lord, top of the list, my lord.
Top of the
I'll
list.
take
not
top
bottom,
top
because
of the list, my lord.
the matters. no.
Oblige.
Madam.
Sir? ಇದು ಜೈನವ್ರೆ, ಇದು ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಇದೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ಬಿಟ್ಟು ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬಿಡಿ, ಪುಟಪ್ ಆಗ್ಬೇಕು, ಪುಟಪ್ ಆಗ್ಬಿಟ್ಟು ಅವ್ರು ಕೊಡ್ತಾರೆ. ಇದಿಷ್ಟು 3 ಮಾತ್ರ, ನಾನು ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡ್ಬಂದು ಮಾಡ್ತೀನಿ. ಅದಕ್ಕೆ ಸರ್ ನಿಮ್ದು ಯಾವ್ದು ಹೇಳಿ ಸೀರಿಯಲ್ ನಂಬರು? 24 and 2,20,000 ಅಂತಿತ್ತು.
22 ತಿಂಗಳು ಅಂತ ಹೇಳಿದ್ದೆ ಬೆಳಿಗ್ಗೆ. ಅದು ಆಕ್ಚುಲಿ 35 ತಿಂಗಳು ಆಗ್ಬೇಕು.
ಅಂದ್ರೆ 3,50,000
8 weeks ಹೇಳಿದ್ದಾರೆ.
3,50,000
8 weeks.
6 weeks ಹೇಳಿದ್ರು.
6 weeks ಹೇಳಿದ್ರು, ಇವಾಗ 8 weeks ಹೇಳಿದ್ರು.
8 weeks.
Next
ಅದು ಬೇಕಾಗಿ,
43.
40?
Tuesday and next week.
ಹೌದೌದು 43 ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇನೆ, ನಾಳೆಗೆಲ್ಲ ಡೇಟ್ ಫಿಲ್ ಆಗಿದೆ ಇವ್ರೆ. 45 ಯಾವ್ದು 36?
38.
ಹಾ ವಿತ್ ದಟ್ ಅದೇನೆ ಸಮ್ ಡೈರೆಕ್ಷನ್ ಅಲ್ಲ, ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಂತ ಏನೋ ಡೈರೆಕ್ಷನ್ ಇದೆ ನೋಡಿ.
ಇನ್ನೊಂದು ಕನ್ಫ್ಯೂಷನ್. ನೆಕ್ಸ್ಟ್ ನಾಳಿದ್ದ ಅಥವಾ ಅದ್ರ ನೆಕ್ಸ್ಟ್
ನೆಕ್ಸ್ಟ್ ಇದು ತಗೊಳ್ಳಿ, ನಂದು ಡೇಟ್ ಬರ್ಕೊಂಡು ಅಪ್ಡೇಟ್ ಅಂತ ಬರ್ಕೊಂಡು ನಾನು ಹೇಳ್ಬಿಡ್ಲ ಡೇಟ್. 31 ನೋಟಿಸ್, ಇಶ್ಯೂ ನೋಟಿಸ್. 32 ಡಿಸ್ಪೋಸ್ಡ್. 33 12/8. 34 ಬೆಳಗ್ಗೆನೆ ಆಗಿದೆ ಬಿಡಿ ಅದು. 35 ಡಿಸ್ಪೋಸ್ಡ್. 36 21/8. 37 ಡಿಸ್ಪೋಸ್ಡ್. ಆಯ್ತಾ? 38 ಡಿಸ್ಮಿಸ್ಡ್. 39 12/8. 40 12/8. ಆಮೇಲೆ 41 12/8. ಆಮೇಲೆ ಇದು 42 ನಲ್ಲಿ ಡೀಮ್ಡ್ ಸಫಿಶಿಯಂಟ್, ನೋಟಿಸ್ ಡೀಮ್ಡ್ ಸಫಿಶಿಯಂಟ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಗೆ. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 43 13/8. ಇದರಲ್ಲೆಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ರಿಟರ್ನ್ ಆಗ್ಬೇಕು, ನೋಟ್ಬುಕ್ ಕೊಡ್ಬೇಕು. 7/8. ನೆಕ್ಸ್ಟ್ 44 7/8. 45 14/8. ಆಮೇಲೆ 46 ಆಫ್ಟರ್ 10 days. ಡೇಟ್ ಕೊಟ್ಬಿಡೋಣ, ಆಫ್ಟರ್ 10 days. 21/8. ಇದು ಅಲ್ಲ 21/8 ಇವತ್ತಾಗಿರೋದು ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ ನಾಳೆಯಿಂದ ಕೊಡಲ್ಲ ನಾವು ಆ ಡೇಟ್. 21/8. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 47 14/8 ವೆಡ್ನೆಸ್ಡೇ. ಪ್ರಿಂಟ್ ದ ನೇಮ್ ಅಂತ ಏನೋ ಹೇಳಿದ್ದಾರೆ, ಮೆಮೋನೇ ಇಲ್ಲ ಇಲ್ಲಿ ನೋಡಿ. ಅದು ಇಲ್ಲ ಅಂದ್ರೆ 14/8 ಲಿಸ್ಟ್ ಮಾಡಿದ್ ಬನ್ನಿ. 48 14/8. ಆಮೇಲೆ 49 ನಾಳೆ 6/8. ಅದೇ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ ಅಂತ ಹೇಳಿ.
ಬಂದ್ಮೇಲೆ ಹೇಳಿದ್ಮೇಲೆ ಮಾಡಬೇಕು.
6/8 ಒಂದು ಇದೊಂದು repeat ಹೇಳ್ಬಿಡಿ. ಇದೆಲ್ಲ file ಹೊರ್ಟೋಗುತ್ತೆ. ಇದೊಂದು ನಾಳೆ ಒಂದು repeat ಹೇಳ್ಬಿಡಿ. ಇದೊಂದು 49 ಒಂದು repeat ಹೇಳ್ಬಿಡಿ. ಬರಕ್ ಲೇಟ್ ಆಗುತ್ತೆ ನಾನು. ಇದ್ರೊಳಗಡೆ ಏನ್ ಗೊತ್ತಾ, ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದೆಯಾ ನೋಡಿ. ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದ್ದು ಇವ್ರಿಗೆ ಏನಾದ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ 47 ಅಲ್ಲಿ 48 ಪ್ರಿಂಟ್ ದ ನೇಮ್ ಇದಾವೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 46
ಯಾವ್ದು ಕೌನ್ಸಿಲ್ ನೇಮ್ ಎಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ.
ಮೆಮೋ ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಇದು ಚೇಂಬರ್ ಕೂಡ
Memo for posting. ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಕೇಳಿದೆ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಇಸ್ಕೊತಾನೆ ಇಲ್ಲ ಮೇಡಮ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವು ಮೆಮೋಸ್ ತಗೋತಾ ಇಲ್ಲ ಅಂತ ಅವರ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ. ಮೆಮೋ ಹಾಕಲ್ಲ ಬೇಕಾದ್ರೆ ಐಎ ರಿಕಾರ್ಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಎರಡು ಹಾಕಿದ್ದೀವಿ. ಅದೆರಡೂ ಪೆಂಡಿಂಗ್ ಬಂದಿದೆ. ಇವಾಗ ರೆಕಾರ್ಡಿಂಗ್ ಇಂದ ಫೈಲ್ ತರ್ಸ್ಕೊತಾ ಇದ್ದಾರೆ. ಅದೆಲ್ಲ ಪುಸ್ತಕ ಆದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ಲಿ ಮೆಮೋ ಹಾಕಿದ ತಕ್ಷಣ ಹೇಳಿದ್ದೀನಿ ಅವ್ರು ಕೆಳಗಡೆ ಅಲ್ಲ ನೀವು ಅಂತ ಹೇಳ್ತಾರೆ. ತಗೋತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ವಿ. ಅದೇ ಬೆಸ್ಟ್ ಫೈಲ್
Okay, sir, thank you.
ರಿಪೀಟ್ ಒಂದು ಹೇಳ್ತೀನಿ ಒಂದು 3 ಫೈಲ್ ಕೊಟ್ಟು ಕಳಿಸಿದೀನಿ ಈಗ 2 ಹಾ ನಂತರ ಈಗ ಒಂದು ಇದು ಸ್ವಲ್ಪ ಬರಪ್ಪ ಸೀರಿಯಲ್ ನಂಬರ್ 49 WP WP 2844 of 24 ನಾಳೆ ರಿಪೀಟ್ ಅದು ಇಲ್ಲ ತಾನೆ ಅದು ಬಂದಿದ್ದೆ ನಾನು ಫೈಲ್ ಅಲ್ಲ ಈಗ ತಗೊಂಬಂದ್ರೆ ಅದರಲ್ಲಿ ಇಲ್ಲ ತಾನೆ ಅದು ಸರಿ ಅಲ್ಲಿಗೆ ಹೋಗಿಲ್ಲ 2844 of 24 ನಾಳೆ ಅದು ನಾಳೆ ಇವತ್ತು ರೀಚ್ ಆಗಲಿಲ್ಲ ಅದಕ್ಕೆ ನಾಳೆ ಅದೇ ಆಗಿಲ್ಲ ಅದಕ್ಕೆ ಅಲ್ಲಿ ತಗೊಂಡಿದ್ದೆ ನಾಳೆ ಅಂತಂದ್ರು ನಾಳೆ ಸದಾ ಇನ್ನ ಹೇಳಿದ್ನಲ್ಲ ಬರ್ತಾ ಇದ್ರೆ ಅಲ್ಲಿ last ಕರ್ಕೊಂಡು ಇದೆಲ್ಲ ನಿಂಬಲ್ ಇದೆಲ್ಲ ಪೈಪಿಂಗ್
ಆಯ್ತು ಬಿಡಿ ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಅಲ್ವಾ ಅದು?
49.
ಸರ್ ಲಲಿತಾ ಮೇಡಮ್ ಕೊಡಿ. ಸೀರಿಯಲ್ ನಂಬರ್ 49 2844 I repeat. Same date. ಈಗ ಈ ಬ್ಯಾಚ್ ಎಲ್ಲ ಮೇಡಮ್ ಎಷ್ಟ್ ಮಾಡೋದು ಅಷ್ಟೇ ಸುಮ್ನೆ ರಿಪೀಟ್ ಅಂತ ನಾವ್ ಕೊಡೋದು ಇವ್ರು ಏನ್ ತುಂಬ್ಕೊಂಡು
ಆ ಕಡೆ ಇಟ್ಟಿರೋ ಚೇಂಬರ್ ಈ ಕಡೆ ಇಟ್ಟಿರೋ ಬ್ರಾಂಚ್ ಕ್ಲಾಸ್ ನಾನೇ ಬರ್ದಿನಿಲ್ಲ ಅರ್ಜೆಂಟ್.
Manya.
ಮೂವ್ ಮಾಡಿದ್ನಲ್ಲ ಅದು ಅಬ್ಸರ್ವ್ ಮಾಡಿಲ್ವಲ್ಲ ಸುವರ್ಣ ಮೇಡಮ್ ಏನೋ ಕೇಳ್ತಾ ಇತ್ತು ಐ ಆಮ್ ಕಾನ್ಸಂಟ್ರೇಟಿಂಗ್ ಟುವರ್ಡ್ಸ್ ಮೇಡಮ್ ಐ ಡಿಂಟ್ ಸೀನ್ ದಟ್ ಸ್ಕ್ರೀನ್ ಆಯ್ತಾಯ್ತು ಮಾಡೋಣ ಬಿಡಿ ನಿಮ್ಮದೇ ಅದನ್ನ ನನ್ಗೆ ಹೇಳ್ಬಿಟ್ರೆ ಆಯ್ತು ಅವರು ಅದರಿಂದ ದೊಡ್ಡದಾಗಿ ಅಂತ ಬಂದ್ಬಿಟ್ರೆ ಆಫ್ ಮಾಡಿ ಮೇಡಮ್ ಅಂದ್ರು ರಿಮೂವ್ ಮಾಡಿದ್ದೀನಿ ಅದೇ